and courage. Insightful journalism, conversations, and dialogues that go beyond headlines, decoding policy, powering innovation, and shaping how India thinks business. Editorial commentary from industry captains and business leaders. In a world driven by algorithms, our stories remain journalist-led, backed by AI efficiency, not AI storytelling. Every fact, every quote, every number, verified, trusted, transparent.
Ladies and gentlemen, it's my pleasure to welcome you all to the BW Legal Nexus Conclave 2025. My name is Aditya Malik, and absolute pleasure to be your host for today. Today is a recognize or it's a conference that will recognize the advancements and development of the diverse legal industry. The theme for Conclave this year it is towards 2026, redefining law, risk, regulation, and also responsibility. We are and will be joined by 100 amazing lawyers, academicians, stalwarts in their respective domains, and students as well who are wanting to learn from them. What you witness throughout the day? You'll witness stalwarts, experienced members of the fraternity walk up to this very stage, talk to you about various topics, answer some of your questions, clear some of your doubts, and more. And what will happen after that? We will also be awarding 30 under 30 and 40 under 40 lawyers and legal influencers. To give you a glimpse of all that we have in store for you today, can we please play the event AV? BW Business World, Chair and Intern-Chief of BW Business World and founder of the Exchange Media Group, is the fastest growing business media house in the country. With a network spanning across 25 niche business communities and 8 magazines, BW Business World is proud to be entrenched in various verticals in the domestic niche B2B communities that organize conferences and also forums to facilitate interactions between sectoral business leaders and create a conducive environment for collaboration. Please stay updated on all the developments by subscribing to the magazines within the Business World Group. I promise you, they will enhance your professional journey for knowledge and insights as well. The latest issue, it features India's top management institutions shaping future business leaderships. For more information, please reach out to the same registration desk जहां से आप सभी ने अपने bands लिए हैं. For doing that, you can also subscribe on www.subscribe.businessworld.in. Launched in 2019, BW Legal World is a community of BW Business World, a 4-decade-old publication that has since consistently ranked among India's largest and most respected business magazine. BW Legal World brings together the global business and legal demographics on one very platform. Can you also play the BW Legal World's brand, Davy? And now a couple of important things for you. First, you can watch today's summit, today's conclave, today's award ceremony live on www.bwlegalworld.com. Any picture, any opinion, any view that you share online, please also use the hashtag BWLegalNexus Conclave. Do follow them on all the social media handles. It's one common bit. It is @ BW Business World and @ BW Legal World. Also, all the speakers, all the moderators, session chairs, panelists, it's a humble request to all of you that every person who graced this very stage of BW Legal World is a stalwart in that domain. And you have lots of experience to share with us, and हम सब आपसे लेना चाहते हैं सारा ज्ञान जो आपके पास है हमको देने के लिए. But we also have a timer. We have an agenda fixed for the day. My only request to you, please take a note of that, क्योंकि अगर आप उसका ध्यान नहीं रखते हैं, they'll just make me stand here and stare at you with that annoying buzzer. That's why. My only request to you. With that, a big thank you to our partners as well. Powered by partner Iris Value Catalyst, our event partners joytravels.com, Opal Events, Fandrum, Beanley Coffee, JustBath.ai, The Thick Shake Factory, Reality, Exchange for Media, IWMBus.com, Impact and Pitch. Now, to formally welcome all of you to open today's proceedings, please join me in welcoming to the stage our Chairman and Editor-in-Chief, Dr. Anurag Batra.
Morning, give Aditya a big round of applause. Bigger clapping is good for heart muscle. I know today it really feels like a December winter morning in Delhi. Last 2 days it didn't look like that, but we are back to that. First of all, my kudos to Krishnendra Joshi, who's our editorial lead and assistant editor on BW Legal World, for putting this together. We've traditionally done the 30 under 30 and the 40 under 40 in December. Last year we did it on 15th December. Aditya referred to the fact that we started 6 years back. On 12th December 2019, we did our GLLS, which is the Global Legal Leaders Summit, which is essentially a law firm summit. And we have a long way to go. What matters in life is you're in the play, and when the right time is there, the acceleration happens. I just want to, Krishnendra will be here. He's on his way from Noida, and he'll be here in some time. Varun was telling me that he was guiding me on how to build a legal community, and all suggestions are welcome. And I always say, I believe in the process of reverse mentoring. I can learn from all of you, from other people, and really know a lot about what's happening. And your practitioners, I don't, you know, more a journalist, as in GE and ERALIS. I am more an entrepreneur. Of course, I'm in the content business. So we have a long way to go, Varun, and we will take your advice and everyone's advice and patronage. Two of my senior most colleagues are here, Mr. Harbinder Narula, who's the CEO of our healthcare community, our pharma community, and our well-being community, and Mr. Hoshi Gaswala, he was here. He is now outside, he's the CEO of our BW Engage, which is our custom content and custom event business. I just want to say that I was in Bombay yesterday and I told Harbinder I won't come for this event because I have very close friends the engagement and I really wanted to attend it. But something told me to this event, there are 27 communities in business world. Some are leaders or some of them are on way of being a leader. For example, our hospitality community, BW Hotelier, is the absolute leader in every aspect, in revenue, in editorial. We started very well with legal. I was telling Priyanka and right? Priyanka and Varun that in the first year at our GLS, we had Mr. Shardul Shroff, we had Mr. Cyril Shroff, we had Ryan Karanjiwala, we had Rajiv Luthra, we had Lakshmi Kumaran. I can go on. Our first 40 under 40 jury, Justice Narasimha was also on the jury. And all these people I said, except one. Mr. Cyril Shroff was not on the jury, everyone was on the jury. And I remember I went to the jury and they said, do anything about legal Anurag, you won't be on the jury. I said, okay, I love it, because I don't want to do anything. When the jury takes ownership of what we do, really what comes out is special. And you saw the quality of winner. But I really wanted to be on the legal event, so I am here. And I must promise you that in this community, both in the B2C, which is what main business world is, and B2B, which is more BW legal world, we will build a world-class community. And as I keep saying, I really believe being in the play is important. Sometimes you may attempt 100, you may only get to 80. Sometimes you may attempt 100 and you get to 200. That happens in life. But just want to say that when we give out the awards for 30 under 30, the quality of award winners is fantastic. In fact, I think we are giving away 35 or 33 awards. 30 of the winners are coming. There were some ties and there were very close calls. And I told KJ that be liberal, because some of them were not going to be 30 next year. Some have applied one or twice, and and they were very close, the one vote difference, or, very, very close. Similarly, in 40 under 40, there are 3-4 winners who applied for the third time and they won, right? So I just want to say that it's an honest process. No process is completely perfect. Ultimately, it's people judging people. It's how you present on that given day. Human beings have biases, however good and professional they may be. But it's an honest process. Can it be better? Everything in life can be better. So I just want to say that you're winning an award through a process of integrity. We also have a locus standi. We're an editorial product. We report on this domain. For example, we did a cover on main BW Business World on NCLT and NCLAT, because it impacts businesses. I mean, it's not just a legal issue. And we are not about courts. That's a different editorial product, what happens in courts and judgments and, that's a B2C legal product. We are about GCs and law firms and professionals, and they connect with the business world. We are, NCLT is important, NCA. And CLAT is important. What GC Shri Rupa started legal world for us, and she did a fab job. And Krishnan is continuing to do that. Ashima Garima have contributed to it in the last few years. They may not be with us, but they're very, very involved with what we do, and we have very high affinity. Today, the legal community is doing so well. There is so much affluence in the legal community, which is a reflection of the importance of legal in a changing policy framework. also, what is happening is, the ambition of Indian entrepreneurs has grown in the last decade. Today, when your entrepreneurs are starting companies, they're thinking of going abroad in the first 2, 3, 5, 6 years. So really, that has also helped. Uh, and the fact is, we have our first panel about how are we keeping pace with the ambitions in the new economy, because the policy is changing. This year, the gaming policy changed. DPDP came into act, right? And these are huge implications. I mean, the gaming business changed overnight, literally. And DPDP is a game changer. We did our first conference on 31st October. We launched a community of data privacy professionals. So we are not in the business of events, websites, magazines, none of that. We do all that. But we're in the business of building communities through content, through insights, through collaboration, through bringing all of you together. And there is a lot. The best time for BW legal world is ahead. I also, Prashant, and I sent, we used to bring out a magazine, and then, I would say that this is a January issue. It comes out. We are about GCs and law firms. GCs and law firms in that. That's how we define. We are very clear where we have to be the homepage of GCs. Because at the end of the day, they give you work. At the end of the day, in the food chain, they're important. Of course, both the bar and bench are also important. So this is an interview this is our cover, and there is a lot. This is the Jan issue. And from Jan, every month, we'll bring out and there is a certain value to a print product. We have, I'm not a teenager, but I'm a screenager. I'm always on my phone looking at stuff, reading stuff. But there is a certain value to a print product. So, I'm sure that we'll engage deeply with you. I learned a lot from all of you when you are speaking and deliberating. We'll have Mr. Justice Waziri, who will be here in the afternoon. We'll also have Mr. Sanjay Jain. We'll also have Mr. Shashank Bajpayee, and many other legal luminaries who will be here. 2 weeks back on 30th November, we had our BW Legal World GLLS and GC100 in this room. Mr. Chetan Sharma, the Additional Solicitor General, was our chief guest in the day. In the evening, we had Mr. UK Chaudhary, Justice Meedha, and Justice Iqbal Ansari here. And it was a house full. There was no space to stand, forget sit. I think we had to put 30, 14 more chairs. I'm sure as the day progresses, you will see more and more colleagues joining in. I just want to say that last night I was on the flight back from Bombay. Harvindra came last night. I stayed in the hotel. Though I went for a wedding, I realized that, Himani reminded me, you have to go for this wedding. A friend of mine's son was getting married. And I was reading this book called The Empire of AI by Karen Ho. And I'm going to present it to you, Hoshi and Harvinder. It's a fascinating book. She's a journalist. She was the one who wrote the first story on, there are many stories on OpenAI, but the first comprehensive account she had access to, Sam Altman. And she's an amazing writer. I can tell you that. I read lots of books. And I think finished 100 pages of the book on the flight. So, and there were implications for the legal world, what's happening. AI is clearly changing every sphere of life, and looks like the singularity will happen much before 2034. But of course, the business of consulting, and lawyers are also consultant, there is, past judgments, there's data, all that is being crunched. But I genuinely believe the value of a professional will never go away. the value of certain tasks is replaced by AI, but the legal professional won't be. However, it has implications across the value chain of legal services. And I also want to say that while AI is a tool that helps us in healthcare, we are not thinking about the social impact of AI. The social impact is the amount of data processing you need. It needs more water. It needs more energy, huge computing power. And that means there's more pressure on our resources. And already in the world, you see some of the local communities objecting to data centers because that means more pressure on, and you know, all of us know post-COVID that what happens in one part of the world impacts you. What happens in other part of the country impacts you. The quality of our lives is not necessarily getting better. Of course, our lifespan is getting better. I live in Delhi, and I travel mostly to Mumbai. 99% of my travel is to Mumbai, 95%. I can only say that as people who have an influence, and lawyers have tremendous influence. They have influence over the community, they have influence with their clients, they're affluent, they have a voice, they understand how to bring a change because they understand legislation, policy. I think we have to do something about the quality of our urban lives. The lives in urban cities where there are opportunities are not necessarily getting better. We're getting affluent, but the quality of life is not getting better. Look at the amount of time it takes. I lived in the hotel because, you know, I saved 45 minutes, live in GK1, saved 45 minutes, at least in the morning. I slept a little more, right? And that's my motivation because I'm always, also the quality of air, the quality of water. One thing that my wife keeps saying is the quality of food ingredients. You can never be sure that it's written this. And so as professionals, I know we all are too busy trying to advance in our professional lives, and that's okay. There's nothing wrong with it. What you do makes an impact, but I think we have to be a little more concerned about what's happening in the society, which I'm sure you are. I'm just bringing it top of mind. I want to end by saying what Dr. UK Chaudhary, I call him the Sachin Tendulkar or Don Bradman of company law. You know, he is a stalwart in the erstwhile company law board, and now and I've had a personal experience, 2 personal experiences with them over in 2026, it'll be 20 years of knowing him. He did a litigation for me in 2003, which lasted till 2019, in where 5-6 years he was very active, and he got us. If he wanted X, we got possibly 2X, okay? We were proven right. I think a lot of time it's about, yes, the money matters, everything matters, but it's about, you know, getting justice. And he said one thing to me. I went to see him a month back. He was celebrating 50 years in the profession. And he said to me, I reached ahead of time. I think I was the second person. Me and Ranjana walked in. Ranjanaji walked in at the same time, 7:40. And we got chatting, and he said, Anurag, the issue in India is that clients and founders and entrepreneurs talk to their CA about strategic decisions more than they talk to lawyers. Whereas in the US, any company, any entrepreneur, any founder has to do something. The lawyer is the first port of call, and then they synchronize with the accounting leader, right? He said in India, for most advice, you go to the CA. He says it's changing, but over the last decade, it may have shifted a little bit. And then we also talked about the number of GCs getting board positions or becoming CEOs. If you look at data, globally more than 34% of CFOs become CEOs. Less than 6% CMOs become CEOs. Less than 10% CHROs become CEOs. But GCs have a very important role. They have a seat at the table, legal professionals, but they are, you know, they can do better in leading companies. So I hope at BW Legal World we are able to make a contribution by making sure the numbers on this rise. The legal professional, whether you're called, whatever you're called, becomes the primary advisor. Beyond succession planning and trust, and compliance. Compliance is a big issue today. I talked about data privacy law that has come into act 45 days back. So I wish you luck. We at BW Legal World, who are still like a startup, we have a long way to go, but we are in the journey. When you're on the journey, you get there. I wish you luck, and I look forward to engaging with all of you. Mr. Krishnendra Joshi will be here in a while. He's done a fab job, supported by the BW Legal World team. Day before yesterday, Mr. Ghaswala and Mr. Narula were at the supply chain, the Business World Supply Chain Management Awards and conference, which happened at the Eros Nehru place. And I asked Sarvinder, how was it? And he said it was very good. So clearly, I've seen the growth of multiple communities and multiple IPs when you put more resources in them. Hopefully in 2026 in the BW Legal World community, both editorially and business-wise, we will put more resources and hopefully do some new initiatives that get your time, attention, and are of some value to you. Thank you for being here. When we do the awards at 1:30 to 2:30 is our 30 under 30, and from 6:45 it is our 40 under 40, and we'll try to stick to time because some of you have your flights and so on and so forth, and really we'd like you to keep your commitments and be punctual, so we wish you luck. My only request to you is when the winners come up, please applaud louder for them because it would matter to them, and as I keep saying repeatedly, when you applaud for others, you build your karmic balance, and someday when you need the applause, it will be there. So God bless you, and thank you for your contributions in building BW Legal World. God bless you.
Thank you so much, Dr. Batra, for setting the context for today. Thank you. While they set the stage up, the first panel, it is on legal priorities for India's new economy, venture capital, data and tech landscape. So as you said, at 1 o'clock to 2 o'clock is the awards ceremony, Legal World 30 Under 30 Awards. Usse pehle a couple of panel discussions discussing numerous topics. The first one, legal priorities for India's new economy, venture capital, data and tech landscape. Please join me in welcoming a panelist for the same. Up first, Ms. Priyanka Duggal, partner, Grant Thornton Bharat LLP. Joining Priyanka is Varun Bajaj, co-founding managing partner, RST Bajaj Global Law Firm. Also joining them now is Sahil Vora, strategic advisor and external general counsel, independent practice. And this one will be chaired by Dr. Anurag Batra, chairman and editor-in-chief of BW Business World and founder of the Exchange for Media Group. So.
To make you connect, I never met you earlier. I wish I met you. I see you worked at 2 media companies. I know a little bit about media, having founded Exchange for Media. So, I'm not Krishnendra Joshi. He's a handsome lad, and he does a fab job, very passionate. We have a very interesting panel. We have somebody who works with a consulting company, but a tax practice. So clearly, what's happening with the regulatory regime in terms of taxes, very important to businesses. We have a law firm professional who again is very active in the community and will bring his perspective in Varun. And we have Sahil, who's been a GC and now an independent legal professional. He's worked at a law firm, he's worked at 2 media companies. So he also understands, for example, right now it is about, yesterday I was on the group of some publishers, I'm on the board of publishing organizations, and we were talking about why should the AI firms be allowed to all our content without our permission? Because that's our IP. There's economic value created there, and why should they get the economic value without our permission? Why is the government really allowing them to do that? A blanket with no permission. So anyway, let me start by saying that there is a new creative economy. India is growing, and Let me get your, are the laws keeping pace? Are the legal professionals keeping pace? What should be the outlook for the new economy? Because it's a creative, it's a digital economy, and policy is changing very fast. Uh,
Hi, good morning. I'm Priyanka Duggal. I work with brand content Bharat LLP. These look at tax and regulatory aspects extremely closely. He mentioned about CA and law combination and all of that. I am one of those who have been a CA as well as a lawyer throughout my journey. And I have to say that law actually brings a better perspective for a person. So as a tax professional, while CA will give me the numbers, etc., but reading the law, applying it for negotiations from a tax perspective becomes very, very important. I have to, add that point because he mentioned something about the CAs today. And law specifically has helped me grow and evolve as a tax professional in a better manner, which a CA could do. Okay, I think on the...
and on what the topic is legal priorities for India's new economy, venture capital, data privacy, and technology law. Let me get your opening comments on that.
So from a venture capital side, I'll say, few years back, it used to be very specific to, early stage funding, very asset heavy linear businesses. But in today's time and world, what we end up seeing is a lot more digital or digitized businesses, AI, fintech, and with all of that comes a lot of nuances related to cross-border structuring, etc., which needs to be involved. And that's why we see, few years back, companies used to come up to us for setting up an overseas holding company and how to structure that better, etc., from an Indian ODI, regulatory, tax perspective. But today, all of them wants to flip back to India. So I think that is the perspective which has changed. While a few years back, India was not a niche market for this, and the landscape for VC has completely changed. All of them wants to now invest into an Indian holding company in the want of a better exit from a peer fund. So that's how I'll say the landscape has changed. That's my first immediate take on this.
Your opening comments, Varun.
Thank you, Mr. Mitra. So first of all, just to briefly coming on to the topic, but so I'm the founding managing partner of RSD Bajaj Global, and also recently got elected senior vice president at Society of Indian Law Firms, where part of the Shardul Shroff committee on the foreign law firms. But want to mention
Allowing
that,
the foreign firms to come or not allowing?
so that's no for
Like we,
see,
he
there's
does
a saying.
Harvinder does a cancer conference. So I said, is the cancer and prevention of cancer conference or a cancer conference? So
So
similarly,
Shakespeare said, "Bring all the lawyers together and kill them because we don't give a straight answer."
never say that. Words have tremendous power. God give long life to everyone, including lawyers.
Right. So I think why I mentioned that is, while the journey has been very magnificent, but it started with BW, where we got the emerging law firm of the year. So I'm always very
And I didn't know that in 90.
right. So we were first generational, absolutely, and I think great platform where first generation boys, I always tell, to grow on merit. So to answer, and we've grown through an economy, so I think this is a great topic. So I would say my response to that is that we take the Indian economy is broadly $3.5, $4 trillion, out of which 1 trillion is new economy. Now, what you see as an upside at a level, if India has to touch 5 trillion, your traditional economy is primarily agri and manufacturing, right? And it is facing huge resistance because of a lot of geopolitical reasons, because the US policy is really disrupting the manufacturing space, and agri was already under pressure. So what the policy makers do, and when we are also part of that, is that they want to focus on the new economy to touch the $5 trillion mark, to increase this 1 trillion to another trillion, to touch that. And for that to happen, your frontier tech is a great opportunity, or AI, robotics.
Deep tech.
Deep tech. An open AI company can touch $1 trillion valuation today.
And we are so futuristic in exchange for media. Our head of tech is called Deep. So we are deep tech.
Yes.
No, kidding.
So therefore, I feel the new economy is actually the opportunity where actually the government is also focusing today. And what are the constituents of new economy? There are two major players. One are the investors, the block, which we call the venture capital funds, and we represent a lot of those. Second are the new age companies, the entrepreneurs, right, which are actually creating the value. And I think both these stakeholders, they form the critical path, and I think policy making on both is required. Especially, I would want to touch on the venture capital part. Earlier, this entire funding on the new economy was coming pre-COVID from China and US. Now, what happened in COVID, there was a press 3 note which came in, border state investments were not permitted. That ended the Chinese investment through a direct route, until unless you had a very innovative lawyer to answer in a way. So the opportunity was only left with US money, but with the change of regime at the US level, that's created stress. So when we talk to the policy level, they feel they need to encourage domestic capital to fund this new economy, because the strategic assets of next age are going to come through the new economy. So the policymakers today are really focusing to encourage domestic funds. But I think one issue which I want to flag here, and I think business world has that power, that there was a recent change by SEBI on the angel funds regime, where they have said that you need to aggregated investor money in an angel fund. Now that is, the financial threshold is very high. So I think presenting a lot of those angel funds in that industry issue, the government should look into it, because if agenda is to money fund the new economy, they will need to encourage more angel investors to put in money. So I think that is huge policy push which is there, and I think domestic capital will win, because the owners of these new Teslas, OpenAIs from India should be Indian, and it by, as our preamble says, it should be by the Indian, for the Indian, and of the Indian. So that.
But I mean, it gets Sahil to come in, and he has a law firm and two top-tier media companies. But let me respond to that. Can I tell you, when 10 years back, when, let's say, investing in deep tech in the new age startup started, less than 4% of money was Indian. So if 100 rupees was being invested into these new age startups, 4 rupees were Indian, right? It is 10 rupees now with all the talk. With all the talk, it is less than 10 rupees, okay? It's about 10 rupees. 10% basically, I'm saying 100, 10. So still there's a long way to go there. Second, Priyanka talked about firms wanting to flip back to India because of the wealth creation opportunities there, the opportunities for exit. And the third question I would say is that in some of the technologies, India is leapfrogging, you know. When I was in the business school 30 years back, you talk about leapfrogging. That leapfrogging is happening now. And India is becoming a supplier of that technology, or an IP owner. Still very small, but there is an ambition of the Indian government and policymakers to be able to strengthen that ecosystem. So we'll come back to your opening comments. You know, you were advising as a legal professional, as a GC, advising large business operations, you're helping people evaluate acquisitions. What are the key legal and governance challenges that you see new age companies and unicorns facing as they scale up?
Thank you. Morning, everybody. I'm Sahil Vora. I have been a law firm counsel. I've been, as Anurag already mentioned, I've been GC for a couple of media companies, and my strong point today is venture capital. Just adding on, if I may, venture capital, which is something that's quite dear to me, I enjoy work, is the fact that in addition, of course, to capital account of press note 3, etc., like Varun mentioned, there's also been a paradigm shift in terms of just the mentality with which capital is looked at today from an investor standpoint. So, not dying to jump onto the bandwagon as they were about 50 when I first the commerce sector in the Indian economy. Capital in short has become smart. So investors have become smart. Look at ability, there's a bunch of, today we've got a bunch of founders who are second and third time founders, for example. Serial entrepreneurs is the catch. Questions like liquidation reference, anti-dilution. What does this mean for me at, say, not at a Series Seed or a Series A? What does this mean for me at a Series C? What does this mean for me at an exit-related stage? Will I get dragged? What are my liquidity options myself? So things have become more nuanced, more sophisticated, and I think governance has also started playing a very big role in terms of how startup founders see things. When I came into the in-house industry in 2010, 2011, legal was looked as a roadblock. Today, legal is a value add, which is a very big difference.
It's an enabler, it's a strategic multiplier, like you are fortifying your technology, fortifying your agreements, and legal can bring strategic insights. I've done 2 acquisitions, I've sold 2 companies, so I know the value a law firm or a legal professional can add. Now, Priyanka, let me come to, from a tax policy perspective, which tax provisions urgently need to be revisited and revamped to keep pace with evolving businesses in this new economy that Varun and Sahil are referring to?
There are actually lots of them. So, we are going to look at the new income tax bill next very soon. But unfortunately, lots of the nuances which exist for fintech companies are still not there. And I'll give you a very small little example of that. When a company is remitting money overseas, or you're making a payment for, let's say, a small subscription fee which is supposed to be undertaken, there is still a withholding tax which is required to be deducted. And more likely than not, you will not have particular details, and hence that withholding tax liability ends up being on the payer. Still not have a mechanism to fix that small of a problem.
Receiver.
Yeah. So eventually what happens is cost base increases, etc. And hence, the cross-border transaction cost is increasing because of the tax element. The second thing which we also, notice is the other regulatory regime around cross-border transactions, specifically related to, creation of permanent establishment or new age tech businesses, where let's say the cloud sitting overseas, the engineers are sitting in India, and the data team is also sitting in India, and hence, some of those clarifications are also required. While the regulatory regime has evolved excellently well, I think tax is far behind on all of those, and hence we keep seeing lots of litigation, on permanent establishment issues. There is also an age-old issue of what qualifies as a software as a product versus a software as a service. Again, lots of those emerging issues are there, and unfortunately our tax laws, whether we call it direct tax or indirect, they're all extremely old, built for asset-heavy, linear businesses, not fully plugged in for, digital businesses. And hence, one important thing I feel is, which becomes important for every startup or VC is structuring it well in advance, because we are aware of what could be the potential issues. Ensuring that some of those tax gaps are filled in, your compliance and your governance is top-notch, because some of those will eventually hit you at the deal-making time, which is not something they would want to, cover up on that front. And hence, but I think top 3, I'll say compliance. Second, some of the permanent establishment and place of effective management issues specifically for new age digital business. And third, lack of incentives. Not many incentives today available from a tax perspective for new age businesses. Let's say if they want to invest in R&D, if they have an IP holding company sitting in India. So incentives is again, I'll say the last thing which is on the top of my mind.
Varun, let me come to you. There's a lot of work happening across fund and new economy companies. By the way, I've never prepared a speech except in my brain. I read the script once, I don't. So you can, it actually distracts me, okay? Yeah, I eat a lot of almonds and I'm a quizzer, so I remember stuff, okay? So you're being very nice to me, but it distracts me more than it helps me, right? So let me ask you, and one of the things is policy certainty. Of course, policy has to keep pace. It has to evolve as new sectors come. In a lot of sectors, some of the developments for the first time, so you have to respond to that. Are we doing well on that count? And I want a candid view. I know it is very fashionable to say the right things on a forum because you want to appreciate the positive side of policymakers, but by being constructive about what can be better, you can actually help form better policy. For example, gaming law. Of course, the concerns of the government were right, but overnight it really, if I may say, it killed the industry, right? So, is there policy consistency? What can be done? And again, in the next few years, there'll be new sectors. I mean, quick commerce in the last 2-3 years is suddenly big, and the government is a very big enabler. It is also a market maker. For example, in drones, we will not allow Indian-made drones or manufactured drones to have a competitive advantage. It's also a market maker. Will buy $1 billion of drones. So the government is doing a lot of things. Yesterday the space policy was announced. So government is very, very progressive. But at the same time, political tell us what are your views on that?
No, I think that's a great question, and I think India has to be the next Vishwaguru, which is the vision of the government. Policy is going to be critical in this phase because in the new economy, your strategic assets of the Industrial Revolution 4.0 are going to come through the new economy. Now, that's a very good question around policy consistency. But since more than consistency today, the challenge with the government is actually to understand the data points to build that policy. Like, for example, what should the IP India? Is it whether the copywriter should get the right or the learning program should get it right? Now, to arrive at this policy decision itself, you need huge stakeholder discussion. Now, second is like overnight the gaming law changed. Real money games as a market was one of the most booming spaces. It got overturned overnight. Now, why did it get why did this happen so abruptly is also the question. Not only it happened, right? Also, on frontier tech, how would you react to robotics versus your new labor code, which has just come in? Yesterday, I was visiting the Tesla showroom in Gurugram, which is open. They are able to, the first...
I thought you were buying me a new car, gifting me 2020.
I think we need to discuss that also. But actually, it's not only the cars they are selling. They are selling robotics there. It's on display. So today in housekeeping, which is costing 20,000, that robot is costing around 5 to 7 lakhs with an EMI of 5,000. So what is your policy on robotics? So is it in sync with your new labor code which you have brought in?
Sure.
So these questions, I think before we get into consistency also, what India is lacked in the Industrial Revolution 3.0 is that policy as a subject was not discussed at length. What do we do at the parliament today? We are not, it's supposed to discuss policy, but 70% of the time it is getting disrupted on some other issue which is not relevant. So how do you build educative policy? I think that is where good politicians have to come in, and they have to be voted by the government, by the citizens to have that seriousness. Today nobody objects if 70% of the parliament time is not getting wasted and not in policy making, but on issues which are not linked to it. But as citizens, we are not agitated by it. The whole idea of policy to make it live was to show everybody what they're doing there.
Sure. So, and that, understand, Varun, you raise a very pertinent question. Sahil, in fact, I feel that when it comes to policy, while the government is very progressive, proactive, and it engages with all the stakeholders, I think younger people should be guiding the government on policy. I feel there is experience and wisdom that older people have, but I think the nuanced understanding of new technology, new business models, rest with the creators who can give a different perspective. So I don't see too many young people on policy.
So you hit the nail on the head, Anurag. What I was actually going to add on to Varun, of course, who elaborated very well and articulately, is the fact that it needs to be a consultative process. That's something we're lacking. You mentioned online gaming. I was actually advising one of the gaming unicorns when this happened overnight. And of course, we all know it's been a bloodbath post that. There was absolutely no consultation at all. And I'm not talking at a mid-management, lower management level. I'm talking about founders of unicorns had no idea what happened. I work with a public policy think tank. I actually called one of them up in virtual panic, and he was in Sweden. He had no idea what was happening. So this is as far as the consultative part of it is concerned. There needs to be a more consultative approach to things, and of course, hand in hand, and as a complementary measure, that is the fact that you have to have, like you said, younger people who have a pulse on what is a tech that's evolving. They're actually responsible for a lot of that current tech that's evolving. You don't have techies today who are sitting in their 40s or 50s. You've got kids who as young as 14. I met somebody at 13. He developed a gaming company which I can't name currently, but is being acquired for a few $100 million, and it uses AI in a manner which I think a little scary. So these are aspects that the government will need to address in terms of consulting with and also actually bringing on board. Having said that, Startup India has a number of people who are fairly young, people in their 20s, people in their 30s, who have a pulse on things as well. But they're not necessarily people who are the creators themselves.
Sure. And I must say, there are bodies I don't want to name. They do a good job. But, I remember there's a certain association which is saying, we're doing this much in gaming, this much in gaming. What do they have to show for? Nothing, zero, right? So there is that two-way dialogue is not resulting into something. Now let me start with you, Sahil, this time. What is, as we go into 2026, and of course, AI is on everyone's mind, so to say. And last night I was watching Christiana Amanpur's show, which I try and watch if I am awake. Mostly I'm not awake at that time. But, she was interviewing somebody from Stanford University, and she was talking about what I was talking, social impact of AI, because the computing power means more and more resources. So we're growing computing power, but we're not growing water. We are growing computing power, but not necessarily we are growing electricity generation. So similarly, there are many aspects of technology's impact that we've not yet factored for the future. What could be those?
I would say in terms of tech impact for the future, the biggest current issue, and I'm not at liberty to discuss this because I'm actually speaking with the government on something directly related to AI. Varun, I think, is actually in cahoots with the government, so he'll be able to actually tell you what the government is thinking if he would like. But tech is actually today looked at completely with a mask of AI, and everyone looks at AI as this harbinger of great things to come in future. But we don't know which way AI is moving. I'm a great adopter of AI. I use AI in multiple ways. But in terms of tech, I would say we aren't emancipated enough today in India compared to what the West is doing to have a broader spectrum of an understanding of where we stand.
And there is a worry that AI is creating even more disparity. I was reading Karen Ho's book yesterday on the flight, and I'm sure you know about the Sama case in Kenya. Now, look at the way the labor was disadvantaged and their labor wages came down, and right now there's a suit going on. So when I read that, it was scary. And then there were other scenarios which I don't want to give. But the fact is, AI will have deep impact, and we'll need to think through the policy. Varun?
Yes, it is, having said that, just before I pass to Varun, I completely agree. But I think somewhere we've also got to look at AI as a great enabler. We just have to look at it from a holistic point of view of marrying the enabling aspect of AI with the risk aspect of AI. That's it.
Fantastic. Varun, your comments?
Yes. So at the we are part of that. So I'm just going to elaborate some of the key decisions which are there. I think the data privacy policy which is being built is going to be one of the most important decision which India makes in this century. And I think it has, if many would know, the rules on the data privacy has been notified next month. And there is something what we are talking right now, the DP board is getting formed for India, which is the data privacy board, which is going to regulate all the complaints you receive. Now the DP board for the first time, the power to put a penalty up to 250 crores per violation. So therefore, this is going to be a huge disruption in the next 12 months. How the DP board reacts, how the stakeholders move, how companies kind of comply to it. And there's another stakeholders which are coming, which usually come in, some is data activists. So a lot of activists are going to come in to bring down companies. And I can see that happening. Like if you had got a venture capital funding for a couple of $1 million, a competitor would say that file a complaint with the DP board to put a liability of 250 crores because you can get bankrupt day one. Or even if you're not bankrupt, no venture capital will fund you.
How do we safeguard against these things?
So all those issues are going to pan out. So right now what we are, when we are doing this, DP board is being formed and we are at the policy front of that. So they are bringing in technical experts to address these issues. Second is, last week, the AI generative paper has been issued by MITI, which is exactly the AI copyright issue you're talking. Now, AI, if you see, is like a machine, and the oil is the data, right? Now, if it takes on to the entire data and builds over it, what value, how does the value sharing happens is the next important major decision for all the stakeholders. And that also the government is at the right upfront making that policy. Now they are doing consultancy. Any of the stakeholders can go and comment on it also. And they are ready to open to it. My last comment is that for startups specifically, it's going to be very critical because they are going to kind of evaluate this. So these are important. Startups usually don't kind of focus on it, but gaming sector has taught us that unicorns of companies, they need to focus more on policy. They have not today understood they focus on other risks. They do not factor in policy risk in their budgets. They will need to understand that $1 spent on policy is good enough for their business to survive rather than later on.
Your final comments, Priyanka.
I'll just add on to what Varun said, that one is the consultative process which is required for, gaming companies like, and we've all seen what happened to them. Second, I want to add on to that, and that's because I'm actually working with some of these gaming companies who are looking to now, who are looking outward. They want to do outbound investments, etc., create their space in a country where, or, park their funds in a country and deploy their funds in a country which is okay for gaming laws, where gaming is not going to be a challenge from a real money perspective. But unfortunately, the ODI regulations are also not very clear at this point of time. And hence, some of those nuances needs to be fixed in as well. Along with the ban, ideally they should have thought through flipping off some of these business models, how to come up with the next business model or a next business idea. So that's, I think I'll add on to that, and that's how
I want to end by saying that I think with the involvement of professionals like you and those in the room, I'm sure with the dialogue or the conversation they're talking of, and founders being more sensitive to engaging with the policy makers to spend their money, time, effort, energy, and whatever little money, they're able to sensitize the policy makers about possibilities beyond banning, so to say. And one topic which we could do a whole day conference is this crypto. What will happen in the future? Now, if you're talking of a deal with the Americans and with Trump as the president, what is the road forward, right? And last thing, I would want a 30-second comment from you. There are winners of our under 30 awards in the room. What would you say to them as successful professionals? What is that one or two qualities they can have as they really move on with the professions? Priyanka, you?
be updated with the commercials. I think that's what's happening in the market. You need to be fully up speed with that. Just read as much as possible and follow what Mr. Batra is also following. So just read as much as possible, be aware of what is happening commercially, and you'll know your calling. You'll know what legal and tax has to do.
Varun?
So my input to all young professionals is generally, whatever you have learned, you are not going to find that valuable. Everything is going to change in this age. So the ability to unlearn and learn is going to determine who are going to be the next leaders.
Sahil?
I think agility is the mantra. A lot of lawyers, including myself, when we started in the profession, you thought if you knew the law, your career was done. And then when I went in-house, I realized, you're a spoke in the wheel, essentially, right? So you've got to be a business enabler. And the job, and I've always said this to my legal teams, is that everyone knows what you can't do and what the law says you can't do. You have to tell them how to do it. You have to marry business with the law.
I will say, having interacted with the legal community over the last 6 years, we launched BW Legal World on 12th December. I would say 3 things. First is what Sahil said, know beyond law. The more you know, the less you know. Second, I think soft skills matter. And third is mentorship. I think it's very important, both formal and informal mentors help you grow. Do this. Of course, read BW Legal World and Business World. Read our managing editor, Mr. Palak Shah's stories. I'll show you some of the stories he does. That's how I lost some of my hair. And, I'll tell you that in my address. But please give Priyanka, Varun, and Sahil a big round of applause. Our next set of speakers are here. And thank you once again.
Thank you. Thank you so much. A picture, please. Thank you, ma'am, in the gentleman. Supriya. Chaliye. The next one, it is from backlog to breakthrough, the next gen commercial disputes playbook. Please join me in welcoming our panelists for the same. Kritika Krishnamurthy, founding partner, AK and Partners. Joining Kritika is Siddharth Sethi, partner, JSA. Ratan Singh, a senior advocate, Supreme Court of India, and Avneet Singh Arora, director, Arbitration and Conciliation, Ministry of Law and Justice. Both of them are not here yet, or are they? Yeah, here. I was just told, now that I see the year here. Lovely. And the session chair for this will be Rohan Batra, partner, Anagram Partners. So please welcome them with your applause, everybody.
Good morning, everyone. I'm actually the second Batra after Anurag Batraji. Today, we have a very interesting topic, something that I've been studying for a while. It's backlog, from backlog to breakthrough, the next-gen commercial playbook. In a way, we're going to talk about how we can revamp some of the legal system issues that we face on a daily basis. And today with me, we have an amazing panel. This panel needs no introduction, but very quickly, in the interest of time, I'll introduce everyone. On my left, we have Mr. Ratan Singh Ji, who's the senior advocate, Supreme Court of India. On my right, I have my colleague Siddharth, who's a partner at JSA. I also have Ms. Kritika Krishnamurthy, who's the founding partner at AKN Partners. And on my leftmost, we have Mr. Avneet Arora, who's Director, Arbitration and Reconciliation, Ministry of Law and Justice. I'll straight away dive into it. We have about 5.3 crores legal cases pending, most of it in the district court, about 64 lakhs in High Court, and about 80 to 90,000 in Supreme Court. Ratanji, what do you think is the biggest factor which is holding us back?
Good morning. My office is in GK1. I started, and it took me more than 45 minutes to reach here with lots of traffic on the road. 15 years back, when I used to start from my place, there used to be very thin traffic on the road. What have we done in these 15 years? Apart from making a couple of flyovers, nothing else. Population has been increasing every day. You are having more and more vehicles. So therefore, traffic is bound to increase. Same is the situation with judiciary. Apart from making better buildings for courts all across the country, what is that we have done in all these years? If we see the population and judge ratio in this country, it is pathetic. That is the problem. How you tackle this? You can tackle this with increased number of judges. You have to increase the judge population ratio. You need to have more judges, more courts. That everybody knows. Now coming to what we generally do and what we generally don't do. 5th and 6th of December, I had organized in Delhi, in Hotel Lalit, world's biggest construction law conference. And out of 57 speakers, 28 were foreign guys coming and speaking about their experiences in India. Problem is, we do not have certain things in this country for legal profession, which is very, very important. One, absence of continuing learning program for lawyers. This should be made compulsory in this country, that lawyers must upgrade their skills regularly. That helps in not only knowing about what are the developments going on, it exposes you to various other aspects. That is one thing. Mandatory continuing learning program is must. In fact, last year, I think, or some time back, I was speaking in a conference where Bar Council of India Chairman, Mr. Manan Misra, was also there. And 2 Supreme Court judges and Mr. Tushar Mehta was also with me on the panel. I said, this is one thing you must work on. He said, we are already working on it, and maybe in 6 months, you will have the CLP in place. It is more than years now. Thing has improved there. Professor Madhav Menon, who has started national law universities in India, he was also advocating for continuing program. Now, why this CLP is so important? It makes you a better lawyer. Better lawyer in court, decisions in court, and quality of awards by arbitrators are big, big issues in this country. You say that why against every single award? It's back, probably. I was just speaking in a conference in Kuala Lumpur, in AIC building. And I was telling them that come to India, we have improved our legislative things, we have made amendments in Arbitration and Conciliation Act. Those bad judgments which Supreme Court had passed, all of this has been undone. We have got legislature is doing everything possible to help arbitration, blah, blah, blah. One gentleman who used to be director of AIAC, Sundara Raju, he got up. He says, Mr. Singh, all of this is fine, but in India, every single award is challenged. And in fact, in one of the conferences where Avneet was with me, and rather he was moderating the session in Mandapam, what is that, Bharat Mandapam, where Vice President had also come. There again I talked about this. Why every award is challenged and why every judgment of court generally is taken up appeal and another appeal and, quality of judgment, quality of court. So when we say that the backlog should have judges who are having domain knowledge, because we're talking about commercial disputes. Unless judges have domain knowledge, unless they know the industry, unless they have got a specialization in the subject for which they are deciding disputes, they'll take days and days and dates and dates and dates. If you have a judge who understands IPR, who understands construction law, who understands tax matters and so on and so forth, it is very easy for them to immediately understand, take care of it. If they don't know this, they will go on and on. Similarly, for lawyers who are not having a specialization, they are again not a good support to the court. 2 years back in Singapore, I was for a conference, speaking in a conference. We were invited to Singapore Supreme Court to train accredited construction lawyers of Singapore. In Singapore, the Singapore Supreme Court gives accreditation to construction lawyers, to IPR lawyers. So they are accredited lawyers. So industry knows where to go, clients know where to go. They are better help to the courts. And when they sit as judges, they are better judges. If they are better judges, the judgments meet the expectation of the parties. If it meets expectation of the parties, you have lesser challenges and lesser appeals. That's my first take.
Thank you so much, sir. So we've heard a lot of qualitative and quantitative suggestions, but I want to go to Avneet to understand some policy framework. The legal world is also machinery in a way, and we are all stakeholders. From the lever of machinery that you are taking care of, what can we do to make sure it moves much faster? And to put some context, in the case of arbitration, we have still about 3 levels of challenge right up to the Supreme Court from the board itself. There's Arbitration Bill 2024, which is under discussion. So what can we really do to help us out?
Thank you, Rohan, for the question. And taking it forward from what Ratan sir just mentioned, we are all stakeholders in the entire ecosystem of arbitration. We have the legislation, we have the arbitrators, we have the lawyers, and we have the disputing parties. So all of these stakeholders have their own roles to ensure and contribute in ensuring that arbitration happens in a very efficacious and timely manner. So as far as the government is concerned, I think we are all aware, as was being mentioned by Ratan sir also, the act was passed in 1996. We made the first major amendment in 2015. We've again made an amendment in 19, another in 21, and we are also envisaging another amendment in 2025 or 2026. So the bill was also put in public domain. The focus of the amendments, if I can say, because we are where we are trying to contribute on the policy side of it, The focus again on in the amendments is to ensure that the arbitration ecosystem is up to date with global best practices. For example, we have tried to include a provision relating to emergency arbitration, which has been proposed and which is there in public domain. I think the bill was put for public consultation. And let me tell you, we received some excellent suggestions. So as far as the consultative process that was being talked about in the first session, I think the government is making very conscious efforts to ensure that all the stakeholders contribute in the consultation. So during the consultations, we received some excellent comments. Coming back to the concrete part of what the bill says, we have tried to include provisions relating to section 9A, which is akin to emergency arbitration globally. There's also a deliberation which is going on modification of an award. Although it's a tricky issue, there is a judgment of the Honorable Supreme Court in Gayatri Balaswamy which has recommended that we should have the tribunal in fact has the power to modify an award, although that may not be legislatively supported today because we don't see provisionally which allows the tribunal to do so. But that is also an interesting issue which is being discussed. We are also trying to see how best section 29A is working. We are aware that 29A is one of its kinds of provisions which exists in our jurisdiction, which doesn't have a parallel anywhere else globally. So the idea is, the audience may be aware, 29A mandates that the arbitration proceedings are required to be completed in a timely manner or in a time-bound manner with the period given in the statute. So there is also a deliberation going on, an active deliberation going on, whether there's a requirement of tweaking that as well. So therefore, there has always been a consistent effort on the part of the government to see what best can be done as far as the legislation is concerned, the policy is concerned. Just also referring to, I think, as was being mentioned by Ratan sir, commercial dispute resolution is a specialized dispute resolution mechanism. So it is very important that pursuant to the arbitration, assuming if it is going in a 34 or in a 37, the courts which are hearing the matters are also equipped to understand the scope of their interference, which I feel is very because we have seen, although the law is consistent across the country, but Delhi High Courts or the Delhi Commercial Court having a head of approach as far as the award is concerned, subject to the condition, as was being said, that the award, if the award is as it looks by a bare perusal, there is no choice for the but because of the Commercial Courts Act, where the courts are day in, day out hearing commercial matters, they have a sense of how to go about arbitrations and interference. I think that has also made a very substantial contribution in ensuring that commercial dispute resolution, as far as I think the larger cities are concerned, the original jurisdiction cities are concerned, has been doing well. There is scope for improvement, but I think all is being done to ensure that we can make it even better.
Can I come in here?
Please, sir.
What has been said is that commercial disputes require a special skill set for arbitrators. Arbitration Bar of India has set up a task force under my co-chairmanship to prepare protocol for construction arbitration. I am working on this. I am hopeful that within next 3 months, I'll be able to come up. The problem even without 29A, you could have done very well. Now you want to tweak it. The problem is that most of the arbitrators in this country are not aware of the practices of arbitration. Arbitrators appointed just because they are sitting as arbitrators. Nobody takes care in default appointment in Section 11 proceedings. Nobody will take into consideration whether that arbitrator has understanding of first principles of the nature of the dispute which is brought before that arbitrator. That is one. Second, no arbitrator reads the files till you reach the stage of oral final arguments. Result is, you have no control over the proceeding. You are not able to decide the discovery applications. You are not aware at all the questions being asked are relevant or not relevant. Cross-examinations for example, wherever I sit as arbitrator, it hardly takes to cross-examine one or two sessions for final arguments because I tell them this is your case. What have to you to say on this? What have to? Once arbitrator has gone through the files in the very beginning, which is the first thing which every arbitrator does globally, and in India, if you ask this to the arbitrators who sit here, for them it's surprise. Second, when it comes to cross-examination, they think that only correcting the role they are supposed to play. It is pathetic. So what is relevant, what is not relevant? Asking the dots by the tribunal, one of the regions, and secondly, cross-examiners are also supposed to educate the tribunal. How can you educate the tribunal if tribunal doesn't know what the dispute is? So, how to take care of this update? With the act, let there be some kind of guideline or the protocol. How it can be done, I don't know. It can be done in some way, like you have brought in India the 5th schedule, 7th schedule. What was that? It was IBA guidelines. If you can bring it there, I am going to come out with the protocol as we see how it ought to go about.
So thank you, sir. That's a good suggestion. Two submissions. One is, I think, the focus on institutional arbitration, because I think the vagaries of ad hoc arbitration are also creating these issues. Because if there is an institution which has a supervision, the quality of arbitrators is at least considered by the institution before appointing an arbitrator. The parties are aware about his background, about his performance with the institution. I think that can ensure in a big way the quality of arbitrators improving. The second point about having a protocol, I think we are also considering, I think it's a part of the bill which was in public domain, where there is a guideline which will lay down a model procedure to be followed by the arbitrators. It can be model, it can be tweaked or changed by the arbitrator considering the facts of the dispute which are before him, but ideally he should try to follow that. For example, a case management hearing under section under order 15A is there in the Commercial Courts Act. So something similar to that for arbitration, I think, can also make a big difference.
Thank you, Avneet. I think that's going to help us in streamlining arbitration. But we've now heard so far that this is where the government is doing something or needs to improve. This is where the judges need to do something. But let's bring the lens back to us practitioners as well. Just a quick fact for both Siddharth and Kritika. I was just checking the live data on the National Judicial Data Grid. I've just put it in front of you. One of the biggest reasons for pendency for civil cases, which includes commercial as well, is, and I can read it out, counsel not available. So over to you, Kritika. What do you think your opening remarks will be on this?
I'm on this panel because I wear many hats. So I prefer to spend my day doing commercial negotiations rather than disputes. If you bring me a dispute, I will say, come, let's facilitate this for you. And I have also worked a lot with the government on policies on mediation. Having said that, I bring in a slightly different, maybe controversial view. Our systems don't work. We are still learning to stand in straight lines in public places. And we've seen that we bring in laws. The government is trying a lot. Let me at least say that they're trying a lot to talk to people who get the system and try to make better laws. But you bring a, strong tiger like IBC and you give it to the system and they will morph it into a purring cat. We don't have strong financial legislations in India. Even if we make them, by the time they are implemented, they are so diluted, the timelines go for a toss, that, there is no intent to solve a problem. Having said that, in the last 1 week, professionally funded fintech startup as well as a publicly listed big company in insurance. Both came to me and said, and I've been trying to do this for 10 years, they said, uh, we have analyzed all the disputes that we have in our bucket. We have classified them and understood these are the majority types of disputes that we have. And can you help us build a standard operating procedure? I was, it was one of the best days of my life. I have been waiting for this, that you need to treat disputes as a business problem. They are not some side department that is just operating in isolation. It is very much part of your business. And if you have a dispute, it's a business problem. You better treat it like that. And now companies are coming forward. The more and more we have professionally funded companies, the more pressure there is going to be that you need to optimize your cost in dispute resolution. And at least at the company level and in any place outside of the court, there is going to be increasing pressure that you need to optimize your processes, bring in more efficiency, make it more cost effective, make it more impactful. And the more and more companies align themselves like this, the problem is going to solve. Unfortunately, I have a very pessimistic view about, institutional systems in India, like courts. A day spent in court, the internet doesn't work, I'm not able to respond to emails. Within that amount of time, I could have done 4 commercial negotiations or done 1 good mediation, commercial mediation. And so, trickle down to courts, I don't know how long it's going to take, but we are going to have to wake up to the fact that India is changing drastically. We are looking at more efficiency, more speed, and if we are not able to give it, people are just going to abandon the systems and create parallel systems. So, it's up to the practitioners, how they align themselves, and up to the systems, how they adapt to this change.
Thank you, Kritika, for this brutally honest view. Companies need to reorganize themselves, not treat disputes as just an ICU ward, but maybe treat it as a respiratory or cardiac department in your company. Now over to you, Siddharth. If you can throw some light on, again, the bottleneck before we move on to the second part, and what has been your practical daily living experience as a practitioner?
Thank you, Rohan. Esteemed members on the panel, ladies and gentlemen, namaste and a very good morning to you. We as practitioners frequently witness commercials delayed owing to procedural complexities or backlogs, and disputes getting dragged on for years even before commercial courts. So my experience has been that to address this, clients today become far more strategic and innovative when it comes to how they manage and approach their disputes. There is a clear shift in business strategy, with settlements becoming a more viable alternative. Today, the dominant client mindset is not legal ego. The dominant client mindset is business continuity and consistency. The primary concern is not legal entitlement, but how a dispute impacts their operations, cash flow, and reputation. When clients come to us, they now want an upfront viability assessment. They want to know as to what a dispute will be in terms of, or will have an impact on their time, cost, operations, and what will be the realistic outcome. And based on an evaluation of this viability assessment, they then decide whether to litigate or not litigate at all. And as a consequence, in my experience, weak or smaller value disputes often get parked or get settled at an early stage. Even in cases of higher value disputes, there is an increasing inclination and desire to opt for pre-litigation mediations.
clients are much more receptive to that today. Coupled with this is the fact that clients today want predictable billing. These are all practical scenarios that I'm trying to throw some light on. Clients want practical billing. Litigation is seen as a project with defined deliverables and budgets. And to budget for long pending litigations, clients approach law firms and request for well-defined fee arrangements, fixed fee arrangements, instead of long hourly, open-ended hourly billings. And to cater to these demands, even law firms are very proactive, and we are very happy to provide for fixed fee arrangements and not hourly billings in all the cases. Dispute resolution mechanisms are also today chosen strategically. Many businesses are proactively opting for arbitrations and mediations, and there is a clear desire to move away from as institutional rules. Seats are also chosen. The leading question today is in the mind of every client: how will I get the most effective outcome to a commercial dispute? Sasta, badhiya, tikau, or tez. No client today wants to be in a situation where bhais bik jaye aur bakri na mile.
Thank you, Siddharth. But in this equation of Tikau, I don't know how lawyers will fit, especially lawyers like all of you. So let's just get a quick round of remarks, because I think there's been a buzz round. And if we are talking about next-gen playbook, time management should be all right. So Ratan sir, it's my wish to see that in 4 or 5 years, a commercial litigant knows exactly that इस डेट पे मैटर आएगा, इस टाइम पे मैटर टेकअप होगा, and by so date the matter will be concluded. How far do you think we are from that vision, and what can we do to get there?
See, this is something one should expect. And in most developed jurisdictions, this is how things work. Months ahead, you are told that your matter will be taken up on Wednesday of March at 3:30 p.m. You reach the court premises, 3:30 p.m. your matter is taken up. You were told that you will be given 45 minutes. You sum up your arguments in 45 minutes. You know that judgments and decision will come within such and such date. But in India, it is not going to happen any time in near future because of the case load we have all across, infrastructure which we are not working on, judges, we don't have enough judges, we do not have enough specialized judges. These are some of the problems which we are still seeing. I have one thing to say on mediation, which both sides, both my co-panelists talked about, and this is important. We all talk about mediation, that mediation will take care of the court case load and it is a good alternative. Problem is in mediation, government and judiciary has been working for long number of years, but eventually what we see today is mediations are only helping you in deciding matrimonial disputes and some property and family disputes. We are not working on to develop a pool of mediators who are having industry knowledge, domain knowledge, as a result of which, apart from these matrimonial and family disputes, no other disputes are not going to this. And in this conference I had one session on mediation from top guys from US, Canada, and all them came. And I said, we will create a pool of construction dispute mediators. There is one way to do it, Nate. Suppose you have somebody who is a construction lawyer who knows construction disputes, but he doesn't know the mediation in that structured manner. There is a concept of co-mediation, where the industry expert sits with one mediation expert and both of them can help immensely.
Yeah.
That is one thing. And one last line on settlement. See, settlement due to the fear that if I go to court or in arbitration, it is going to take years and years is not a good thing which we see happening. Then the people who are breaching the contracts, who are on the wrong side of law, they will keep doing it if they know that other side is ultimately going to come to me and settle with me. So this fear is a problem. So settlement out of fear of delay in decision making is again not something which is a good sign for all of us. Thank you very much.
You're absolutely right, Ratanji. And let me get some final thoughts from Avneet as well. Where do you think we are right now? Well, we've discussed where we are. What are the tiny steps we can change to build a world-class institution to maybe allay apprehension given by Kritika?
So I think to begin with, I think a good testing ground could be arbitrations being done in time. And the question that you asked about, how do you see that can be done? I think the day when we see that arbitration or an arbitrator is seen as a full-time profession and accepted as such, people don't ask what else. If someone says I'm an arbitrator, which is what happens in the West. If a person says an arbitrator, day when it comes, we have crises and that have been given by the arbitrators. I think that can be a testing ground for us to then extrapolate this also. Because as was being said, the caseload in courts is huge. I mean, it will be very, very difficult to, at the first instance, start doing this with the court system. But where in arbitration party autonomy is, that is their choice. The clause provisions are yet to be notified, but again, the Mediation Act brings involved very actively in the passing of the legislation. The Arbitration Act took a long time to recognize institutional arbitration. While Mediation Act, what it does is it creates an ecosystem of stakeholders. We have a mediation service provider, which is akin to an arbitral institution. We have a mediation training institute. The entire process. So I think this policy mindset change, which is most important, which was being the parties see mediation as a process which can give them good results at the outset, can make a big difference. And I think in this regard, some of the public sectors have done very well. I was told ONGC has a mediation and conciliation scheme where the success rate is 75%. So they say 75% of their matters are getting settled in mediation and conciliation. Although ONGC is slightly different because the contractors that they have are very repetitive. So the only client that they have is ONGC. So they are inclined to settle the matters. It's a very limited pool of people that work together. So, but that is a good test case to understand that even in a public sector where there are a lot of approvals to be taken and consents to be taken, mediation does work. So I think commercial mediation with focus on some good mediators who have industry knowledge, as was being said, I think can also make a big difference.
Thank you, Avneet. So we are seeing some grassroots of progress. Just very quickly to get Kritika's and Siddharth's comment. I know we're almost on a section 29A lease. For Kritika, do you think data is going to be an enabler for us in managing disputes?
Thank you very much for asking me that, and I'll keep it very, very short. We were talking about quick commerce in the previous panel. I think we need an aggregator of sorts for, disputes, anything related to disputes. To answer Mr. Singh's question also, so the Ministry of Corporate Affairs, and my organization was the one who helped them set it up. We run an exclusive training program only for commercial mediation in India. And under that program, I personally trained 750 commercial mediators. They were not all lawyers. There were engineers, there were investment bankers, there were fund managers, there were CXOs of the Forbes top 500 companies of India. But nobody knows that they exist. And as he really pointed out, mediation is still used for, divorce and partition disputes. The problem is that, and now if you look at the Commercial Courts Act, the mediator is appointed by the Legal Service Authority, which is technically there for access to justice and have nothing to do, don't mind me, nothing to do with commercial disputes. And so data is going to be a major enabler. We need to set free the disaggregation of data. That is one of the key strategies of dispute resolution. पेचे फसाना, okay? I think पेचे फसानों के दिन अगर जिस दिन लद गए, things will automatically become better.
Thank you, Kritika. We also need to let the audience set free from us. So Siddharth, quick comments.
Yes, Rohan. So this is more for my younger colleagues in the audience. The future of commercial disputes belongs to lawyers who think like risk managers and negotiators first and litigators second. There is a need for a change in mindset. Lawyers must reinvent themselves from being post-dispute firefighters to people who are enabling and facilitating settlements. Lawyers ought to guide their clients that delay is not a leverage. The old playbook of file, adjourn, and settle later does not work any longer when clients are bleeding money awaiting resolution of disputes. Conducting a genuine cost-benefit analysis at the very start of a litigation goes a long way in guiding your clients and hand-holding your clients. Lawyers must identify and flag potential dispute triggers and advise their clients in safeguarding and providing for structures that minimize disputes. Dispute avoidance should be the key today. Lawyers should ensure that the contracts provide for strict timelines, clear exit mechanisms, enforceable ADR clauses, boilerplate arbitration clauses which are mechanically inserted at the end of a document without any thought have to be done away with. The standard clauses that we put in the arbitration, in any agreement, have to be stress tested against real world situations. How will they operate if the courts are congested or where an arbitration, etc., arbitration seat is not functional, etc. And last thought, technology is the key. Clients want speed, efficiency, transparency, and not necessarily the old traditional courtroom craftsmanship. So therefore, lawyers have to be tech savvy, data savvy, technologically literate, evidence-based, AI-based assisted evidence management, e-hearings, e-filings, etc. are the future. So lawyers all need to be equipped with that. So those are my 2 cents.
I'd like to thank everyone, each and every panelist. I think one central message for all of us is legal industry 1.0 was the giant elephant. The legal industry 2.0 looks like a legal cheetah to me. Sasta, fast, tikau, and gets the job done. I'd like to thank again all the panelists for this lovely discussion. And let's have a huge round of applause for all our panelists.
And thank you, Rohan, for moderating that. Thank you. We're very sorry for the buzzer. We just had to make sure that we don't get more late. Thank you so much, Ratanji, Avneet, Kritika, Siddharthji, and also Rohan. Thank you. Quickly moving ahead, the next one, it is on India's labor codes in action. What has changed for business, for workforce, and also for compliance? Please join me in the Mishra partner, Denston Link Legal. Joining him is Abhin Rasti partner, Ketan & Co. Joining them is Atul Javle Consulting. And this one will be chaired by Pooja Ramchandani, partner, Shardul Amshar Mangaldas. Everybody. You know, the people walking up on the stage, their collective experience is far more than the applause that you gave them. Let's try to take 2 now and welcome them. Lovely. Thank you.
Good afternoon and welcome to the BW event panel on India's labor codes that have moved from a decisive legislative intent to an operational reality today. Our focus today is not on what the code says, but on how it is reshaping business decisions, legal risk, and workforce strategy. Today we have our eminent panel of experts, Mr. Atul Juvle, Mr. Gyanendra Mishra, and Mr. Abhinav Rastogi, who all were just introduced to all of you. So what we have done is we've structured our discussion around each code. We'll try to wrap it up as soon as we can, but there are 4 codes and there are quite a few questions. And we'll dive into the practical implications, challenges, and strategies for implementation, which I'm sure are questions that everyone has. So we'll begin with the code on wages, and I'll start with Mr. Juvle. Mr. Juvle, what practical adjustments do organizations need to make while recalibrating wage structures to protect both margins and morale while remaining compliant?
First of all, thank you very much, BW and Dr. Batra as well as Doshi for inviting me. And really, it's a great start in the morning with Batra's keynote and also 2 sessions, wonderful sessions. So there is a liability on us to make our channel. So margin and moral. First of all, it's a really wonderful movement in the social security of India. Because when we talk about, when people are going abroad, one of the main reasons is social security. So I am not saying that social security will improve drastically, but it is a baby steps. And I will cover that on the wage part of it, moral and margin, where what is the question. So when the particularly in the proposed code, it is said that 50% has to be basic, and if the variable portion is more than 50%, it will be added to basic. Now, how does it work out? Is the there are 2 parts I want to, one more part I want to include is the gratuity also, because it's a part of wages. So, if we are to restructure the wages, important is that we ensure that while restructuring wages on the basis of the code definitions, we have to ensure that first of all take-home salary is not reduced. But that take care of that is really hurting to the moral of all the people, including young and old, whatever it is. Because we are concerned with what comes as SMS final credit to my account after tax, whatever deduction. So that should be ensured that to keep a moral. I have seen in my career 3-4 incidences where people were not accepting manager position because take-home salary was getting reduced once they become manager. So that should not happen. That will be a dampening sentiment, particularly for the youngsters. The reason is that for them, 1,000 rupees count. 1,000 rupees or 2,000 rupees count, not for the people who are earning more than 5 lakhs rupees. It doesn't matter. So most important for the moral, because moral keeps the company's productivity on the high stage. If moral is down, then company cannot survive. Even if you make some kind of particularly savings on the net profit side, only for the stock market, your progress depends on the moral of the employee. So moral, I said that, and it is wonderful in the code that one of the most I like that is the gratuity. Gratuity was becoming dead because today we know that nobody is working. Means I will say that 80% people leave the job between 1.5 to 3 years, 3.5 years, or maybe 4 years. Even my suggestion in the company was not to celebrate the people who have done 25 years, but my suggestion to the companies was to make the people more celebrity, those who spent 5 years in the organization. So gratuity will become a real aspect for the fantastic aspect for the wage revision. Reason is 15 days salary for 1 year is really a great when you lose a job. When you leave a job, that's not a problem. But when you lose a job, 15 days makes a lot of difference. Secondly, the wage structure, which will become a 20%. If I say that the 2 months or 3 months notice, it becomes 20%. So almost a person who is terminated will get at least 3 months legally payable compensation, which is a good for when you are in a trouble. On the company side also, I wanted to talk. I see there are marginal hits will be there in the payments. The reason is that when you want to keep the model, marginal hits will be there, but it will be temporary because it will create a long-term impact on your business and progress also. So, yes, companies and employers have to redo the calculations, redo the wage structures, but my suggestion is that they should not put the people on the minus side, which will impact the moral and which will impact long-term success of the business. I love this actually because they have given this, the calculations also. So it's a win-win situation for both. Yes, with some marginal cost to the employers, but it is good for the sustainability we talk. Sustainability depends on the employees because organizations cannot do sustainable business without employees.
Thank you. So as we can take away from this, balance is key. And once you are looking at restructuring of your wages, try not to reduce the take home because that's important for all your employees. And possibly a clear communication will also add to resolving any risks that could come with it if there is going to be a reduction in take home. So with that, I'll move on to Mr. Mishra. Mr. Mishra, what do you see as the highest likelihood of disputes under the wage code, and especially when we're talking about wage restructuring? Are they legacy arrangements? Will it be, the bonus payouts, the allowances? So where do you see the likelihood of disputes arising?
Thanks, Pooja, and thank you, Business World and Business Legal World, for organizing this very pertinent conference. So I think that's a very important question, and the very scope of dispute is arising the way the code has been implemented. So the real issue is not to, discuss whether the changes or the codes are good, but the real questions, are we ready for that? Since no time has been provided for the corporate to decode and implement and restructures, which requires a wide-scale restructuring of various policies, compensation and benefits, payroll processes, etc. So there's a big confusion when to start and when to finish, because the code has been implemented like for code on wage. Now, this law now completely repeal all previous laws. So as on today, when you look from the effective law perspective, all old laws are repealed. New law from the 21st November has been enforced, but the rule has yet not come, so you don't know how to enforce that. So what is going to happen in the interim is not clear. There's a lot of confusion. The clients are coming to us and asking what to do. Suppose if today someone is resigning or service is terminated, how to deal with the gratuity? Whether now we need to give the gratuity on an enhanced wage or the original wage. So there is much confusion, and that confusion, I think, will start leading to a lot of disputes. Because, so that uncertainty was one of the most important things that need to be addressed and which has not yet not been addressed. On the other hand, and I am speaking on a larger, scale, I think nobody questions the relevance of these codes. They were long due, and it is a really a very progressive piece of discussions. But the question is that whether the appropriate consultation, which is very important for success of any legislation reforms, more particularly on the labor, giving the different stakeholders into it. So I believe that, the consultation would have helped in seamless implementation of the law has not been done enough, if it has done at all. India provides a framework under the India Labour Conference for discussion on the labor issues where all the three different stakeholders and more than three different stakeholders are present. But you know that since 2015, no ILT conference has taken place. And look at the history when these codes were passed in year 2019 and 2020. Most of these codes were passed when the parliament was in turmoil because of the agitation on farm laws. So the question is that the way you look at it, it depends on your vantage points, that you look at it as in political expediencies or procedural shortcut, but the enough deliberation which was required to build larger consensus lagged as far as this code is concerned. And that is why you see there's a large scale protest. You know, the all trade unions have threatened a nationwide strike from February, from the month of February, to challenge the implementation of labor code. Today, I heard I was reading in the paper that your main opposition party, Congress, is also telling that we will oppose the implementation of the labor code. So, that is very unfortunate because, as I said, it was long demanding and long required need of, you know, reforms in the labor laws, and it is a really positive states towards building a, you know, progressive labor law regime which helps or creates an architecture which creates a balance between the enterprise and the employee's right. But unfortunately, because of certain aspects that I highlighted, the implementation is too much in question right now, and a lot of uncertainty looming around how it will go. Now coming back to Pooja's question, that where we see, you know, so as a lot of, you know, scope for or the, you know, dispute. So as you see, you know, the wage definition, now the major change which has basically happened is that now your wage for all your social security benefit is capped at 50%. So the new definitions is a positive step in the sense that it clearly defines the component which will be considered in the wage and the components which are excluded from the definition of wage, which may make the part of your CTC. But the catch is, the seismic shift which has happened is that now whatever way you structure your CTC, for social security calculations, the 50% of your CTC will be treated as your wage. And that requires a large scale restructuring of the compensation and benefits. And I see that the legacy issue will be where the major challenge or major dispute will happen. Because mostly in the service sector and corporate sector, you will see that the tendency to construct the CTC is in a way that a large portion of your emoluments are parked in, you know, performance incentive schemes or variable pays and ESOPs, etc., etc. And now when the employer will try to grapple with this change in the sense that they will try to reduce your variables and allowances and increase your basic pay, the challenge will be to deal with the legacy structure, how to go about it. Obviously, for a senior level employee, you will have to build the consensus, as Pooja was referring to. So the consent and consensus would be the key, but there would be an element where, you know, the employees may not be satisfied with. But when you're falling in the workers category, any change in wage structure, you know, requires the process, legislative process to follow, which is the 9A process, what we call, which again talks about consultations. So how you are going to do and how to create a balance, also referring to that where your take home is not reduced, but the cost of employment also is not increased beyond the proportion, because we must understand that the very basic of this law was for ease of compliance, ease of doing business, and to attract the larger investment in India. The cost arbitrage is one of the most important factor. And when you look around your competitor in the field of attracting the foreign investment, large scale manufacturing activities, Cambodia, Highlands, where the labor cost is much less in India. How to create this balance and how to ensure the regulatory compliance and the least business disruption is going to be a challenge, and this is where you may see disputes coming in.
Thank you. That's quite a few points to think about, and I think the most important one is that legacy arrangements that were never challenged earlier could be the weakest link. Of course, with the current uncertainties and what we're seeing in terms of the pushback on the labor code implementations, the labor codes clearly are here to stay. So the next one is for you, Abhinav. What future-proofing principles should employers adopt today to minimize litigation tomorrow?
Sure, thanks Pooja, and thank you BW for organizing this. Well, if I were to distill this into one legal principle, it would be that wage restructuring should be based on substance and rather than just doing some arithmetic or some calculation around it. That's one of the key take of the entire recalibration of wage structure. So to give you an example, we're doing a live matter where wages are approximately 70 to a wage bracket of 50%. So firstly, most employers, they are kind of taking refuge to a specific component which is prescribed under the excluded components, that is some pay to different expenses. So I'd like to touch base upon that point first, that any expense or any allowance or anything paid to an employee would not automatically fall under. There has to be some rationale, there has to be a tool for which that amount is paid. For example, a legal allowance given to a person who is in the legal department could be excluded. But if you apply this universally across the establishment, it would not fall within the purview of the excluded component. In a sense, what would that mean? That it would open your wage restructuring to scrutiny, to understand why this component was paid, and it should be included. So what I'm trying to say here is that it should not just be arithmetic. Proper reasoning, rationale should be adopted when you are doing that restructuring exercise. Also, importantly, you should check that while doing this restructuring exercise, it should not happen that your contributions like PF, where the threshold is 1,800 rupees per month for 15,000 employees who are earning up to 50,000 rupees, that should not get compromised, in the sense that if that reduces, then again, you're opening a Pandora box to scrutiny. So in a sense, everything should be from the perspective that how an organization functions, what rules could fall to have a particular allowance which could be paid to them, could fall within this excluded category, so that your liability for wage terminal benefits like gratuity, everything gets reduced to an appropriate amount, up to 50%.
Yeah, that's quite key. Compliance today must be designed keeping in mind tomorrow litigation risks, and rationale is definitely one of the important factors when you are looking at making changes to your wage structure specifically. I'll move on now to the Industrial Relations Code, and I'll start off with Mr. Juvle again. Do the revised thresholds for standing orders and retrenchment and closure genuinely improve agility in restructuring and workforce planning?
Yeah, actually, answer is yes also and no also. The reason is we have done that one number of 100 magical number to 300. So this is one of the major, and I think it's a good start. The idea is that if somebody starts a business, why they should go to government for the approval for closing of the business. That's because that is one of the dampening, and then particularly delaying the process of restructuring or retrenchment. So this is a good move that 100 number has moved to 300 because it is required. Now with the change in this ecosystem where we are having so many people on the roll, that 300 number is also very less actually. If we talk about the platform workers or we talk about the gig worker, gig side of story, the numbers are very huge. But it will give some kind of relief. We cannot expect that everything will happen in maybe one go. So I feel that there are many suggestions which have come in the particularly or maybe enactments, which will benefit the reclassifying and redoing the total structure where the agility will be there in some cases. I am not saying that it will be all across. Because if I have businesses going in the loss, I cannot invest my time in government permission to close down. Though finally it becomes bankrupt and then it closes down rather than I can do it at a right place so that people are also informed transparently. Because the problem is the transparency and then companies or employers are bound by the rules of the particularly taking the permissions and all. We need to move out of that permission. We have moved a lot actually, but still there is a room balance. So I feel this is a good start. One thing I wanted to comment on this, my panel, particularly member Mumai, this also, that today we are into particularly a situation where the labor codes are published and we are waiting for the rules. One of the litigation, the particularly increasing litigations will be which to be followed. And that's where they should be taken as a guidelines rather than law, where as you know, that SEBI provides a guideline and you have to comply. So companies should not wait because that's a common practice across the world, not only in India. When the law comes and there is a time, people feel that let's wait for the last announcement. Till that time, I will take that benefit. That approach should not be there. That approach will dampen the particularly sentiment, and we want to grow. If we want to become particularly second country in the world, definitely we have to move forward with the forward guidelines and all. So if the companies take it seriously, I think we can see a light early than rules comes.
Thank you. That's interesting to know that numbers help, but I suppose planning and procedure compliance will also be equally important when you're looking at any workforce restructuring. Moving on to Gyanendra, which provisions under the IR code are most likely to be tested in court and why?
So, I think, the first provision I know that going to be challenged in the court is the increase of the threshold from 100 to 300. And there would be the constitutional basis for that as well, that India being a socialist country, and there are the directive principle of a state policy which says that the government's responsibility is to protect the livelihood. And the data shows that in large number of manufacturing industries still fall within 100 to 300 of the category. So it may be challenged that the government has left the large section of lower level of workforce at the mercy of the employer, and basically by increasing the threshold has introduced the concept of hire and fire within the the employment scenario. So therefore it will be tested constitutionally. The Supreme Court in its earlier decisions have held valid the threshold of 100, but whether it will be tested in the same way when the threshold is 300, and more particularly the wage code gives states to even increase this threshold beyond 300 to any level where they wish. So there may be a competition among the states who want to seem as a progressive state and wants to attract investment to increase the threshold even much higher. So that's the one thing which I believe will be challenged. The second challenge may be now the extension of a standing order across the establishment. Earlier, the standing order was only applicable, as you know, to factories and other industrial establishment. But now it has been made across the board, even to service sectors, IT sectors, etc., etc. But there is no corresponding model standing orders, because when you look at the current standing order, there is only one model standing order, which is more tuned to the manufacturing sector rather than the service sector, IT sectors or technology sectors, etc., etc. And so how to harmonize their service rules with the model standing order, and when the model standing order go for certification before the authority, the challenge to harmonize their existing rules, which many times are guided by the global policies of the companies with the model standing orders and all that, you will see a lot of challenge happening there as well. On the bonus front, you see, again, there could be a challenge, because as far as the provident fund is concerned and the threshold limit, payment of wages, minimum wages, all the threshold has been taken away. But as far as the bonus is concerned, though the current limit of 21,000 is not disturbed in the sense, but there would be a further notification that what would be the limit for SAT. So there could be a challenge on that as well. So there are multiple issues where I see that the challenge may happen, Pooja.
Right. I mean, there is no law where there will not be a challenge, especially when it comes to employment law. And the IR code is definitely a code where jurisprudence will shape the business reality much more than the statutory text. So Abhinav, how can employers structure policies and documentation to avoid disputes rather than merely defend them?
Sure. I'd like to share an anecdote here of a FICCI event which Pooja was moderating. A simple line said by a trade union that stayed with me. When HR fails, IR triggers, correct? So that's a very powerful line, and that's what the entire realm of industrial relation code has been. From a reactive approach to litigation to a preventive measure. How there is a mechanism now, we are against the mechanism which is outlaid in the code now. That is one. Then your trade union representation becomes very imperative. So what, in a sense, I do not think that we need to overhaul the entire policy framework for employers. What they need to do is that they already had global policies in place. They need to just have reference, or they need to localize it from Indian employment law context, have a representation. For example, there was a grievance redressal mechanism in an employer's, typically it is a part of their employer's handbook. Now just just go a step ahead and have representation or have a reference to your non-managerial employees as well. Similarly, the standing orders, like my fellow panelist was speaking, is the heart of industrial relation now. They have a disciplinary mechanism, they have an appellate authority. So just ensure that you have a robust system, and the system is evenly played out to give equal opportunity for employees to set out their grievances so that you mitigate the litigation aspect.
Thank you. Prevention through policy design is definitely far more effective than a post facto legal defense, which comes with a lot of added cost. Right, so now we move on to the OSH code, and we have one more, so we will move on quite quickly. We'll keep from that. Mr. Juvle, this one's for you. How are companies leveraging technology, audits, and training to ensure consistent safety practices?
Thank you. Actually, OSH code is really, we need a mindset change for India. And particularly, it remains with every Indian, not the code. The reason is that we don't take safety still seriously. That's where I feel, because I have seen, and recently Goa incident is one of the examples that don't take it seriously. So rather than having the codes and rules and regulations, each one of us got some obligation that we should look at the code. How do we take safety seriously? Now, coming to the OSH code and the audits are improved a lot, because now it is moving from assurance audit. Assurance audit is just I take 5% sample and give audit report. Now it is coming to 100% level because of the artificial intelligence, because of the machine learning, and so it will improve. I have seen a problem when we wanted to catch a worker in the factory doing wrong thing. But today it is CCTV, we can get the evidences and which he or she cannot defend in the court of law. So audits will become real-time audits and we can have on the safety, but corporates are becoming very serious on the safety, and I see that when I'm in a board that where we talk safety other than, because that's a kind of importance is given to safety code. So audits will become real story, and then there will be, we were talking about the litigations. The litigation becomes zero because if there is a evidence on the board, actually, we can definitely take the actions. Because in labor laws, particularly, we talk about the manufacturing somebody too, but there are also new type of businesses also have what litigations because there are no evidences. If evidences are there, I don't think there can be appeal. In the morning we talk about the appealability is one of the points in Indian judiciary system. So I am positive on this side actually, particularly audit side where there will be real-time audit.
Thank you for that. It's encouraging to hear that safety compliance is becoming more and more important nowadays. Gyanendra, the next one's for you. What safeguards can organizations adopt to continue using contract labor without triggering adverse findings on core activity engagement?
So for that, again, I will say that you basically need to change the mindset, that, we need to understand that the engaging the contract labor is the reality of the way the modern business works, But now the law puts certain clear obligation on the employer to engage the contract labor where it seems necessary to engage the contract labor and not to engage in their core activities. So that mindset shift, seismic shift in the mindset, where you see the engagement of contract labor as in cost measures rather than from the necessity perspective, that if I'll hire the contract labor, they will be hired at the lower cost than our regular employee. So please engage the contract labor wherever possible. I think that mindset now to be changed, and you need to have the contract labor where there are, and the law also now gives the instances where there is no regular and continuous requirement of the job. Where there is a continued requirement, you should engage the regular employee and give them the protections, statutory protections. So first of all, in my opinion and my advice would be to change that mindset, evaluate your entire contract labor engagement policy and processes, and try to engage the contract labor where it is required, where it is necessary, where you don't have the required skills within your regular employee set, and that will see the reduced litigations and other aspects.
Thank you. So contract labor decisions and restructuring of whether or not you need to engage for core activity must withstand scrutiny. Of course, one has to go back to look at, are you engaging contract labor in core activity or not? What is core activity for your organization? And also whether, you can make that change effectively. Abhinav, where do you see the greatest legal ambiguity around leave and there's a lot being asked on leave encashment with the changes in the labor code, and how should employers mitigate that risk?
Sure. So yeah, I wouldn't strictly call it ambiguity. Definitely there is an overlap. And by overlap, I mean that the central and state government need to come up with clear notification guiding employers. For example, right now, the OSH code talks about post 30 days of leave, employees have the right to encash leaves. Whereas the state-specific shops and establishment, which is a primary statute for condition of service, provides for leaves ranging from 45 to 60 days. Now, this is a dichotomy here. How do employers navigate through this? So a simple exercise is that you need to first map all your locations, all the state-specific shops and establishment statutes leave provided under those state-specific shops and establishments. When you have done that, and once you have come to a conclusion which is the most beneficial statute between the two, the idea would be to comply with that more favorable statute for the time being until the central government or the state government comes in and gives clarification. Another interesting point is while OSH code, people are harping about the fact that post 30 days the leaves can be in cash, but the definition of wages under the OSH code is very different to the definition under the state-specific shops and establishment, which is more of a very inclusive definition, that is gross wages. Here it's going to be restricted to some limited amount because it only going to be it only will encapsulate your included components. So what I mean to say here is that a mapping exercise is very important. If you have multiple location, map it against the state-specific shops and establishment, map it against the OSH code. Once you've done that exercise, see what the wages component is under the OSH code, what is the wage component under the shops and establishment, whichever is more beneficial until the central government and state government comes with a clarification. Idea would be to comply with that for the time being.
Right, thank you. And I think to just add to what Abhinav said, there is also the component of, do you really need to encash the accumulation which one has gathered under the Shops Act, under the Labor Code? So that's the question that, we are grappling with right now. In my view, I don't think so, but then let's see what happens going forward. All right, the last one, Social Security Code. Mr. Juvle, have social security considerations begun influencing decisions on hiring models, outsourcing, or gig engagements?
Yeah, if there is a clarity, so there will be impact on the outsourcing model, and certainly it's a welcome stage. As a welcome step, I already mentioned on this code actually. So I believe that this change in the mindset, and which is happening actually, because we want to become a stronger nation, and everybody wants their own business in the growth scenario of India, and I think it's a welcome step.
Yes, this definitely reflects a broader shift in mindset, and compliance considerations will, going forward, definitely shape workforce architecture and not just HR policies as we engage different types of workforce. Gyanendra, which aspect of the Social Security Code represents the biggest break from the earlier regime?
I believe, this Social Security Code, now there's a lot of confusion, but, the thing is that from the Social Security perspective, I think it is the least disruptive among all other code, basically. ESI, I believe, is where the most of the changes will happen, because now it has been, the application of ESI has now been made universal. Although the salary threshold has not been changed, but now there is no requirement for scheduled employment and geographical locations, and therefore this will give the larger coverage, and that's the biggest change I see, the Social Security.
Right, and I think one more aspect that I would add to what Gyanendra just said is that there is an introduction of a limitation period for Provident Fund, which is, I think, the biggest help from an ease of business doing perspective. Till now we were looking at a possibility of a scrutiny or a claim or a Section 7A proceeding commencing right from the time an establishment was established. But now there is a 5-year limitation, and I think that's a welcome change for the industry. Abhinav, we wrap up with you. What risk-calibrated compliance approach should employers adopt while the framework continues to evolve?
Sure. So I'm conscious of the time and I'll keep it really short. The first one being that engagement of fixed term. That introduction has been made that they would be entitled to your employees. So that assessment needs to be done. In terms of another important aspect which I'd like to quickly highlight is about the gratuity. Don't wait for the last mile. The definition of wages is applicable as on date. There's no reason why an outgoing employee should not be paid gratuity as per the new definition. We are grappling with that issue. Pooja would echo with my views here, because this is a huge cost impact, right? From basic, which was about 20-30%, to what now it could be at least 50%, it could be more. So we need to understand, don't wait for the last mile, get in touch with your auditors, assess the liability. Grandfathering may or may not happen. There is a lot of debate over that. But just be ready until all the rules or the rules, the state governments come with the rules. Just have that agile approach. Do your wage restructuring, but ensure ready for ready for fixed term employees and gratuity payments.
Thank you, Abhinav, and thank you to all our panelists for their exceptional, thoughtful, and practical discussion. If there's one clear message today, it's that the labor codes are not merely it's not merely a compliance mandate. They're an opportunity for an organization to modernize workforce practices, strengthen governance, and build more resilient and future-ready enterprises. As the regulatory framework continues to evolve, those who invest earlier on in robust systems and transparent policies will not only stay compliant, they will also set benchmarks for responsible growth in India's evolving labor landscape. Thank you and enjoy the rest of the BW event.
And thank you, Pooja, for moderating that. Thank you so much. A picture. Lovely. That was what has changed for business, workforce, and compliance on India's labor codes in action. And now we are moving towards AI, accountability, and the enterprise, the new frontiers of digital law. We're running a little late. We'll try and cover it up now because you want to start the awards on time. A couple of you have flights back, as Dr. Batra talked of in the morning, and you want to be punctual to that. Surely, as you talk about the new frontiers of digital law, let's welcome our panelists on the stage. Up first, Dr. Pawan Duggal, advocate, Supreme Court of India. Joining him is Advocate Pulkit Chaudhary, Data Protection Manager, Spare Bank. Joining them is Lakshmi Menon, General Counsel, HPE. This one chaired by Shivrati Bajaj, co-founder and managing partner of RFT. Let's please welcome them with your applause, everybody. Thank you. Hey, sir, you can start. He's right there.
Okay. Afternoon, everyone. Pleasure to be here. And sorry for the 2-minute delay on the panel, I believe. Clock's ticking, so I guess we're on time. So we have one of the most interesting topics here today on the elephant in the room, which is artificial intelligence. For everyone, I think everyone in this room is using AI. Is there anyone who's not using AI? Great, then we've got a room full of answers and questions in that way. So I know we all should consider ourselves very fortunate because we are sitting at a milestone in the history of law and regulation, where we have a massive change coming in the whole landscape of not only how regulations are made, but also how they're interpreted and also how they're becoming applicable. Artificial intelligence is the new age that we've entered in as professionals, as people, and it's touching all lives. As we say, it's got the largest market touch. However, with the coming in of the Personal Data Protection Act and the government aligning towards artificial intelligence guidelines, the DPIIT coming out with the AI and copyright working paper, are all giving us inclinations as to how we will see our way forward in this very interesting times. Now, the personal data is, as we say, we are living up on the grace period for the same, where the applicability begins next year. And we have the penalties imposing are very clear. They're telling us either all the technology companies to obviously either align or be subject to the heavy penalties which rise up to 250 crores per instance. So it is not even dependent on revenue unlike the other jurisdictions such as the GDPR and EU GDPR. Clearly analyzing the fact that we are taking our own stand as a country on the technology laws and how we're going to deal with them. So we have got a very interesting panel here with, to quickly introduce myself, I'm Shivarthi Bajaj, we've got Dr. Dugal here, Lakshmi, and we've also got Pulkit. So I think I'll leave everyone to introduce themselves if they want to. But Dr. Dugal, of course, is an illuminary in this field. He practices with the Supreme Court of India. Lakshmi is with the GC with the HCL. And we've got Pulkit, who's with a Russian bank. So, so yeah, I think the bank is Sebar Bark, right? So yeah. So we will start with Dr. Dugal first. Dr. Dugal, pleasure to be in conversation with you again. Your thoughts would primarily, I would want that, you know, India is undergoing a transformative period from a regulatory perspective with the introduction of DPDP Act and rules, and with several perspective of plans for the AI regulation. How do you see this with the direct intervention of DPDP and AI in isolation?
Thank you, Shivarthi. The question is, today, DPDP Act, without becoming implemented, is already becoming portion of it as obsolete. Why? Because when they passed it in 11th of August 2023, they didn't think of AI. Today, AI is becoming a big data fiduciary because AI is taking the decision how my data as a data person is going to be, data principal is going to be taken. Yes, I can still apply the principal-agent relationship to say, well, I'm the principal, I'm invoking AI, so if my AI use is wrong, I'm going to be liable. Either way, the fact of the matter is the fire below my seat has already started. Whether I'm beginning to feel it or not is of no consequence because the fire is. I'm waiting for 30th of November 2026. That's the day when the exposure starts. Why? Because that's the day your potential complaints could potentially start coming in. Therefore, if you are in the mindset that you know, we all love in India cricket lovers, we all have that we can all hit 6 sixes on the last 6 balls of the T20 match. I think that never happens. I think you want to be hitting your 6. Problem is if you want to do jugaad, maybe jugaad may not necessarily work in the DPDP context. Therefore, how you are going and invoking AI in your day-to-day operations, you will have to be mindful of the fact that the AI also complies broadly with the parameters of the DPDP. It's a very transformative space, as she rightly talked about. But the next 1 year should also be the space where we should see a lot of movements in the form of more clarifications from the government to say how you need to be dealing with these things. There are a lot of gray zones yet. People are clueless. And as far as AI is concerned, the elephant in the room is not being addressed by any stakeholder. Look at the European Union AI Act. Look at the Chinese AI laws. Look at South Korea's law on AI. Look at El Salvador's new legislation on AI. Now look at Japan's new Basic AI Act or Hungarian law. Everybody is like the five blind men who are trying to describe an elephant. Nobody is dealing with the fundamental issue, will AI be granted legal personhood? Well, I am very clear that very quickly you'll have to start granting a conditional personhood and finally personhood to AI. Why? Because AI today has begun at that level where its cognitive intelligence is more than a PhD scholar or a PhD researcher. And only hold on, it's just AI. Agentic AI, a typical agentic AI agent is able to do one particular task 500 times more efficient than humans. And now with the AGI coming in and ultimately super intelligence, I think corporate sectors will have to be prepared. The laws is much, much behind. Well, the government is now beginning to wake up as far as AI is concerned. But the government is saying, I'm very clear. More innovation, less regulation. I don't want innovation to be hindered. Wonderful. The only problem is that the misuse of AI is beginning to catch up in a big way. Go to Darknet this morning, and the only version, or shall I say the predominant model that's available there is cybercrime as a service powered by artificial intelligence. Cyber criminals, no, we don't want to dirty our hands. Let's use AI for the purpose of going ahead and doing illegal activities. So corporates, legal stakeholders, DPDP ecosystem stakeholders will have to wake up, start tightening their belts. A lot of people are saying, hold on, let's not go ahead and do it, let's wait on. हो सकता है कुछ relaxation आ जाएगी, देख लेते हैं. Let's try to look at next September, October. I think that's a bit too late. Begin to start having your own preparedness levels in terms of where you currently stand vis-a-vis your preparedness for DPDP. Look at how you are doing your compliances under the IT Act, the IT Rules 2021, the IT Directions 2022, because all these are ultimately marrying down into a huge mesh of regulation. And the problem is, people still don't believe that they could potentially be facing 250 crores. Well, why? Because the argument is 250 crores is the maximum fine available. So I'm not going to get the maximum fine. Don't worry, gentlemen. The fact still remains is, if you get fined, your fine starts at 50 crore rupees. Yes, after 50 crores, the Data Protection Board has got some discretion whether to grant you anything between 50 and 250 crores. But the fundamental issue is, what most of the people are forgetting is that DPDP Act is a draconian legislation. Why? Because this money will not go to any private complainant. It goes to Government of India. It goes in the form of payment to Consolidated Fund of India. And should you say, sir, I don't have money, the government says, go back, no problem, sit back and relax. We consider this as areas of land revenue. So I'm going to attach the properties of the company. If that falls short, no problem. I now have the ability to attach the assets of the top management. So suddenly now top management has to be more careful that they must try to get the more compliances and more documentation in place. Why? Because if they don't do that, the ultimate exposure could be to the personal assets of the top management, which is unheard of. Of course, people have not even begun thinking in that direction because, we as Indians always wake up in the last moment. But I believe the time has come. It's a transformed world. Meanwhile, with this new approach, this new working paper on copyright, we are already beginning to see diversions, differences. A NASSCOM does a 25-page dissent note to this particular working paper. Why? Because they think it's going to have a prejudicial impact, rightfully so, on the industry. And if you are one of these small content creators, be prepared to be marginalized, because it will be consolidation of the big few, the big tech, versus marginalization of the smaller, the medium content creators. So very interesting times. All I'll have to say is, you have to tell everybody in your ecosystem, please don't reduce things into writing. Whatever you do, don't reduce into writing. Why? Because the moment a personal data breach takes place, two triggers trigger off. Number one, within 6 hours of my coming to know about it, I have to report it to the Computer Emergency Response Team of India. I don't report it, no problem. After 6 hours, I commit an offense, punishable with imprisonment and fine, section 70B6 of the IT Act. But that's one exposure. The second exposure is within the next 72 hours, from the time I come to know the attack or the personal data breach, I am required to give a detailed report to the Data Protection Board. The moment I don't do that, that is also non-contravention. That's also contravention. That contravention, the 250 crores also potentially start sinking in. So I think we're going to see a tsunami of complaints against corporations, against entities, should they not be compliant. So I think the only way forward is compliance. That's the only nirvana going forward, but it's a transformative stuff. We have to realize that our journey has begun. We are already riding a running tiger, and we do not have the ability to get out the tiger. Therefore, we have to go ahead and calibrate our approaches and strategies as we move forward. Thanks.
Absolutely, thank you, sir. Yes, we are actually running a very aggressive tiger, right now. And to add to it, I'd like to move to Lakshmi, stating that with the advent of, not the advent exactly, but the coming up of a working paper on AI and copyright, which is directly in fact, it is trying to put a policy on one nation, one license. That, in short, means that there is a question of dealing with fair use that has been a very big hinging point for all copyright matters in India up till now, in terms of dealing it on a more monetary and statutory aspect. So when we are talking about AI and an amalgamation with intellectual property rights in terms of ownership, the biggest question that we have now is who owns your data? Is it the creator, the person who put the prompt, the company, or some third-party vendor? The output ownership is something that is a very big question mark in the ecosystem right now. So Lakshmi, I'd like your thoughts on the intermingling of IP, DP, and the advent of AI in terms of ownership and in terms of the law and regulation. How do you think it stands and it evolves? Thank you.
Yeah, thanks, Shivarti, and good afternoon, everybody. I'll first probably address the question around AI and copyrights. In most jurisdictions, any AI content or any AI output is not treated as copyrightable because there has to be some sort of significant human input. And obviously that would entail things like skills, judgment, intellect. So unless that is demonstrable and very evident, any AI-generated output would not be treated as a standalone copyrightable piece of work. Some of the jurisdictions, interestingly, which actually recognize potential copyrightable work which is generated through AI is China. Because China believes that if they are able to show that even the AI content or the AI generated output has certain features of intelligence, can function on its own, then that would be given copyrightable status. What's also interesting is countries like Australia, the US, India, we are countries or jurisdictions that clearly believe that copyrightable works have to have human intervention, it has to have human creativity, but there are jurisdictions like the UK where they're clearly also looking at the potential of recognizing generated content as standalone copyrightable work. What's fascinating is in order for AI to be recognized as a standalone copyrightable work is it should have, features which are very identical to human intelligence. And the other fairly fascinating thing which I came across when I was going through this piece was any sort of copyrightable work which has any AI input, if it is merely used as a tool, it can gain copyright status. However, if it is a standalone work or if it is completely operational without any sort of human input, that will not be treated as copyrightable. So even when, like for instance, a person who's an AI developer is using, say, some sort of an AI tool to edit content or to carry out some other sort of work to embellish some literature or something that they're working on, that will be treated as something which is capable of being copyrightable. So, so when it comes to copyright and IP and and AI, there definitely has to be human oversight, human in the loop, human intervention, because it's quite clear that without that level of intervention, these works would not be treated as original. On the point that you made regarding accountability, especially when you drew reference to the AI, the METI guidelines. So the METI guidelines are a very interesting set of guidelines which are basically anchored in 7 principles. And one of the 7 principles is accountability. So the other principles are, do not cause harm, keeping the human in the loop, fairness, transparency. But I think one of the most critical pieces of the guideline is the accountability element. And that also ties in with the copyright related debate, because when AI is created in an accountable fashion, and by the way, when the people who create any sort of AI output, it's not a single person. So most of us have this misnotion, or it's like almost to the point of dystopia, that when you create any sort of AI content, it's only someone who's a technologist or someone who has some coding capabilities who's able to create it. But actual content creators of AI are people who span across an entire spectrum. So it's people from the leadership team of that company. It includes C-suite executives. It includes people from legal, from compliance. And why that's important is because you need a broad spectrum of professionals to help develop robust frameworks so that AI is generated and produced and created in a responsible fashion. So responsible and fair use is so important and critical to the entire dialogue when it comes to accountability. And some of the companies that have really aced the principles of responsible use or secure use are companies like Google, for instance. They have principles rooted in explainable AI, or you take Anthropic, for instance. They are very focused on building AI platforms, which are again rooted in safety. You have IBM, which is the creator of Watson, which again is very rooted in the principles of responsible AI. So these are some of the companies that have really got it right. There's a German company by the name Validator, and this company actually creates certain solutions which are used to develop accountable and robust AI frameworks. Why is creating a robust AI framework important? It's important because your regulatory framework and this AI framework or accountability framework that you're creating need to merge. They need to talk to each other, because if it doesn't talk to each other, that's when there is a greater possibility or there's a greater susceptibility for AI caused harm, right? And interestingly, harm that's caused by AI cannot be easily redressed by AI. Right? So therefore, I would just want to conclude this particular point by saying that creating accountability in developing AI is no longer optional. It's absolutely essential. And either companies that are involved in the business of creating AI, or businesses that are involved in purchasing or consuming, or if you're a user of AI, it's so important to understand that you don't buy something which is not explainable. You don't buy something which is non-transparent. You buy something where the AI actually is clear. It's able to explain itself. It's not like a sandbox or a black box where you cannot figure out what's really going on, because it has independent decision-making capabilities, and you need to understand that. So that's why it's really important when you have this conversation, or when you're looking at investing in AI, using AI, always take a moment to understand if that tool that you're using, are they deploying responsible and secure use principles, or are they just blatantly selling a product to you without revealing what's really happening in the background?
Thank you, Lakshmi. So what we need to appreciate here is that the not laws as such as of now, but the guidelines are clearly hinting towards a very important aspect, which are also highlighted in the AI regulation guidelines released by MeitY, is privacy has to be built in the design of the product. So privacy by design is something that has been a very front runner in terms of the messaging explained to everyone through the guidelines. And the second aspect that has really come through is that who owns what, who created what. When we think of that, we only think of probably a tree or a flower or some other object in terms of creativity, but IP goes way deeper. It goes up to the inventions that have been made by very learned inventors. It goes up to be deep fake or misuse of cross brands being created by a lot of entrepreneurs. It goes up to the fact of the multiple designs that are important and have been filed in the ecosystem and are owned by various brands and creators. So these are the very, very strong lines that are being crossed with the advent of AI and with the, of course, the built-up of the Personal Data Protection Act, Pulke. I'd like to take your thoughts on how, when one is building and the role of personal data in a company in terms of it being inherently incorporated going forward as a design factor to build on privacy by design.
Thank you for that question, Shivarti, and very good afternoon to all the ladies and gentlemen present here. So I would say that AI is a relatively new concept as compared to data privacy. And in terms of building it and its deployment in, you can say, the organizational infrastructure, its intersection with data privacy is something which is very much technical in nature. And on the data privacy side, we already have the concept of privacy by design. We do have certain principles governing it. And I guess this is the roadmap that every AI developer should focus upon. From Indian regime, I would say that DPDP is something which is not actively covering AI per se, because there is no mention of AI there. And that is something that our government should proactively work upon. And while we were sitting here and we were listening to insights of our honorable members of the legal forum, one of the members of the parliament has introduced a bill related to AI and its accountability. And taking into consideration, so I would just like to mention that DPDP is not covering AI per se, but whenever you are incorporating any kind of personal data into your AI system like LLM models or maybe the chat bots, at that particular instance, the DPDP Act gets triggered because you are governing your AI model on the basis of personal data, and which is very well covered comprehensively under the DPDP Act. Now, privacy by design is something, even though which is not, you can say, recognized by our Indian legal regime, but this is something which is a global principle and that should be very well incorporated, and it works on the best industry practices.
Also, if you could just highlight it along with the DPDP Act in terms of amalgamating the two.
Sure. In terms of DPDP Act, I would say that it's still a very new legislation. It's like a newborn baby which will develop over a time. And we might see a lot of amendments in it, and we might see AI being an integral part of DPDPA framework. And we might see a comprehensive legislation in the future so that such kind of principles are not only applicable to the organization in terms of best standards only, but rather as a regulatory mandate. So these are my broad, you can say, conclusions on this. And comparing it with the GDPR, so under the GDPR, we have some of the rights pertaining to use of AI by the organization. So we have the right to restrict the processing based upon AI. And we don't have anything as such in the Indian regime as of now. So I would say that there should always be a kind of human intervention whenever any kind of personal data is being processed entirely through AI, and we should have such kind of principles in place. To conclude, I would say that implementing the AI models is like, in terms of GDPR, it's like operating a flight wherein a trained pilot is allowed to retain the control. From DPDP perspective, it's that the pilot is entirely responsible whether you are opting for an autopilot mode or not. So this is a brief, yes, please.
So Pulkit, when I read the DPDP Act, one of the things that stood out, especially around AI, was the fact that all these AI developers are now going to be clearly covered, and they would have to follow the, the principles and the obligations under the Act, because there are three distinct areas where I see that they are going to be governed. One is all AI, be it content creators or developers, they would have to start following the consent process. So consent becomes somewhere king, and they will, in order to develop any sort of AI training modules, they cannot collect or collate data without obtaining consent. So this is probably the first attempt at really regulating, I would say, AI users, AI developers, AI processors. They also become data fiduciaries. And by virtue of that, it's like it's literally like putting a leash or a rein on them, because all this while, all the AI developers who went out and were involved in data scraping or unauthorizedly mining data, they are all now on a leash. And clearly, they're not going to be very happy about it, because there's a cost to that compliance, like Sir said some time back. So the second aspect is accountability, because now they are data fiduciaries. And the third aspect is the data subjects, or the users, whose data they're going to collate and use and process. Those folks now have a right. So earlier, though they were voiceless, right, data users. But now data users are going to have a clear voice, the right to erasure of data, right to amend their data. So obviously, AI developers, users, as well as processors are not in a very comfortable spot right now with the new DPDP Act. That's how I see it.
Right, thank you. I think we'll have to conclude. So I'll just quickly take concluding remarks from everyone. And now, since we are at a very gathering of lawyers, everybody from the legal field, I have a question for everyone to include in their concluding remarks. Dr. Dugal, what is the one clause that you would say is imperative for all contracts going forward to be included as an aspect keeping in light today's discussion?
The master clause will have to be compliance with DPDP, will have to be done by me and by my outsourced vendor or service provider, be that as it may. Now, both of us are in the same boat. My responsibility is not going to be adjudicated solely on my basis. I will have to be responsible for that. So get your terms very, very crystal clearly defined, revisit all your contracts without any exception, and make sure that there are appropriate standard addendums to the contracts whereby your legal interest under the DPDP Act could be protected.
Lakshmi. Concluding remarks, aspect of any clauses that you feel are imperative going forward in all contracts. Yes.
I think it will become very important to look at the liability and indemnity clauses, because DPDP being a law, I think more vendors are going to push very hard to have very broad indemnities. So clearly that is something for all customers, for customers to look, for vendors to look out for. So they're going to have a tough time negotiating that, especially because there are clear thresholds and limits also prescribed by the Act. Yeah. And another very important thing, not from a contracting perspective, but I think it's very important for all of us lawyers to ensure that your board, the board of directors, if you're working as an in-house lawyer, ensure that the board is appropriately briefed, because any failure to apprise the board when there's a data protection breach will also result in a penalty of 200 CR. I think that's the second highest penalty that's been prescribed in the act.
Thank you. To conclude my remarks, I would say that I totally concur with the insights of the panel members. Apart from that, I just want to conclude by saying that data privacy is something which is not a one-person game and should not be entirely dependent upon the data protection officer or the privacy council of the organization. Rather, it has to be, you can say, a game of all the individuals participating in the daily affairs of an organization, be it CEO, be it the operations team, be it HR, be it the CRM team. So I would say that it more of a culture-based game that will, I would say, proactively shape up the regime, the privacy or the AI regime that our economy is heading towards. So by that, I'll conclude the remarks.
Thank you. Thank you, everyone. Let's see how this interesting times proceed with the advent of data fiduciaries, personal data, data processors, and everything being taken over by AI and regulation. I think we're going to witness very interesting times ahead, both in the courts, on contracts, and in our daily use. Thank you, everyone. And thank you, Team BW.
Thank you so much. A picture, please. And thank you, ma'am, for moderating that. Thank you. Thank you so much. Thank you. And now we'll take a brief break from the panel discussions and we'll move towards the celebrations of the afternoon. It's an honor to welcome all of you to the 5th edition of BW Legal World's 30 Under 30 Awards. Today, we've all gathered here to celebrate and honor the young Turks like yourselves who've showcased exceptional body of work very early in their legal journey and on their path to become the leaders of tomorrow. A big thank to our partners as well, powered by partner Iris Value Catalyst, event partners Atatik Shake Factory, Joy Travels Private Limited, Opal Events, Reality Plus, Exchange for Media, IWM Buzz, Impact, Pitch, Phantom, and also Beanley Coffee. With a list which has been handed over to me, it comes via a very strong and honest and transparent process, जिसके बारे में Dr. Batra बात करेंगे in his address. What exactly happened from the time you nominated yourselves till the time that I will be getting the awards list in the next few minutes. उस पूरे process को हमने बहुत ही सुंदर तरीके से we've captured it in an EV. We'd like to show you that as well. We just wait for this last table. We have 1 2 very important keynote addresses and then of course the awards ceremony as well. Quick because we don't want to keep you holding for lunch as well. और बहुत flight भी हैं. Also the visa payment, which is very important, which we want to make sure कि हम उसे कैंसिल करवाने में उसके भागीदारी बिल्कुल नहीं बनना चाहते हैं. But चलिए, first for the jury AV, please.
BW Legal 30 under 30 awardees have been chosen based on the candidates' meritocracy, meticulousness, and learnedness with a growth mindset, research foundation, and contributions, which is par excellence based on the experience and achievements in career at this bright age. And we see them as future flag bearers of the legal profession, as stalwarts, achievers, and contributors to the larger society. I wish all the winners the very best for future. Congratulations again. Thank you.
Good evening. It's my privilege to be part of the jury panel of 30 under 30 awards. And thank you, BW Legal team, for having faith and trust in me as making me to be part of the jury panel. So thank you. I'm thoroughly impressed with the transparent selection process. As regards the awards and the nomination we have received, we have given weightage to the merit, the key achievements of the professionals who have submitted their nominations, and their contribution to the legal field. We received nominations from very promising and hardworking professionals who are confident and have aspirations to create space for themselves. I congratulate all the winners. They have a bright future ahead, and this 30 under 30 awards will certainly make them confident and enhance their morale. Best of luck to all the winners, and my best wishes for the hard work put in by BW Legal team. Thank you.
BW 30 under 30. It was a proud privilege to be part of the jury to select one of India's brightest young lawyers, both in the litigation domains and also in-house domains and other legal functions. So the best part was to interact with the fellow jury members who were all stalwarts in their own right, and to select the future leaders in the legal profession. As they say, catch them young and watch them grow. So let's shape India's legal future in the best possible manner. And my congratulations to all the winners.
Greetings to all the winners and those who lost this year, they will make next year. Congratulations to the organizing committee. Judging BW Legal's 30 under 30 was energizing for me. Beyond resumes and designations, we engaged with minds that are curious, ethical, and impact-driven. Our deliberations were rigorous and unbiased, rooted purely in merit, integrity, innovation, and social consciousness. What impressed me most was the courage to rethink law as a tool for change, not just practice. This generation isn't waiting for the future of law. They are already shaping it. All the very best. Thank you.
BW Legal World 30 under 30 एक ऐसा मंच है जो युवा विधि प्रतिभाओं को अपने कार्य, विचार और समर्पण को प्रस्तुत करने का एक सशक्त अवसर प्रदान करता है। इसके लिए BW Legal World प्रशंसा का पात्र है और लीगल 30 under 30 जैसे उत्कृष्ट आयोजन के लिए मैं उन्हें हार्दिक बधाई देता हूं। इस वर्ष सभी प्रतिभागी अत्यंत प्रतिभाशाली और संभावनाओं से भरपूर थे। विधि के विविध क्षेत्रों में उनके कार्य ने यह स्पष्ट कर दिया कि आने वाला भविष्य सुरक्षित और सक्षम हाथों में है। प्रत्येक उम्मीदवार का प्रदर्शन सराहनीय था, जिसके कारण चयन की प्रतिक्रिया अत्यंत चुनौतीपूर्ण रही। वास्तव में हर नाम इस सम्मान की सूची में शामिल होने योग्य था। फिर भी गहन विचार विमर्श के पश्चात विजेताओं का चयन सहमति से किया गया। यह निर्णय सभी मानकों पर आधारित और सर्वसम्मत था। मैं सभी विजेताओं को हार्दिक शुभकामनाएं देता हूं। आप विधि व्यवसाय के सक्षम ध्वजवाहक हैं और आने वाले समय में नई ऊंचाइयां प्राप्त करेंगे। जो प्रतिभागी इस बार सूची में स्थान नहीं बना सके, उनसे मैं कहना चाहूंगा, निराश ना हो। आपकी प्रतिभा और परिश्रम अवश्य ही आपको आगे सफलता दिलाएगा। एक बार पुनः सभी को बधाई और धन्यवाद।
Business World 30 under 30 awardees were chosen on the basis of merit, and each of the young lawyers have demonstrated exemplary legal knowledge, The young achievers have demonstrated exceptional merit, skill, and impact in their chosen field of law at a very early stage of their careers. We wish them all the best.
Let's please give a huge round of applause for jury members. It's not easy. Absolutely not easy with the kind of nominations you send in. Usme se ek list banana, but of course, list is a list, order is an order, which of course Dr. Batra will talk of. But before we do that, we have someone very special who's joined us today for the keynote address. Please join me in welcoming to the stage Deepika Narayan Bhardwaj, Director, Ekam Nyay Foundation, a journalist, a filmmaker, and also a social activist for her address. Please. अब स्वागत करते हैं एक बार और.
Good afternoon, ladies and gentlemen. Thank you so much, Anurag sir, for giving me this opportunity to speak to such august audience. I have done my law, but I'm not an advocate. And today, speaking in front of dignitaries like yourselves who are stalwarts in the field of law, I feel like giving a submission for the first time in Supreme Court of India in front of the judges. So please bear with me, but thank you so much, Anurag sir, for having me here. Injustice anywhere is a threat to justice everywhere. Until a decade and a half ago, I didn't even knew what these words were, leave apart the meaning of theirs. But today, these lines define the work that I do. Hi, my name is Deepika Narayan Bhardwaj. I'm an independent journalist, a documentary filmmaker, a social activist, and I run an NGO called the Ekam Nyay Foundation. Equal rights, equal justice is our motto, and we counsel and help those men and their families in India who are in distress because of false accusations, wrongful prosecution, very bitter matrimonial disputes, domestic violence, sexual abuse, child custody disputes, and feel helpless and unheard as our laws dealing with gender justice primarily treat only women as victims. In February 2025 this year, I stood next to Captain Rakesh Walia, a senior citizen, a decorated soldier of the Indian Army, retired. He was falsely accused of rape by a woman who has lodged 9 rape and molestation cases in Delhi alone in the last 6 to 7 years. There was not an iota of evidence against Captain Rakesh Walia. His only mistake was to meet this woman for digital promotion of his book, which was a world's bestseller. In just 1 hour of a car drive with him, where he picked this woman up from Chhatarpur metro station and dropped her at Botanical Garden metro station, this lady cooked up a case of brutal rape. We had to approach all the way Supreme Court to get him justice, which found him innocent, and now we have got the woman booked for extortion. In January 2024, I got a call at 10:30 p.m. in the night by Dheeraj Gupta. He was crying profusely. We often do not think that men can cry, but that night he was crying profusely. He had just come out of jail after spending 5 months on a fabricated charge of rape by a woman he had not even seen. I repeat my words, he had not even seen, forget even touching her. He was implicated in this case because the people who filed this false rape case on him wanted to extort 50 lakhs. These are just 2 instances of countless cases that we deal with on a daily basis where people who are presumed guilty by the system, the men, we help them every single day. We handheld them and we tell them that there is a hope and it is not hopelessness everywhere. It is tough to do this work, but still it is an important work in today's time and today's generation. At Ekam Nyay Foundation, we have in the last 1.5 years counseled more than 2,000 men and their families. And I say this as families, though we primarily talk to and counsel men, because behind every man, there's an entire set of family comprising of women, children who suffer if this man suffers. We have got more than 37 people arrested who were false accusers, extortionists, by working on ground with authorities and pleading to them that you need to listen to the other side as well. We are living in times where we are in 21st century, but in our country, the laws and the system do not recognize that a man can also be a victim of domestic violence. A man can also be a victim of sexual abuse. A man can also be a victim of very, very devious means to trap him in false cases and extort money out of him. And last but not the least, that a man can also be beaten up behind four walls. And when he speaks up, the system does not hear them. At Ekam Nyaya Foundation, we are trying to bridge the gap and tell people that justice belongs to everyone and not just one particular gender. I'm very pleased to share with all of you as well that though we are an organization that works on men's issues, on 16th of November 2025, we held our first conference, the Ekam Nyaya Conference, where though until now we have felt as orphans because people do not want to speak about these issues publicly because you are seen a misogynist or anti-women or anti-feminist. We had former Chief Justice of India, Justice UU Lalit, speaking at a conference and saying that what we stand for is truly the need of hour. Being pro-justice does not mean anti-women, and it is the onus on our system, our judiciary, that while actual perpetrators get punished, no innocent should be victimized by putting him through a trial, a criminal trial for years and years when he has done no wrong. Thank you so much once again, Anurag sir, and it's always an honor to speak on the stage. Thank you so much, sir. Thank you, sir.
Thank you so much, ma'am, for your inspiring stories and all the very, very, very best for the journey ahead. It's also an honor, it's always an honor to listen to our next speaker. Please join me in welcoming to the stage a guest of eminence for today, Shashank Bajpayee ji, ILI Central Government Standing Counsel, Delhi High Court, and also Counsel for Union of India Supreme Court. Please.
Thank you so much, Anurag ji, for giving me such a wonderful opportunity. Mishra ma'am is here. Vivek ji is here. There's a lot of things. I'm very happy. Anurag ji told me come in the 40 and 40 under 40 and 30 under 30. 30 under 30 is very close to my heart. There's a 2-3 reasons because I missed that opportunity in my life when I was in 30s. Anurag ji, I'll tell you 2-3 things from the bottom of my heart. When you told me you will give us some very small or big speech, I told to 2-3 my juniors, please prepare a good note. What should I speak in this very good event and meet such a very wonderful and they drafted a very, very good speech. What is the legal profession, how we can grow, what we should do, what is the opportunity in my life, how you can earn a lot of good clients, cases, and all these things. Then I discussed with someone else. He said, please say something different. Then I decided I'll not go with these 2-3 speeches. I'll go what really I am feeling. Yesterday I was discussing one of the very good things with my brain and with one of my very, very good junior during the course of the argument before the court. That is the very important part because previous to this, the speaker who was speaking here, she's doing extremely good. Anurag ji told about very, very high words about her. She is doing very good things about men, women's, rape victims, domestic violence cases, and a lot of things. I'm very happy for only and only the one reason. This is the biggest platform in the country where you are here, you are getting the opportunities to getting the award. In this stage, 30s, आपने डिसाइड किया कि मुझे एक अवार्ड लेना है कहाँ से देश की सबसे बड़ी ऑर्गेनाइजेशन से आज उस ऑर्गेनाइजेशन ने उस संस्था ने आपको चूज किया कि 30 एडवोकेट्स हैं का नाम है जो मैं कहना चाहता हूँ which is very important and very important I am telling you 30s में मुझे नहीं पता था विवेक जी कानपुर से हैं हमारी मुलाकात हुई 15 साल हो गए विवेक जी तो लोग कई चीज़ें कहते थे जब आप किसी डिस्ट्रिक्ट से आते हैं स्टेट से आते हैं आई केम फ्रॉम द स्टेट ऑफ उत्तर प्रदेश कि आप सुप्रीम कोर्ट आए कि सुप्रीम कोर्ट में आप किसी को जानते हैं आपने कहा मैं किसी को नहीं जानता, तो उस स्टेट के सबसे बड़े आदमी कौन है? तो कोई पर्टिकुलर नाम होता है, उनके पास चले जाइए, ही विल रिकमेंड योर नेम फॉर पास, ही मे रिकमेंड योर नेम टू इंट्रोड्यूस सम ऑफ द AOR, ही मे इंट्रोड्यूस योर नेम फ्रॉम सच ए वेरी बिग लॉ फर्म, जैसे मिश्रा मैम इज देयर, यू वांट अ इंटर्नशिप, आप उनको रिक्वेस्ट करोगे, दे मे शी मे अकोमोडेट यू। नहीं जानते हो, अदरवाइज देयर इज नो चांस टू गेटिंग ए गुड इंटर्नशिप, गेटिंग ए गुड जॉब, गेटिंग ए गुड क्लाइंट, गेटिंग ए गुड प्लेसमेंट। व्हाट इज रिक्वायर्ड 30s में? और लीगल प्रोफेशन, आई एम अंडरस्टैंडिंग आफ्टर around 20 years of my small practice कि this is nothing, this is only if you have a right path, right choice, right client, right organizations, right law firm, आप ग्रो करते जाओगे और करते जाओगे। मैं एक बड़ी, अनुराग जी ने मुझे कल एक बड़ी अच्छी स्पीच मुझे शेयर की, और वो स्पीच मुझे चेतन शर्मा सर ने भी शेयर की। उसमें उन्होंने कहा कि दुनिया का जो सबसे अच्छा प्रोफेशन है, बेस्ट प्रोफेशन इन दिस वर्ल्ड इज अ लीगल प्रोफेशन। लीगल प्रोफेशन में पैसा बियॉन्ड इमेजिनेशन, जो एक पूरा कॉर्पोरेट हाउस पूरे साल में कमाता है, एक अच्छे लॉयर कुछ महीनों में कमाते हैं, कुछ हफ्तों में कमाते हैं। बेस्ट लॉयर हम आज अपनी लाइफ में देखना शुरू करते हैं, एक पूरे वर्ल्ड में, चाहे वो बराक ओबामा को देखें, चाहे बिल क्लिंटन को देखें, चाहे इंडियन सिनेरियो में हम आते हैं तो भीमराव अम्बेडकर को देखें, चाहे जवाहरलाल नेहरू को देखें, राजेंद्र प्रसाद को देखें, चाहे KM मुंशी को देखें, चाहे मल्टीपल लोगों को देखें, एक कॉमन प्लेटफॉर्म है। उस प्लेटफॉर्म को आपको समझना होगा, वो प्लेटफॉर्म क्या है, सक्सेस की निशानी क्या है। तो सक्सेस की निशानी में 5-6 बड़ी स्पेशल चीज़ें आती हैं, वो मैं बड़ी विवेक जी से बड़ा एडमायर भी होता हूँ, पहले होता था, अब तो और ज़्यादा होता हूँ। एक ड्रेसिंग बहुत अच्छी होती है, तो हम लोग ने देखा सारे लॉयर्स बड़ी अच्छी ड्रेस पहने बैठे हैं, ड्रेसिंग है, टाई है, सूट है, शूज़ है, वॉच है, cuffing, everything, you have a very, very good dress. Then very good tab, latest technology है, because you are in Delhi, you are not in Chhattisgarh, Jharkhand, Odisha, Madhya Pradesh, where women are in the second grades. You don't have a toilets, you don't have a taps, you can't use your own phone in the courtrooms. You are here in the best super premium high court in the country. And the Delhi High Court is the high court beyond Supreme Court. बिकॉज इंडिया की सबसे इंपॉर्टेंट मिनिस्ट्री, सबसे इंपॉर्टेंट डिपार्टमेंट, सबसे इंपॉर्टेंट रेट्स, सबसे इंपॉर्टेंट जजेस, सबसे प्रीमियम लॉयर्स दिल्ली हाई कोर्ट में। एंड दिस इज द ओनली हाई कोर्ट जिसमें पूरे देश के लोग आते हैं, ग्रो करते हैं और एक लेवल तक पहुंचते हैं। आपको एक अपॉर्चुनिटी मिली है, उस अपॉर्चुनिटी में आना बहुत ज़रूरी है। और 30s में आपने डिसाइड किया क्या कि मुझे इस देश का बहुत अच्छा लॉयर बनना है, मुझे बहुत मेहनत से काम करना है। सफलता आएगी, इसमें तो सोचना ही नहीं, सफलता नहीं आएगी, शोहरत नहीं आएगी, पोजीशन नहीं आएगी, पावर नहीं आएगी, कनेक्शंस नहीं आएंगे, वो सब आएंगे। क्योंकि अनुराग जी ने इस पूरे देश से 140 करोड़ लोगों में से 35-30 लाख लॉयर्स में से इन 30 लोगों को ऑप्ट किया है। ये आने वाले 2025 का मेरा जो ये बैच है, जो ये अवार्ड लेके जा रहे हैं, जिनको इस देश के 10 या 15 या 20 साल बाद हम इस देश के पवन दुग्गल, इस देश के हरीश साल्वे, इस देश की मीनाक्षी अरोड़ा, इस देश के मल्टीपल लॉयर्स के रूप में हम देखेंगे, जिनका एक नाम होगा, जिनकी एक पोजीशन होगी, जिनकी एक क्रेडेंशियल्स और क्राइटेरिया और क्रेडिबिलिटी होगी। इस चीज़ को अर्न करने के लिए आपके पेरेंट्स ने यहाँ पे आपको भेजा, आपके पेरेंट्स ने डिसाइड किया कि मेरी बेटी, मेरा बेटा कई देश के कई शहरों से दिल्ली जाएं, अवार्ड फंक्शन लें, लर्निंग्स हों, अपॉर्चुनिटीज़ मिले। जो मैं कहना चाहता हूँ उसमें एक बहुत इंटरनली कुछ चीज़ें हैं। इस देश के फ्रेमवर्क को जब आप समझते हैं, इस देश के लोगों को आप देखते हैं, तो उनका जो विश्वास है, पहले मैं कुछ डिफरेंट एंगल से सोचता था, बट जब मैंने इस प्रोफेशन में आया और इसका रिगार्ड, इसका रिस्पेक्ट, इसका कमिटमेंट मैंने लोगों से देखा और लोगों से बात की, दे सेड कि अच्छा आपका बेटा लॉयर है, कैन आई डिस्कस विथ यू? सर मेरा ये मैट्रिमोनियल केस है, सर मेरा ये रेप केस है, आप मुझे बताइए, मेरा सिविल डिस्प्यूट है। एज ए लॉयर जब फर्स्ट ब्रीफ होती है लाइफ की, या सेकंड ब्रीफ होती है, 10th ब्रीफ होती है, हम भी कहते हैं यार केस आ गया है, नहीं आता तो क्या फ़र्क पड़ता है, किसी से पूछ लेंगे, दुग्गल साहब से पूछ लेंगे, क्या फ़र्क पड़ता है कि हम साइबर क्राइम में क्या करेंगे जाके। केस भी आता है, कोर्ट में जाते हैं, एक्सपर्टीज़ होती नहीं है और हम केस कभी कभी हार जाते हैं, पर क्लाइंट ट्रस्ट करता है, कहता सर आप मेरी अपील फाइल कर देना, हम जीत जाएंगे केस। हमें इस समय क्या करना चाहिए? कई लोग आते हैं कि अब सर 3 साल का लॉ हो गया है मैंडेटरी, मेरी बेटी ने कहा था कि मैं तो जुडिशरी की तैयारी करनी थी, अब 3 साल बाद करूंगी, अब मुझे 3 साल सिर्फ टाइम काटना है, तो 3 साल बाद फिर हम मजिस्ट्रेट बनेंगे। ठीक है, कुछ ने कहा मुझे LLM करना है, कुछ ने कहा मैं अभी 3 साल बाद का सेटअप देख रही हूँ या 5 साल बाद का सेटअप देख रही हूँ। मेरी सिर्फ 3-4 बहुत अच्छे छोटे से सजेशंस हैं जो बहुत टफ नहीं है, जो मुझे समझने में बहुत समय लगा, सच में समय लगा। लीगल प्रोफेशन में आने के बाद सिर्फ 2-3 काम करिए। आप चाहे कहीं भी प्रैक्टिस करिए पूरी कंट्री में, वहाँ का जो सबसे अच्छा चैम्बर हो, जो सबसे प्रेस्टिजियस चैम्बर हो, उस चैम्बर से अपने आप को एसोसिएट करिए। यू विल डेफिनेटली, जो ये प्रॉब्लम्स आती हैं छोटी छोटी, आप समझ नहीं पाते हैं, आपको एक्सपीरियंस की प्रॉब्लम्स आती हैं, चाहे वो कॉर्पोरेट में हो, चाहे सिविल लॉज में हो, चाहे क्रिमिनल लॉज में हो, चाहे PMLAs में हो, किसी भी डिपार्टमेंट की हो, तो वो आपके सीनियर के गाइडेंस में आपकी लाइफ ईजी और स्मूथ हो जाएगी। सेकेंड, जो अपनी एजुकेशन और एजुकेशन के बाद फर्दर एजुकेशन है, क्योंकि नाउ there's a lot of difference in the local high courts and the Delhi High Court, and local high courts and Supreme Court, other states district court versus Delhi ke district court, there's a lot of difference. There's a very high quality in Delhi, there's a very high life in Delhi, and there's a very promising career is in Delhi, because they are differently and very differently. I'm saying and requesting you in this stage, being a lawyer, please, अब आप इस प्रोफेशन में उस 2 स्टेजेस में जाएंगे. इफ यू वांट टू बी हरीश साल्वे, मे बी 70s इन हरीश साल्वे, तो यू हैव 40 years इन योर लाइफ. तो मान के चलिए मुझे 70 तक रहना है. अगर आज हरीश साल्वे को आप देखते हैं, हरीश साल्वे के जो बाद का बैच है उसको देखते हैं, जिसमें के वेणुगोपाल, राम जेठमलानी, के परासरन, मतलब दे आर बियॉन्ड 90, 92, 93 और 94 की रेंज में चल रहे हैं. अगर आप 94 को टारगेट कर रहे हैं अपनी लाइफ में और 90 को टारगेट कर रहे हैं अपनी लाइफ में, तो निश्चित रूप से सबसे इंपॉर्टेंट है वो हेल्थ. निश्चित रूप से फिजिकल हेल्थ, यस. मेंटल हेल्थ उससे भी ज़्यादा इंपॉर्टेंट है. मेंटल हेल्थ में तीनों चारों चीज़ें हैं, जो जैसे विवेक जी, वन ऑफ द वेरी फिटेस्ट लॉयर इन दिस सुप्रीम कोर्ट, लोग कहते हैं कि बड़ा फिट रहते हैं और चीज़ें बहुत अच्छी हैं. हम लोगों को स्ट्रेस बहुत होता है. आई आस्क्ड टू माय फादर, पापा शुरू में जब 30s में था कि लाइफ में स्ट्रेस भी कुछ होता है. बाद में पता लगा लीगल प्रोफेशन में बहुत स्ट्रेस होता है. जब क्लाइंट फ़ोन करता है मेरी बेल क्यों नहीं हुई, क्लाइंट फ़ोन करता है मेरा डिवोर्स क्यों नहीं ग्रांट हुआ, क्लाइंट फ़ोन करता है कि ये प्रॉब्लम आ रही है, मेरा एग्जीक्यूशन क्यों नहीं हुआ, तो स्ट्रेस कौन लेता है? स्ट्रेस आप लेते हैं. लॉयर्स के पास होते हैं, लॉ फर्म्स वाले शाम को 11 बजे फ़ोन करते हैं, ये क्यों नहीं मेरा काम करवा के आपने भिजवाया. वो स्ट्रेस, उस स्ट्रेस से बाहर निकलना, क्योंकि वो स्ट्रेस होता है. सेकेंड, अपने आप को ग्रोथ पे रखना, और लगातार वो ग्रोथ उस लेवल तक हो जहाँ तक आपके सपने नहीं पहुँचते हैं, क्योंकि इस प्रोफेशन में हाइट्स की लिमिट नहीं है, लिमिटलेस हाइट्स है. ये इंडिया का फर्स्ट फेज था जस्टिस चंद्रचूड़ का आफ्टर 75 years ऑफ इंडिपेंडेंस, कि हाईएस्ट नंबर ऑफ वुमेन्स इंडिया में सुप्रीम कोर्ट ने 12 वुमेन्स सिंगल बेंच में सीनियर डेजिग्नेट की, जो इंडिया के लिए बहुत बहुत और बहुत बड़ी बात थी. प्रीवियस टू दिस जाना था एक स्टेट ऑफ यूपी से, मतलब पूरे स्टेट ऑफ यूपी विच इज द बिगेस्ट स्टेट इन द कंट्री, 23rd और 24 करोड़ ऑफ पॉपुलेशन के बाद सिर्फ सेकंड वुमेन एक स्टेट से सीनियर डेजिग्नेट हो पाई सुप्रीम कोर्ट में. पॉइंट 1 तो प्रॉमिसिंग है. निश्चित रूप से हायर जुडिशरी में आज की डेट में जो हाई कोर्ट जजेस हैं 8% वुमेन्स हैं, सुप्रीम कोर्ट शायद 5% वुमेन्स हैं, लोअर जुडिशरी में सिर्फ 15% वुमेन्स हैं. उसमें क्योंकि यहाँ स्ट्रेंथ लड़कियों की बहुत ज़्यादा है, वुमेन्स लॉयर्स की बहुत ज़्यादा है, तो उन्हें पता है कि स्ट्रगल करके एक लिमिट, और लिमिट क्या है? जो हाईएस्ट लिमिट है. जब इंडिया में फातिमा बीवी सुप्रीम कोर्ट जज बनती हैं, जब इंदु मल्होत्रा सुप्रीम कोर्ट जज बनती हैं, जब इंडिया में बिला त्रिवेदी सुप्रीम कोर्ट जज बनती हैं, तीनों में डिस्टिंक्शन था. एक सुप्रीम कोर्ट से डायरेक्ट सुप्रीम कोर्ट प्रैक्टिस करके सुप्रीम कोर्ट बनती हैं, एक डिस्ट्रिक्ट जुडिशरी से सुप्रीम कोर्ट जाती हैं. पर कैरियर था 30 साल का. यू आर इन 30s, यू विल बी गो अप टू 65. तो दिस द 35 years ऑफ लाइफ. उसके बाद प्री दिस, अगर आपको जज बनना है, अगर आपको अच्छा लॉयर बनना है, तो अच्छे लॉयर्स भी कई सारी बहुत प्रॉमिसिंग, चाहे वो अभी सेकंड राउंड ऑफ स्पीकर्स हैं, गीता लूथरा, दे आर वेरी गुड इन क्रिमिनल लॉ. मल्टीपल लॉयर्स, उनका एक फेम हुआ, उनका एक नाम आया, उनकी एक पोजीशंस आई. वी आर इन 30s, अगेन वी आर इन 30s. Batra Saab is also here, so everybody wants to become a AOR in Supreme Court. There's a lot of AORs in Supreme Court. इन लीगल प्रोफेशन में हमें डिमांड क्या होती है, विच इज़ वेरी इंपॉर्टेंट इन माई लाइफ. एंड ऑफ द डे स्ट्रेस रिलैक्स कैसे होंगे, आपको स्ट्रेस कब नहीं होगा. मैं आपको ये बात हृदय से कहता हूँ आज, और बहुत मन से कहता हूँ, जब आप निश्चित रूप से अपना 100% अपने क्लाइंट को देते हैं, क्लाइंट के साथ जीते हैं, क्लाइंट के संग काम करते हैं, क्लाइंट को एक, दिस इज इनिशियल, दिस इज नॉट आफ्टर 20 years of दुग्गल साहब की एज में आने के बाद जब आप सिर्फ पैसा कमाते हैं और एक बहुत बड़ा नाम होता है, बहुत बड़ा ब्रांड होता है, अभी हम लोग उस स्टेज में नहीं है. हम लोग अभी उस स्टेज में हैं जहाँ सिर्फ कमिटमेंट है, काम है, सबमिशंस हैं, ब्रीफिंग्स हैं, गाइडेंस हैं, लोगों की नर्चरिंग है, लोगों के अटैचमेंट्स हैं और एक क्लाइंट जनरेट आप कर रहे हैं. आप लॉ फर्म में एक अपने आप को, जब आप जूनियर एसोसिएट से जाते हैं और पार्टनर की पोजीशन तक पहुंचते हैं, 20 साल लगते हैं. जब इसे मिश्रा की जगह 20 ईयर्स, जब आप एक ओनर का, मैनेजिंग पार्टनर का ट्रस्ट जीतते हैं. एक कोर्ट के अंदर आई एम टेलिंग यू, वन ऑफ द वेरी वेरी गुड काउंसिल कभी होगा, मैं आई विल रिक्वेस्ट टू अनुराग जी, उनको मैं लेके आऊँगा. मेरी शी इज़ द वन ऑफ द मैटर, शी वॉज माई ब्रीफिंग काउंसिल. मुझे पता नहीं था कौन है, तो मैंने कहा तुम आप अपने आप से मैटर कर लेना. सेकेंड डे शी केम टू मी, सर मैंने मैटर कर लिया. एंड आई वॉज इन द कोर्ट बिफोर जस्टिस सचिन दत्ता. Sachin Datta said to the ASG was appearing in that matter, in the whole of your panel, there's a 900 counsel, and she's the counsel who is one of the best counsel. She's the very honest counsel. तो ये जब उसको एक compliment मिला, which is the very international matter of high eminence and related to very high stake matter, तो मैंने उस लड़की से पूछा, मैंने कहा यार तुम्हारा प्रोफाइल, तो उसने बताया सर मैं लंदन की बैरिस्टर हूँ. मैंने कहा यू आर डूइंग दिस जॉब, जीपी यू आर हियर एज ए गवर्नमेंट लीडर. कहती यस. एंड शी इज द ब्रीफिंग मोर देन 1200 very premium matter of this country into the all these courts, Supreme Court, High Court, London, and appearing everywhere in the 6 years of practice. Well, 6 years of practice means 30s and the 30s, 24 to 30s. So then we are ensuring कि I told her maybe you will be the best lawyer, you may be the best, and best, best lawyer, you may be the justice. तो आज जो आप लोगों को आप आइडेंटिफाई कर रहे हैं, मैं आज आपको फिर कह रहा हूँ, अनुराग जी ने आपको आइडेंटिफाई किया है. दिस इज द बिगेस्ट मोमेंट ऑफ योर लाइफ, यू मस्ट बी हैप्पी. प्लीज इस अवार्ड को लेने के बाद, इस फंक्शन में आने के बाद, आपकी रिस्पॉन्सिबिलिटी बनती है कि 20 साल बाद आप ये इस देश में कहें कि मुझे अपनी लाइफ में उस समय ऑप्ट किया गया था जब मैं दुनिया में कहीं लोग नहीं जान रहे थे. ये फोटो, ये अवार्ड, ये ऑर्गेनाइजेशंस, ये बेस्ट टीम आपको मोटिवेट करेगी, ये आपको आगे ले जाएगी और आपके फील्ड में सबसे ऊपर ले जाएगी. इस बात का प्रॉमिसिंग, क्योंकि अनुराग जी ने एक दिन मुझे कहा, शशांक जी मुझे लॉ में नंबर 1 बनना है, मुझे उन लॉ के लोगों के लिए काम करना है जो सच में इस देश के लिए काम कर रहे हैं. इस देश के जो सबसे प्रीमियम लोग हैं, जिनको वो इस ऑर्गेनाइजेशंस में लाते हैं, इनका जो ज्यूरी प्रोसेस है, विच इज़ द टफेस्ट प्रोसेस, आप उसको क्वालिफाई करते हैं, उसमें अपने आप को प्रूफ करते हैं, उसके बाद आप यहाँ आते हैं. तो आप यहाँ आने के बाद क्या सोचते हैं, आपकी ओपिनियंस क्या होती हैं, आप अपने आप को कहाँ देखते हैं? बेस्ट सॉलिसिटर ऑफ दिस कंट्री, बेस्ट बैरिस्टर ऑफ दिस कंट्री, बेस्ट जस्टिस ऑफ दिस कंट्री, बेस्ट पॉलिटिशियन मे बी इन दिस कंट्री, चाहे वो जेटलीज हो, चाहे वो कोई भी हो, कि बेस्ट पॉलिटिशियन बनना है तो दिस इज़ द प्लेटफॉर्म. बेस्ट लॉयर बनना है, दिस इज़ द प्लेटफॉर्म. बेस्ट पार्टनर बनना है, दिस इज़ द प्लेटफॉर्म. और जो क्वालिटीज़ हैं 5-6 बहुत, चाहे कोर्ट जाइए, चाहे घर पर रहिए, चाहे सोसाइटी में रहिए, अभी कम से कम 20 साल, आने वाले 10 से और 20 साल ऑनेस्टी से, हार्ड वर्क, डेडिकेशन, और निश्चित रूप से दिस इज द प्लेटफॉर्म वेयर यू कैन इंटरेक्ट टॉप ऑफ द लाइन एंड टॉप ऑफ द लाइन्स लॉयर्स, मैनेजिंग पार्टनर्स. अदरवाइज दिस इज इम्पॉसिबल कि आप उनसे मिल सकें. दिस इज द इम्पॉसिबल आप वहाँ काम कर सकें. दिस इज द इम्पॉसिबल कि आप उस बियॉन्ड इमेजिनेशन जा सकें. इसलिए निश्चित रूप से मेरे लिए नहीं, अनुराग जी की जरूर तालियां बजाइए और एक अच्छे से तालियां बजाइए. इनको खुश हो कि उन्होंने आपको अपॉर्चुनिटी दी है. थैंक यू सो मच, थैंक यू सो मच, एंड थैंक यू सो मच. नमस्कार.
Shashank sir के लिए भी. See, I'm not a lawyer, but I've been inspired quite enough now to go and research about it after this. But thank you, sir. Thank you so much. It's always a pleasure to listen to you. We're also being graced by the jury chair today. And may I please request Meghna Mishra ji, a senior partner, Bahuguna Law Partners, who is also the jury chair, to please, ma'am, say a few words.
Very good afternoon to all of you. I think most of you here are winners, so many congratulations. But just very quickly, I want to share that, and I was just telling Anurag ji also, कि बहुत awards होते हैं, but this is one of the most transparent and honest processes I've ever seen, where there were, and there were applicants from pan-India, all with different, so there were law firms, there were practicing lawyers, there were people who were who had used their legal knowledge to sort of set up an app. There was someone who was doing investigation on the criminal side. So it was also very enthralling, interesting for the jury itself. And this award is really an acknowledgement of where you have come so far and where you could go from here on. And one point that I do want to, and I agree with Shashank really, is that we all hold hands and extend help to all our junior colleagues. And so it's not like, you know, you never need to think. I've also reached out to Pavanji on the corridor and said, ki, kya hai? You know, you can reach out to your senior colleagues at any time and look at it as a journey of moving forward with your colleagues, and always keep looking back to see whom you can also help to come forward. I would also urge and use this platform to say, please do a little bit of pro bono work as well. Don't be focused only on your personal growth of money and reaching somewhere, because I think that is also a need of the hour. And many, many congratulations to all of you once again. I don't want to take more time because I think we are already running a little behind schedule. So many, many congratulations to all of you. And those who didn't make it, I'm sure you will next time.
Thank you so much, ma'am. Thank you. चलिए जी, now for the award ceremony, to formally open the award ceremony, opening address के लिए please join me in welcoming on stage Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business and founder of the Exchange for Media Group.
Thank you. Let me say what Elizabeth Taylor said to many of our suitors. I won't keep you long. You know, I'm very happy that Ms. Deepika Narayan Bhardwaj is here. I've known her for 15 and a half, 16 years. And I was telling Shri Pawan Duggal ji and then Meghna ji that she's high integrity and she's non-commercial, which is a deadly combination if you want to really bring about a change. So please give Ms. Bhardwaj a big round of applause. She does fantastic work. And you know, the reason I called her here is because she has a foundation. You can give her donation. You can write a word. You're a very wealthy man, and that's not a joke. So please do write. I'm going to write to her in 2026. So please do write a check to her. Whatever, it doesn't matter. It can be 10,000, 10 lakhs, 10 crores, doesn't matter, right? Also want to acknowledge the presence of Mr. Hoshi Ghaswala. He's the CEO of a BW Engage Business and a senior most colleague of mine. Plus he's a Parsi, so they're special. And Mr. Harbinder Narula is the CEO of our healthcare, well-being and pharma community. I really want to keep to time because we're running late. But since the parents are there, I know a lot of parents have come in, brothers, sisters have come in, family members, friends have come in. Shashank ji says these things to me privately, that what matters is how well you know your profession and what is your court craft. So everything he says here, he says it to me privately. Meghna ji, thank you for acknowledging her process. And I want to, Mr. Siddharth Batra is here, and I remember in the first year of the BW Legal World 40 under 40, our jury chair, I had requested Justice Narasimha, that time he was not a justice, to be the jury chair. Mr. Shardul Shroff was there, Mr. Ryan Karanjawala was there, Mr. Rajiv Luthra. It was a dream, 12, 15 such people. And I was also there, and I have to tell you this, because I saw Siddharth. And Siddharth applied. I know Siddharth is a very prominent political family from Haryana. And I know him well, and I've known about his family for 40 years. Never met him, only met him a couple of years back. And then he became the lawyer of my MD. So the jury meet is on, and Mr. Justice Narasimha says, let Mr. Shardul Shroff be the jury chair. And everyone agrees. And I think the jury was pretty much run by Mr. Shardul Shroff, Mr. Rajiv Luthra, and Mr. Ryan Karanjewala. There were other 12 such members who were talking on text to each other, but these three people were deciding who were the winners. And they were really involved, and they told me, you don't know law, you will not be on the jury, you just sit. I said, okay, fine, I'm very happy that you've taken ownership. It doesn't get better than that. But I stayed there to learn, observe, because it was the first. And then one of my law firm we do work with is Trust Legal, Sudhir Mishra, and Petal has applied, Siddharth has applied. There may be 3 people I know who applied, and they're very, very good. I know because I know their work. I recommended Siddharth to be the lawyer of MDI. Iski kismat mein tha, ye ho gaya. And Petal ji I work with, so, and they present very well. And Justice Narasimha is texting me, you know, they're not voting for Siddharth. And he doesn't know Siddharth, like, he's just being like, he's just seen him and then he's saying about 1 or 2 other candidates who we want to win, but for some reason Mr. Shroff, Mr. Karanjewala and Mr. Rajiv Luthra, God bless him, are not, I mean, they're placing them lower. And finally, again, Mr. Shroff is getting into technical things. Do you practice? When did you give up your practice? This. So he is 42 on the list, Patel is 41 on the list, and both are not making on the list. And then they go through and they disqualified 2 people. On some, of course, very legit grounds. I don't remember exactly what that was. And that's how Mr. Siddharth Batra and Patel made it to the jury, and I saved some hair on my head. So that's how we do our awards. I want to tell you, in a world, you're lawyers, everything can be influenced. I'll not go into it. It'll be, it'll not be a good thing. But our awards are honest. I keep saying every process is close to perfect. The only 2 people who are perfect, or 3, one is my wife, the other is Lord Shiva, and third is Modi ji. Rest, everybody is imperfect. So our process is an honest process. It's not a perfect process. No process where human beings are judging human beings can be perfect. Plus how you play on that day. I also have one winner of our 40 under 40. Tonight there is 40 under 40. He's sitting here in the left, and he's applied for the 3rd time. And there are many people who applied for the 3rd time and won. So really, it's an honest process. That's the only thing I want to. I am a parent. I have 2 children. My daughter is 21 plus. My son is 17 plus. And I see there are parents here. I just want to say 3 things. One is, Shashankji talked about mental health. The most important thing for mental health is sleep. So sleep 8-9 hours. Don't say, I मैं 4 घंटे सोता हूँ. It's not a badge of honor. Whatever habits you form now will stay throughout your life. Whatever good habits I got in my 30s, I have. Whatever bad habits I got in 30s, I have. So try and. Second, I read this book called Tuesdays with Maury 25 years back. I don't get any royalty on the sale. But it basically says spend time with your loved ones. We are too busy pursuing money, fame, accolades. That's also okay. That's how the environment is. But spend time with your loved ones, your parents. I lost my mother last year. So, spend more time with your parents, husband, wife, brother, sister, pets. And last thing, I want to end by saying that, Shashankji talked about life lessons. I keep saying that the 3 C's matter. You should do away with. 3 H's you embrace. And I added a 3 G's recently. So I'll start with the 3 C's you should do away with. First is comparison. I know you're in an awards process, it's by elimination, but try and compare less. 0 may not be possible, it's not possible. I am not able to get to 0, so I can't say. You're unique, your gifts are unique, you are unique, so enjoy that. Criticize. Don't criticize people, organizations, individuals. You don't know enough about them, their circumstances. And last is complain. If you are doing well in life, you're getting an award, you're doing well in your practice, you have everything to be happy. The 3 H's which I keep saying you should embrace. First is hard work. Shashankji talked about it, Meghnaji alluded to it. Deepika is a product of that. Whatever you focus on grows. Second is humility. I think all the big people I know who achieved anything in life are the most humble. Right? They're very, very humble. But the 3rd H, which in my view is the most important H, some days I'm also low energy. I can't say, I'm never depressed, but I'm low energy. It depends on my sleep and sometimes on external factors. But the most important H, what does it stand for? For the less than 30-year-old, I'm asking. What is that H? Take a guess, yaar. Hair. Clearly, I don't have that. Hair, that's a good answer, but yeah, next time I'll add the 4th. I get very upset if you talk about hair and all, okay? Let's take this person's photo, but anyway, it's hope. The time is less. I wake up every morning believing today is the best day of my life. I stay hopeful and it helps me in life. So, 2 शब्द बहुत important है life में. एक तो कोशिश. सिद्धार्थ सेठी जी आपकी हिंदी बहुत सुदृढ़ है. शशांक जी आपकी भी सुदृढ़ है. और दूसरी है उम्मीद. आई थिंक अगर आप कोशिश और उम्मीद अपने पास रखेंगे तो लाइफ में कुछ भी कर सकते हैं. जो भी शशांक जी बोल रहे थे आप वो कर सकते हैं. एंड आई एडेड द 3 G's बिकॉज आई सेड मैं हर बार 3 C's और 3 H की बात करता हूँ. फर्स्ट इज द मोस्ट इंपॉर्टेंट, मे बी आई एम ओल्ड फैशन, इट इज ग्रैटिट्यूड. सच्ची में मैं जब 10 साल का था तो मेरी मदर बोलती थी भगवान को थैंक यू बोलो, तुम्हारे आँख ठीक है, नाक ठीक है. मेरी बड़ी बहन है, 4 साल बड़ी है मुझसे, तो मैं बिट्टू दीदी को बोलता था, ये मम्मी कैसी बातें करती है, पागल है मम्मी. ठीक है तो क्या है, क्यों थैंक. बट दीज डेज आई थैंक फॉर स्मॉलेस्ट ऑफ थिंग्स. आई एम अलोन, आई एम सेइंग थैंक यू. समटाइम्स विद फ्रेंड्स आई एम सेइंग द थिंग, यू नो, व्हाट इज ही डूइंग. बट ट्रस्ट मी, the more gratitude you give, the more happier life is. And you know, gratitude and complaining cannot stay together. It's like positive and negative. So the second G is, it's also very, it's grit. Lage raho, haarne ka nahi. Right? I'm an entrepreneur, I've seen many seasons. मैं लगा रहता हूँ, और someday it works out. I can tell you many instances. But the most important, you know, we glorify hustle, you know. I've been first generation. I think hustle is okay, I wouldn't, but let me say, grace takes you more places than hustle can. So be graceful in life. Sometimes I'm not. Sometimes also I'm also an emotional person. I react very emotionally. But I'm minimizing that. I'm saying, okay, I'll do the right thing. So have gratitude, have grit, and most importantly, have grace. God bless you. Congratulations. Please give yourselves a big round of applause.
Thank you so much. I think that's a lot of motivation to begin our award ceremony. Chaliye ji, any picture, any opinion that you share online from the celebrations, please use the hashtag BWLegalWorld30 under 30. That's 30, that's numeric, and 30U30. All the winners, once you receive your award, please step down from the stage, proceed to stage left, that is audience right, for an individual picture, and also stay back in the end before lunch or a group picture, both for editorial purposes. To present the awards, please join me in welcoming our presenters on stage. सबसे पहले Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business World and founder of the Exchange Media Group. Joining him is our jury chair, Meghna Mishra ji, Senior Partner, Bahuguna Law Partners. Also joining them is our guest of eminence, Shashank Bajpai ji, LLM, ILI Central Government Standing Council, Delhi High Court and Council for Union of India Supreme Court. And also joining them is Deepika Narayan Bhardwaj, Director, Ekam Nyay Foundation, a journalist, a filmmaker, and also a social activist. Ma'am. It's a list in alphabetical order. Nothing else, there's no rank in it. The top 30 are the top 30, you've made it all through and through. Chaliye ji, the first person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Ehsan Anwar Allara, Senior Associate, JSA Advocates and Solicitors. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World 30 under 30. Aditya Ajay, Principal Associate, JSA Advocates and Solicitors. For Aditya. Hello. Congratulations. And the next person to join the power list of BW Legal World 30 under 30 lawyers and legal influencers. Advocate Pulkit Chaudhary, Data Protection Manager, Sberbank. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Ankit Dev Arpan, Director, Lex Cyber Attorneys. Congratulations. And the next person to join the list of BW Legal World's 30 under 30 lawyers and legal influencers. Arnav Mittal, Government Pleader, Union of India, High Court of Delhi. Congratulations. Thank you, Deepika ji. Thank you so much, ma'am. Once for her, please. I request Oshi Gastala, CEO of BW Engage, Pawan Dugal ji, Advocate Supreme Court of India, also Ganendra Mishra, partner of Denston Link Legal, to please join us on the stage and help present the next set of awards. Surely, with that, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Ashwani Kumar, partner, AMSC Advocates and Solicitors. Congratulations. Thank you, Meghna ma'am. Thank you, Shashank ji. Thank you so much, sir. Thank you. Once for them, please. A jury chair, a guest of eminence. Thank you. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Bhavna Chandak, Senior Associate, Kachwaha and Partners. Bhavna, everybody. Congratulations, winners. Reminder, individual picture, group picture in the end. With that, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Devina Das, founder and international legal consultant, that unconventional lawyer. Chaliye ji, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Inderdeep Singh Aluwala, clarity, precision, and resolution. Congratulations. With that, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Kshitij Sharma, Senior Associate, Tri-Legal. Congratulations, Kshitij. Thank you, Hoshi sir, Dr. Duggal, thank you, and also thank you so much, Girnandraji, thank you. May I please request Harbinder Narula, the CEO of BW Healthcare World, BW Wellbeing World, and also BW Pharma World, along with Vivek Narayan Sharmaji, arguing counsel, Amiga, Advocate of Supreme Court of India, to please join us on the stage, sir. Mahek Ansara, Advocate, Intellectual Property Rights, Independent Practice. The father? Well, congratulations, sir, for him also as well. A louder one for him. Congratulations to you as well, sir. Chaliya ji, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Manohar Samal, partner, Ratan Samal Associates, LLP. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Mukund Sharma, Manager, PNB MetLife India Insurance. And the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Nikshita Niranjan, Deputy Registrar, International Arbitration and Mediation Center, Hyderabad. Congratulations. Moving ahead, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Angela Mukherjee, Senior Associate, Denson Link Legal. Congratulations. Thank you, Oshisa, Harbinder sir. And thank you, Nagaso sir. Thank you so much. Thank you. That's the question. Chaliye ji. Please request our next presenters to join us on the stage. Varun Bajaj, co-founding managing partner, RSD Bajaj Global Firms, along with Gurpawan Singh, president of Iris Consulting, along with HP Menon, General Counsel, HPE. Please join us on the stage and help us present our next set of awards. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Purvisha Jindal, Senior Associate, Shardul Amarchand Mangaldas, and co-advocates and solicitors. Purvisha. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Prabhav, Bahuguna partner, Bahuguna Law Associate. Prabhav. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Pragya Jain, a Senior Associate, Ex-Counsel Law Offices. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Pratham Mehrotra, partner, Mehrotra and Associates. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Ravi Raj Shekhar, Senior Associate, Luthra and Luthra Law Offices. Ravi, everybody. Congratulations. Thank you so much, Varun. Thank you so much, ma'am, as well. Thank you. May I please request Siddharth Sethi, partner, JSA, along with Atul Juble, partner, AP2 Legal Consulting, and also Mumtaz Bhalla, partner, ALP2, please join us on the stage and help us present our next set of awards. Moving ahead, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Suyash Singh Radhor, Manager, Legal Setu by Pine Labs. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Lex Sport. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Utkarsha Sharma, Senior Associate, Learned Partners. Congratulations. Thank you so much, gentlemen. Thank you. Thank you so much. So, couple with you. May I please request Shivriti Bajaj, co-founder and managing partner of RST Bajaj Global Law Firms, to please join us, along with Dimpy Mohanty, partner, Lex Counsel as well, to present our next set of awards. Along with Siddharth Batra, I get on record as Supreme Court of India. Sir. The next person to join the power list of BW Legal World's 30 under 30 lawyers and also legal influencers. Varun Verma, founder and advocates, We Law Chambers. Congratulations. Moving ahead, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Zarish Ali, Senior Associate, JSA Advocates and Solicitors. Congratulations. We're down to our last three winners. Don't forget individual picture, group picture in the end, and lunch will not open before that. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Arshit Singh, partner, Circle of Councils. Arshit, everybody. Congratulations. But we have to say that I think in all the years I've been hosting for Business World, you've been the nicest audience in terms of appreciating. You've sustained till the end. You can clap on that also. It feels good to be under 30 also. Chalo, next person to join the power list of BW Legal World's 30 under 30 lawyers and legal influencers. Ayush Srivastav, Senior Associate, K&M and Partners, Law Offices. We have with us Prabhakar Tiwari, Associate Partner, K&M and Partners, to receive the award. Congratulations with that. To the next last person who's joining the power list of BW Legal World's 30 laws and legal influencers this year. Jessica Tapush Bakshi, Principal Associate, Chartered Arjun Bangal Das & Co. We are being joined by her mother, who's receiving the award on her behalf. Ma'am, please. Madhumita Bakshi ji. For Jessica and for ma'am as well. Congratulations to all the winners. An important announcement. Post-lunch, we invite all of you to also stay back because we'll have sessions which will feature Justice Nazmi Waziri, former Judge Delhi High Court, Mr. Sanjay Jain, Senior Advocate, former ASG, amongst many others whom you would of course want to listen to and also meet. Along with that, while all the winners join us on the stage with their trophies or a group picture, Mr. Singh is here. Can you also play the partners, AV? All the winners, please, IE, with your trophies on the stage. While you're joining us, can you play the partners, AV? Winners, please. And the jury members as well. And the presenters as well. Please come, IE. After this, please join us for lunch. It is 3:05. We try and start with the next session. Please, all the winners, आइए. Come. You can also sit in the front if you want. You can also sit here. You can also sit in the front if you want, if you're comfortable with that. If you also want boxes for your trophies, you can take them from here, from the Business World team. For those who especially taking flights back home. कोई और भी आगे आके बैठ जाओ, अकेले मत बैठाओ उनको. Anyone else wants to join? You'll also sit in the front. Yes, thank you. We can't see you, sir. आप आगे आ जाओ. You can come and sit here if you want. If you're. We've got 2 empty slots here. Let's just call it that. Come, come, come. Now everyone is. Ajo, ajo. You got more photographers than the people getting the picture. Nice. Acha. You can look into your individual phones now. You got 10 seconds. Jahan jahan aapke phones hai. Quickly. Then we'll do the main picture as well. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Done. Thank you. You can join us for lunch. You'll have to wait. The center frame now, please. Also, it is 3:10. We'll try and resume by 3:35. We will have to, I mean. Also, smile, guys. Done, Naval. Please wait. Now there. There. Now, thank you. Please join us for lunch. Congratulations. 3:35 we start again. Thank you. Hello. Welcome back. May I please request you to also ask your colleagues to join us in sites so we can start like now? Or we are already very late. We don't want to go more. We'll take a minute more and then we'll start with the next panel of the people joining in. Surely we'll start with the next panel and I'm sure people will join us eventually. The next one, it is on State of the Law 2026, a yearly roundup and key trends redefining India's legal landscape. Before I welcome all the panelists for upcoming panels as well, a humble request, please try and stick to the timer now. I'm sure they've cut some time. जो वैसे ही बहुत कम था to discuss everything, I'm pretty sure. But we'll all try and match up to each other's expectations. Our panelists for this, Rohit Jolly, partner, Hammurabi and Solomon partners. Joining Rohit is Samar Suri, counsel, partner VSA Legal. Joining them is Abhinav Mishra, founder, Chambers of Abhinav Mishra. And this one will be chaired by Varun Singh, managing partner, Foresight Law Offices. Let's please welcome them with your applause. Did I say something?
I will sit somewhere else.
Abhinav will not be joining us, but we have with us Shalini Sati Prasad from ASA also joining us in this panel. Please. No, I know low come hai, but we can all double up and match up to their. Badhiya. Thank you.
Yeah, thank you, BW, for allowing us to do this discussion. And I think the topic is very wide, and discussion around it could be also surrounded on many issues. But we will try our level best to ensure that we stick to, the timeline as was indicated. And of course, since we're joined by experts on various fields, I think it'd be interesting to have some ideas about what went around in the year 2025 in terms of how the laws have been made or the issues that as a country we have surfaced or faced. And I think it'll be equally important to also understand that what are the things that we need to look at from the standpoint of going ahead in the year 2026. So to begin with, of course, in the age of technology, in the age of, media, the one most fat topic which everybody seems to be concerned about and or talks about is AI. And I think it has been extensively being used. It's no secret that it's been extensively used in every field, be it law firms or be it courts. Now, even the Supreme Court talks about there is an app called Supace where they are streamlining and trying to ensure that the filing or the reading of materials becomes a lot more simpler for courts, for judges in the Supreme Court and even in other courts. So streamlining documents and wanting to take care of, high bulk affairs to read. So I want to jump onto this topic and talk to maybe Rohit to begin with, that what is his views on the AI and the usage of his AI in the legal world?
Thanks, Varun, and thanks, BW, for having me. With AI, I'll just give some statistics first before it. With the innovation and technology and AI, there's a lot of positives also, but it is a big challenge for cybersecurity also. In the past year, we faced around 36 lakh cyber attacks, uh, causing more than 22,000 crore losses. That is the uh, volume of cyber attacks and losses that we are looking at. So coming to the point, uh, in India especially, and since it is a borderless crime, so it has to be uh, looked in a way that when we are implementing or any laws are there, it is covering everything. First is AI. I think all the laws governing IT and cybersecurity goes back to IT. Then there is no central act. We have a digital bill that is coming up, and we have fragmented governance. We have me- uh, by MIT guidelines, RBI, SEBI. Everyone has their own guidelines. So the just one thing, then you can jump on to the next question. So the issue that is still arising is for companies to follow everything, and it is cost heavy also.
Correct. No, actually, in fact, not just that. I think synchronization of laws and how it affects companies is, of course, is a widely talked about subject, because the manner in which either any company has to fulfill its compliance is very, very difficult, and the lack of synchronization does take a huge impact on them. But actually, I want to take this topic forward, where in the year 2025, or in fact even to 24, we have widely discussed and talked about the consolidations of the criminal law in our country. And I want to ask Shalini your inputs about how do you see that as a boon or a pain for our country as in date?
Hi, everyone. Thanks, Varun. Not just criminal laws. We see the new labor code being implemented in parts, of course. And we see many other regulations, like we are talking about AI, and there are regulations on dark patterns. Now, who knows what dark patterns is? But it is something that exists in the e-commerce world. And again, people are conned. There are two faces of the story everywhere. But a consolidation, I think the legal landscape in India has really matured now. Now, what we should look at is the implementation of that matured setup that we have. We talk about arbitration laws. I think it has been amended time and again, the laws, the statute, and we are at a place where we are pretty equipped to handle international arbitrations, to have great institutions in India and make India a dispute resolution hub. But it all depends on the judiciary and the bar as well on how we take it forward now.
Right. Actually, you raise an interesting point about implementation, and I think most of us who are litigating lawyers, we do see that a lot of laws are actually, made but not implemented. In fact, when you talk about labor code, I know for a fact that I've done work on labor issues where you've seen that labor code was actually enacted in 2020, but in 2025, it's been, for the first time, it's been said that it's been notified. But I want to get Sumer into this, because the one aspect about implementation of law is that it has very wide ramifications. And of course, we saw that, considering Sumer knows environmental law really well, I want to ask through a question in the environmental sector that, we saw that there was a step forward taken from One Shakti judgment, where there was in decision taken that post facto clearance should not be allowed, but that's again been now turned back. How do you see that in impacting the systems in such like in the implementation of projects? How do you think that will be impacted with this judgment?
Thanks, Varun, for the question. Hi, everyone. So it was not unprecedented what happened in Supreme Court, but it happens rarely. Just to give you a brief background of what the issue was and what happened. under Indian environmental law system, what you need before you start operations of an industry is a prior environmental clearance. The most important word being prior. The government came about with a couple of circulars, one in 2017 and later on in 2021, whereby the government allowed the industries to get post facto environmental clearance. This is what was challenged in One Shakti by the petitioners. And the Supreme Court this year, I think in May, struck down those circulars on the ground that the concept of prior environmental clearance is not followed. And therefore, we don't agree with what the government is wanting to do. Later on, CREDAI, being the head institution for all real estate developers, went as an association to Supreme Court. And Supreme Court thereafter sort of set aside the judgment passed by Justice Oak in One Shakti and said that, look, this is not sustainable development. What sustainable development means is that you have to look at the interest of all the developers as well. There are too many infrastructure projects which are in question. And therefore, to balance it out, Supreme Court said that we are going to, in exceptional circumstances, allow post facto environmental clearance. And therefore, the two circulars that were initially challenged were brought back in force. What impact it is going to have on the projects? Of course, it's a boon. The share market, I'm sure, did very well after that judgment was passed. But if you ask for my personal opinion, I think somewhere we have to look within ourselves and ask ourselves, what is it that we want? Do we want environmental laws which are to be strictly implemented, which is what Justice Oak said in his judgment? Or are we okay with letting the government compromise with the entire scheme to bring about laws which can sort of completely take away the impact of these strict environmental regulations?
Right. So in fact, thank you for that. That's an interesting thought to take it forward, because I'm trying to stick to the timeline as indicated by the MC. That, you know, if you're looking forward and if you're looking at implementation as such, where environmental, of course, is a very tricky topic. And of course, we can go on for hours of debates as to whether it has to be pro commercialization vis-a-vis protecting the environment, and where do you draw the thin line. But if you look at, let's say, you know, business operations in general, like if you're looking for growth, if you're looking for a success story, now that we're looking at the year 2026, I mean, we all see, you know, various acts being consolidated, various outdated laws to be removed. Like we heard about the labor law, we've heard about the consolidation of the criminal law. We're looking at AI. What do you, I want to throw this back to Rohit, that what do you feel would be most essential, or do you think would help us look at, let's say, from the information technology perspective, that what do you think would be the most useful going ahead to ensure a market which is better for growth?
First, I think I'd like to deal with the DPDP Act itself, because that is the first thing that is being implemented, and the compliance complexities is what will cause problems, especially for startups or smaller entities, because they'll increase their cost expenditure a lot, and the compliance complexities will deter them, and will be maybe good for us as lawyers, but it is something that and coming to the second part, what we are looking in the year 2026, we are hoping the digital bill is passed, and a comprehensive, robust act is there. Secondly, this for AI and for AI governing laws and DPDP, one thing we have to be very careful that we have to align them with global laws, because cross-border harmonization is very important, as we have seen in one or two instances where this North Korean group attacked Wazir X, and there's no answerability. Same thing happened. There was an Australian company attacked by American players, and the servers were used in some third jurisdiction. So the attribution is very important.
Right. So in fact, I recently attended a fintech event as well, and where there was a lot of discussion about like cross-border harmonization, and in fact, even from a regulatory standpoint, we in fact hear this in at least in the insurance sector, that there is something called the regulatory sandbox, where you allow a propelling environment so that new players in the market are allowed to introduce products which will help them test the market, see how well it does, and basis the free playing field, if they're able to succeed, they're able to put that product in the market. And then I think cross-border transactions that are doing to that large extent, when you're looking at financial transactions to, there are lots of countries which are part of a network which are allowing this cross-border fintech products to, come up. I think, so that's a debate for maybe fintech, and I think we're not really touching upon that. But I want to put this to Shalini, that, we keep talking about India to be, the leader in the arbitration market, and want it to be India to be pro arbitration. There are so many events happening in India day in, day out, from international events to daily events and the judges, the lawyers who are all talking about that, how India should be on the face of arbitration going ahead. Looking at 2026, what do you think India can do to make that impression stronger?
Uh, we are reaching there. I'll still not say that we are the hub. But of course, I think as a fraternity together, we are really trying very hard to be there to replace Singapore or maybe London-seated arbitrations or Paris-seated arbitrations. What is the most important factor here, as per me, is minimal judicial intervention. If somebody is going for ADR, it should be ADR and not a direct DR before courts and not a litigation. We have seen a lot of changes in the laws, but we have also seen some judgments like DMRC Damal, which have really created a lot of distrust in the international community. And any international player coming to India will always bear it in mind that even if I get an award in my favor, what will happen? After years, when as the Supreme Court in a curative petition reverses everything, and I go back to arbitration. So I think minimal judicial intervention is paramount here.
In fact, I want to bring in Sumer also on this. And I think the fact that, in minimum judicial intervention, I think I believe you also worked on a case, or you've recently had the exposure of work, or doing a matter where the modification award took place, and you had something to say on that as well.
So, you're right, Shalini, when you say that India wants to do a lot of things, wants to project a lot of things to the outlook. But unfortunately, look at what our courts are doing. And I can say it openly. I have legal luminaries behind me to fight a case in case there is one against me. But see, till today, the law was that once an award is passed, the courts will generally not interfere under 34. The courts would not modify that award. And that is a very important law we held the field till now. What has the Supreme Court done? The Supreme Court now says that we will not follow key, and we will grant liberty to the court under 34 to modify the award. In exceptional circumstances, you may dress it up all you want, but ultimately today you've empowered under 34 courts to interfere with arbitral awards. And therefore, I feel you have created one more ladder, one more step in the ladder, because in arbitrations, I mean, Section 11s go up to Supreme Court, Section 9 goes up to Supreme Court. An award is passed, that award goes up to Supreme Court. So how many battles will a person fight? So we really need a lot of introspection before we can actually call ourselves an arbitration hub.
Right. No, I mean, I don't want to, because since we're litigators, we obviously are against judges, we are against the government. So I want to rather end this on a more positive note. And I think, before I go on to the next question, I think from whatever limited experience that I've had and understood, that I think the reason why Singapore does so well is because it is institutionalized to a great extent. And SIAC leads the field because it's thoroughly professional. It has full of experts. The timelines are very, sought after. It's not like the same litigating lawyers who are running to court the same day and doing an arbitration in the afternoon or later in the day. So I think and I think India is trying to push that, at least when we see that from DIAC or, the other organizations that are coming up in the institutional way, to kind of promote, institutional arbitrations. And of course, at the same point of time, they are also promoting lawyers to be arbitrators in, like, smaller disputes, not wanting to be just an old boys club, wanting to allow more experts to kind of be homegrown in this profession to allow faster results. I want to maybe bring Rohit back into this. Okay. Rohit, and like most other litigators, not very fancy talking, but I want him to jump into this again because we may as well want to talk about something on the positive side as well. So, I mean, you are part of a fairly big firm, and so how do you see, like, ensuring more, I mean, to make offices more arbitration friendly? What are the steps that Solomon Harabi are taking to ensure Hammurabi are taking to ensure that there are more arbitrators, there are more arbitration friendly lawyers in your firm, or what are the steps just to ensure growth of arbitration from in your firm?
We in Hammurabi are not taking adjournments.
To that. I think it's not just the laws. I think we as legal practitioners and professionals have also changed a lot. We are more accountable towards our clients. A hearing is done, you need to send a proceeding to your client, letting the client know that this needs to be done. We are also into specialization these days. So I think as professionals, the face of our profession is changing, which is amazing to witness. And I think 2026 has a lot to offer.
You want to add something, or should I go back to? So, I mean, of course, being professional, of course, and I think as all stakeholders, we all would admit that it's equal responsibility for all of us to be as professional as possible, as diligent as possible towards our clients, and ensure that, the growth does take place. But I think other than that, if is there anything which you feel, Sumer, as maybe not looking at arbitration, but in general, I actually want to take away this question away from arbitration and want to talk about 2026 on another very positive aspect is that, we all struggle with, since you're an environmental specialist, and since we all know that we all struggle with the pollution in our city, what do you think we can do to make this city a little more livable?
Banning tandoors.
That certainly is not the answer. I hope I had a magic wand and I could do something about it. It is something very shocking. About 3-4 days back, I was hanging out with a friend and he asks me in the evening, what are your courts doing to prevent this pollution? And I stepped back and I thought to myself, this is not the court's job. This is the regulator's job. This is the government's job. Because the government has failed so badly at the court to step in, and it's been there since about 30 years now. We have living cases which are going on, Godavarman, MC Mehta. They've been going on for over 30 years. Application after application is filed. Anyways, getting back to your question, I saw something in Ranchi day before I was there for a matter. And I think decongestion is what we need. Before we come up with a plan of making a new parliament, a new Supreme Court that is going to be built now, why don't we think of something constructive by taking these big institutions out of the heart of the city? I know it's Lutyens, I know it's not easy to leave, but if we don't think of these out-of-box solutions, I don't think anything is going to happen. Other than that, there is a lot of education that needs to go in. Our time's up. I can see it in red, in fact. But yes, education is something that cannot be compromised with our day-to-day living. We need to have our lifestyle changes. I don't think I have any other solution for having better air quality in Delhi other than what I said. We need to decongest. We need to have better urban planning. This is not the court's job. Others need to step in.
Yeah, I think that's a good, fairly good final thoughts before we say bye-bye to this topic of State of Law 2026. I think, all the topics that have been touched by all the elite panelists today gives us this final conclusion that, it is a collective responsibility. There is, at some level, like we spoke about arbitration, that it's necessary for judicial interventions to reduce. At the same point of time, we spoke about an environmental law that how it's the need of the hour for the governments to think out of the box. And I think somewhere down the line, if 2026 is going to be far more responsive, the responsibility is equally, I think faced with all of us as well, that, how do we see it? We want to take it forward, and as collectively, what are we doing to either implement or take forward the law in the right direction as we want it to be? Because there are lots of new laws that are coming through, right?
Sorry, just to add to that, we certainly don't need more laws. We have a lot of them. What we need is better implementation.
Yeah, so better implementation, and I think maybe it's time for consolidating them, because we've spoken about in labor law that there have been consolidation. We've spoken about in criminal law that there is consolidation. There is, if you ask anyone about whoever practices on the original side, CPC, I mean, every suit gets entertained, God knows for what reason. And there are judges who are saying that they're not equipped under the powers of 711 to strike them down or nip it in the bud on day one. Why is that? Because the laws today are not, I mean, thanks to all the creative lawyers who are sitting here, we can create any suit from anywhere, right? And that's only happening because the laws of our country is actually so outdated. I think maybe it's time for consolidating and swifter implementation by all of us who are collectively direction.
And simplifying. You don't need complications. Matters are complicated as it is. Simplify the is what is needed.
So thank you all of you for listening to us, and thank you my elite panelists for contributing towards this discussion. Thanks.
Thank you so much, and thank you, Varun, for moderating that. Thank you. Thank you so much. चलिए आगे बढ़ते हुए, the next one, it is on the evolving face of white collar crime, the convergence of law, of forensics, and also of investigations. To share the views on the same, let's please welcome our panelists. Up first, Vivek Narayan Sharma, arguing counsel, Supreme Court of India. Joining him is Gurpan Singh, President, Iris Consulting. Joining them is Siddharth Batra, advocate on record, Supreme Court of India. Also joining them is Advocate Shiv Chopra, and this one by Das Bhalla Partner, ELP. Let's please welcome them. How many years? I'm here.
Good afternoon, everyone. I'm sure everybody is well rested after the lunch. So we'll try and make it a little engaging for you. Thank you, Legal, for having us here. We are going to be talking about white collar. I think the most spoken about topic in the era of today. Crime has been there since centuries, but the definition of crime has undergone a change over a period of time. When we spoke about the Harshad Mehta scam, it was a shocker because that nobody could expect a stock market scam, and then that led to SEBI. But now with the derivatives fraud that we are seeing in the IndusInd Bank portfolio of asset liability desk and the trading desk, we realize that the definition of crime keeps evolving. they say that, you know, criminals are smarter than than the police always, so they find new ways. And obviously, the previous session spoke a lot about on technology and AI. So with the advent of technology, there has been an increasing change in the way the crimes have been committed in a country like India, which is vastly populated and um, goes up to different remotest villages where these scams happen. Uh, it took us 110 plus years to understand that we need a change in our criminal law system. In 2023, our entire criminal law system changed when we brought in the Bharatiya Nyaya Sanhita and the Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Saksha Adhiniyam. We've picked up our laws from the British, but we've kept them very, very regressive and very, very old pattern. And um, we've realized that with time, crimes have become very localized. What may be a crime in Delhi may not be a locally occurring crime in UP, and with borders changing, the nature of crime also changes. In this background, we've had increasing dependence on forensic investigators also, not just for giving some credence to the source of investigation, but also to see how these technical aspects of a crime can be covered by people who are experts in the field. We are not living in an era today where lawyers are sitting and saying, oh, do this to find out what happened in a crime. We are in an era where we have forensic investigators, and they very sophisticatedly, in an internal investigation, find out what has happened, so that there is some paperwork that you can defend. Economic offenses, financial crime, all these are like unlike traditional crimes where you have a paper trail. So if you have the right machinery in place to investigate them, um, I think it's very easy to prove a crime like this, which is why um, we've had situations where even the government has now started relying on forensic investigators. In this background, I would like to put up a question to Shiv. How do you think white collar crime has gone beyond traditional crime, and what do you think has been the approach? How is the Supreme Court seeing white collar crime in line with the Sansera judgment?
Thank you. So, just to point out something, any criminal who gets caught is an accused. The criminal who doesn't get caught stays as a criminal. Now, if you see Sandesra's judgment, what we are seeing now is a recovery first process rather than punish first. In this case, you had 5,100 crores being recovered from banks, obviously voluntarily through a OTS settlement. Just a week later, same bench of the Supreme Court refused a OTS settlement to quash the criminal proceedings, where the bench held that since this emanates from PC Act offenses, therefore we will not intervene. But that was the exact same case with the Sandesra judgment as well. Sutherland defines an economic offense or a white collar offense as something that does not cause violent harm. What we are seeing ourselves evolve into a society today is multifaceted investigation by multifaceted organizations. When we had Harshad Mehta scam, it was only the CBI that was involved. Today, take for example Sandesra. You have Fugitive Economic Offenders Act. You have the CBI investigating the PC Act. You have the Enforcement Directorate investigating the PMLA. Three separate agencies. To add to that, you have the SFIO investigating the Companies Act. Four agencies. So if you say that, Shiv, it's a positive view to curtail 5 investigations, curb six complaint cases and 2 FIRs, you can say yes, very practical view. So therefore, recovery first and punish later. But if this view is not consistent, what we will not derive is some level of consistency. And consistency is the bedrock of any jurisprudence. So today, if Sandesra can get away with it, why can't another organization? Which is why I'd like to pose it back to the other panelists. Is there a possibility that now the Supreme Court can formulate guidelines beyond the state of Punjab judgment? That can it go and say that, yes, in these cases where if you come within a certain timeline, you can now go ahead for a caution?
As much as the Supreme Court may want to recover the money, first you have your ED, which wants something else. So they will come in even where they don't have a power. But uh, it's appalling for me to know that Supreme Court had to tell them in the Chhattisgarh excise scam that, there is no predicate offense and your proceedings are totally illegal, and it went on to a stage where they eventually, after getting a quashing from the Supreme Court, uh, registered an FIR, and then the state registered an FIR, constituted a sit, and then ED came in again. So it's pretty much like a premeditated thing. As a law firm lawyer, I feel that lawyers are very reluctant to touch the technical aspects. So Gary, what is your view on the role of a forensic expert in investigation of a financial fraud? Do you think that it's undergone a change in the last few years, or you think it's the same and you've always been there doing the same thing?
Thank you. Very relevant question. Sorry for the sore throat, but I'll try to be at least speak. And thankfully, this is not a singing competition, so I can survive. So we talked about technology. And if you look at technology, not only the courts are adopting technology, but your complete life has adopted technology. Your banks are your own phone. Your OTT is on your phone, your Zomatos, your everything is on phone. Everything has become technology. And the frauds are also linked to technology. So every next day, deciphering means of fraud, trailing the beneficiary, even after finding evidence, interpretation of evidence is going to become more complex. So that is the reality we're facing. So it has to be a time when more and more cooperative approach will start playing a role rather than the traditional style of, okay, here is a crime, here's evidence, it's over. So rather, it evolves every day up to an extent that even if you have something ready as an evidence, different lawyers can interpret it differently. So not only lawyers presenting it, your expert witness along with you to ensure it reaches the right result. I'll just give one case that we were working upon, B.R. Shetty in Dubai, 88,000 crore company being finally sold at 74 crores. And believe me, it was almost a situation that B.R. Shetty would have gone harmless. He had given affidavits, I've got no assets, I got nothing. It's all just a business failure. And when we came into play, we found his assets more than 400 crores. We found many other cash tracks which were plus 200 crores, and things started turning. So it was, if left to, without the forensic support, means this could have been just shown as a business failure. So complexity is increasing. The cooperation has to increase to really get criminals get the right result which they deserve.
Thank you for your views. I totally agree with you. Even in the Qatar food scam, if it wasn't a financial audit done by technical people, they actually hid the fact that they had no rice and no grain lying with them. So I do understand that getting deeper into this matters. Siddharth, what is the right stage for lawyers and investigators to collaborate on white collar cases? When do you think is the right time for you to get in touch with Gary if there's some investigation that you're foreseeing?
Thank you for your question, Dean. In fact, just before starting this discussion, I was discussing with Shiv as well. But I think the right answer to this is the moment something triggers in the company, I think the lawyer should set in, because as Gary was also saying, it's become so complex. So he was talking from the prosecution side as to unearth what has gone wrong. But there can be situations for lawyers or companies when you have to defend it properly as well. Sometimes something very small can spark into something very big for a company. So whether the company has to go for internal investigation, what the company has to do, whether an offense is made out, what has been done, what has triggered, what has set in, if there is any report of the forensic, how it is to be looked into, how the investigating agencies would look into, to what extent the agencies can come in, how they can step in, what are the materials they can look into, what can be destructive for the company, what can ultimately bring the company to a very difficult situation. All that has to be first gauged, I believe, at the level of a lawyer, because ultimately a lawyer is the one who's ultimately defending the company, the last action in the court. And of course, all the what agencies do are ultimately replied by the lawyers in the court in order to see it as to how it comes into the practical form, because whatever Gary may do or the forensics independently may do will be all in-house at the end of the day. But how it is seen in the court and what is the law on that, right? Like supposition, whether can you take something self-incriminating of a person, whether you can take the voice sample or not, voice samples can be taken, whether there is any evidence which is in such form. So my answer to you is that, of course, the moment something sets in, it is the lawyer who has to decide where the company has to go to.
Thank you, Siddharth. Since you said lawyers have to decide everything, Vivek, what's your view about summons being issued to Mr. Datar and senior counsel Mr. Pratap Venugopal, because both of them were playing very different roles when they were summoned. And we will obviously come to the suo motu judgment later. Supreme Court did stand up in a couple of cases, but then the suo motu judgment almost said it's like reinventing the wheel for company lawyers who are GCs. So what do you think is the learning from Pratap Venugopal's judgment? Because he was issued summons by ED for being an independent director in the Care Health investigation. And to the best of my knowledge, independent directors are always exempted. Even in a small 138 case, I've seen judges asking us, no, tell me the role of the independent director. Why are you coming after him? So summoning a senior advocate and an independent director and then a senior counsel for giving advice, overlooking the mandate of Article 20, Subclause 3 of the Constitution. What do you think? Where are we? Should lawyers really get into all this?
Well, this was clearly a face-off between ED and lawyers per se, and then Supreme Court rightly intervened there. The case, in fact, originated with regard to an opinion which was given by Mr. Dattar, and then at that time, Mr. Pratap Venugopal was advocate on record in Supreme Court, and then he was briefing Mr. Dattar. So it was employee stock option on the issue that was there with regard to the company in which Mr. Pratap Venugopal was also an independent director. So initially when, means prior to Mr. Pratap Venugopal was issued under Section 50 of PMLA to Mr. Dattar. Supreme Court AOR Association filed a resolution before the court that means first of all they sat together and then raised a voice against it, and then they gave a representation to the Supreme Court Chief Justice. But nothing had happened at that stage because by then ED had already withdrawn that notice. Subsequent after few days, Mr. Pratap Venugopal got the notice. And on that, again, the Supreme Court AOR Association raised voice, passed a resolution, and then represented before the court. But at the same time, Supreme Court took the suo motu cognizance. In the meantime, ED suo motu again withdrew the notice, but it also came with the explanation that it is in the capacity of being independent director of the company. So being independent director, you have nothing to do with the company. You are only overseeing, means a particular specific area domain. You have no control over the company. So anyone who is having the control over the company can be summoned under Section 50. Otherwise, unless there is direct evidence involving a person, he may be third party, maybe lawyer, then Section 132 of BSA comes into play. So if suppose I have no role to play in a possible crime which has been committed, I'm only an advisor, being a lawyer, then there is nothing that can be done against me. But if I'm participant in the crime, then in that case, I can be summoned. So the elements of summoning under Section 132 were completely missing in Supreme Court cognizance of this. So this had been a very serious matter, and it would have in coming time some implications also, because ED would also try to find some passage through the judgments that are being passed. So let us see how the situations evolve in coming time.
Absolutely. So how I see it, general counsels play an internal advisory role, and with the suo motu judgment, how do you think it's going to play out for GC Shiv? Because if I am a general counsel of a company and there's any conversation happening, there's no attorney-client privilege that I'm attracting, I would not want to be in that room. all know how ED acts, and why would I want to go to the ED office for questioning? So is it a step forward or is it a step back? Is it holding accountability of GCs? How is that different from a GC advising a company to an independent lawyer advising a company?
Very
So,
pertinent question.
we are just 4 minutes into it, so let's keep it very short.
Very pertinent question. I think Supreme Court has missed an issue here. The statutory framework of 132 versus 134 is very different. 132 confines itself to advocates, whereas 134 expands itself to legal professionals. Now, a GC is no less than an advocate because the only difference is he has one client versus us as independent counsels have multiple clients. He is upheld to the same level of ethics. It's just that he has given up his license to work for a company. The reasoning Supreme Court is given is that he is not amenable to the bar association, but is amenable to his master. Now, this concept is not there throughout the world. When we're advising clients across different jurisdictions, you will find that in the UK, a general counsel is protected, and the same in the USA. But now, if a general counsel travels to India on work and advising a multinational corporation, his privilege suddenly vanishes the moment he enters into Indian shores. This is a very key issue, and to get over this, companies have to employ what we call a GPP, a global privilege protocol, to decide under which protocol you can act and which protocol you can advise. Your advice has to be strictly legal. Where the GPP is not favorable, you must engage in external counsel, even to conduct a forensic audit, like Mr. Batra said earlier. That forensic audit, if you're getting conducted by your GC, and it has to be and you are summoned, you are obligated to inform them. Once that obligation is waived off, then I'm sorry, but you are stuck. So for that instance, get in an external counsel. So there are multiple steps you can take. Segregate your communication from GCs and segregate your communication from external counsels to see which communication will be privileged and which not. See which border jurisdiction protects you. If the jurisdiction of UK protects you, have your conversations outside India and make sure that there's a clear line of communication between you and your client, and you don't get these issues mixed up. And also, don't circulate legal opinion within your company. And very shortly, there will be an application that is going to be moved in the Supreme Court on this issue to expand the scope and to see how the Supreme Court will come back on the issue of 134.
Thank you, Shiv. Gary, do you think a strong coordination between the legal team and a forensics team is essential to a robust investigation? Have you had instances where there has been a disconnect between the legal team and the forensics team on anything concerning the investigation, whether it's the manner of collection of evidence or whether it's the way you are interpreting an evidence? And how do you navigate situations like these?
No, sure, thanks. Very relevant. But I want to take a step back even before I say the cooperation during an investigation. One thing, some of you must be doing it, but my complaint to legal community, all GCs and all external counsels, why you're not part of preventive actions? Why you're treated like a doctor, jab tak bimar nahi padenge, inke paas nahi jate? Why you're not creating that image that I can give you preventive actions as well? So that's first. And if they are not done, that's where the challenge of complexity increases. Coming to the next stage, which you said, if there is something wrong and investigation takes place, one of the biggest disconnect we find is because yes, we may have some internal legal counsel tell us how the evidence is presented, but one of the biggest disconnect again remains, no, I only need 3 answers. Who's the beneficiary? How it has happened? I said it is not a single step anymore. There are mule accounts, there are long chains, and a lot of time the beneficiary might be a Benami entity. So in that case, we had like you said, we had a very unique situation. When from a large mining company, thousands of crores were swindled, and there was no trace of where exactly the promoter has taken it. We looked at another way, and we found a lot of relatives were holding these assets, which were land banks, which were future going to be raised as townships and things like those. So when we say, here are the 2 situations, they said, no, it doesn't help me. I said, why don't you put a case on all those guys who holding 1,000 crore of land and never filed income tax? Take that action. they will stand up and say, no, this is not mine. So a lot of time, the innovation on both sides can work. So that's how possibly we need to look at it.
I think, Gary, because prevention doesn't happen because it's managed internally, and with what Shiva said, I think GCs are going to step away from it. It's going to help the external lawyers. But Siddharth, your closing remarks on do we require any, because Gary raised a very pertinent issue, do we require any ethical or professional boundaries that need to be drawn between counsels and investigators?
You see, it's very interesting. It's a big list once you start reading it. In fact, I read it for the first time, Vivek, when I gave the AO exam. It's actually too stringent. The Britishers have left. Of course, we follow the common law system, but if you read the Advocates Act and the Bar Council rules, in fact, there is a limit on how big can your board be as well. The board that you put outside your office has to be this size, otherwise it will be a misconduct. You can't write yourself as an advocate, Supreme Court of India. That's a misconduct. You can't write like that. So it's very stringent, if you ask me. And of course, when you're entering into a company or a client which is going investigation or would be investigated later on, something goes left and right, where, in fact, again, I was discussing with Shiv, you tell somebody to delete your data, right? And that comes on the record. There, of course, the trouble brews up, and that can be a difficult situation. So all in all, of course, I believe for me and for all the youngsters, we must read what is there in the Act. The Act and the Bar Council rules, in fact, give us a very little window on what our advice has to be and how it has to be.
Thank you, Siddharth. Since the time is up, I'm going to put my last question to Vivek for his closing remarks. Vivek, I don't think involving lawyers, the intention is to name the. It's an element of frustration on how lawyers advise clients to deal with investigations. Do you think summoning lawyers is a veiled threat to lawyers to not act in a manner and directly impinge on a party's right against self-incrimination? Because if I am compelled to appear and I have to make a statement on what I discussed with my client, obviously the Supreme Court said you can't do that. Someday, if something like this, or if it doesn't happen, what is the intent of the investigating agencies? Is it to impinge on a party's right against self-incrimination, or is it threatening the lawyers to step away? What do you think is the larger objective behind it?
The underlying savior for a client is the lawyer. So when the lawyer is trying to save, and if you attack that lawyer, so then you have the entire gamut open before you. So that might have been the intent, but be that it as it may, what is the frustration within the investigating authority that I see? Today, the investigations which are roaming around, we are still doing it, means we are lack of forensic professionals. All the investigations which are required to be looked into in today's scenario, we need at least 10x experts in the investigating authorities. Those people are just not there. So there is a deep frustration within the investigating authorities that they are not able to, find proper ways and methods as to how to do, and then there are time lagging. And in the court, they have enough power to arrest anyone and not get released, and the courts are also not releasing them. So that power combining with that frustration, bringing some kind of vacuum in between where the lawyers come in. And that's, maybe the future targets. So what is required, of course, you need to have, whenever you are with the client calls and with the informing the client about any decision making pertaining to any opinion, pertaining to any question. So you must need to codify so that you could, provide your innocence, because that is that one thing which has opened today could be in multiple in coming time. So be careful. And of course, in coming time, because forensics would be a requirement, to all of you would need to upgrade your talent with regard to how to read the forensic information, reports and all.
Thank you, Vivek. Thank you, everyone. That was an interesting session. The panel wanted me to ask questions, but I think that we just heard a bell, so we'll wind up now.
That will legitimately
Thank
stand
you,
here. I'm very
thank
sorry
you,
for that.
thank you.
But thank you so much. And thank you, ma'am, for moderating it as well. Please. Thank you so much, Vivek sir, Pravan sir, thank you. Siddharth and Shiv as well, thank you. Surely, quickly moving ahead with the next one. This is the GC Law Firm Reset. New expectations, new economics, and also new alliances. And to share the views on the same, let's please welcome our panelist, CV Raghu, Managing Partner, CVR Law Partners LLP. Joining them is Ravi Vaswani, Founder, Zentrum Law Partner. Also joining them is Amit Gupta, Vice President, Legal and Land Acquisition, Purva Green Power. And this one will be chaired by Pranav Mehra, Senior Director, Legal, Freshworks. Supriya, the panelists, can we invite them? They're outside in the discussions. After this, we will move towards the climate bit, very important. Looking at the state of Delhi, which is on ESG statements on trial. After that is the last one, which is on deal making across sectors, less from 2025. It's a wrap up types. And then, of course, we'll start the 40 under 40 word ceremony as well. Gentlemen, please, aye.
We never thought that we'll be on stage so soon.
Thank you. Good evening, everyone. I see that energy boomed. Would you like to take a 2-minute break, come back from whatever you want to do outside? But this is going to be a very high energy panel, so I want you to be in very high energy as well. If you want to take a 2-minute break and come back, I am up for it. We'll drink our coffees because we wanted to drink something before we sat here. Or should we start right now? Yes. So since we are very short of time, we have the collective experience of this panel is 100 plus years. We're looking at you, sir, with that much experience, and then we kind of follow. Yes, right. So more than 100 years, and we've all been in a law firm. We've all been GCs. And there's a very different expectation when you're a GC versus when you're a law firm partner. There's this a revenue model that a law firm has, and there's a budget model that the GC has, right? And then there is an expectation setting that sometimes happens, sometimes doesn't happen, right? And therefore, it will either make or break the relationship. But relationships are also built on trust. Relationships are also built on years of experience in the industry. Relationships go beyond the money part of what we call the fees, right? So there is, the panel kind of speaks about new expectations, new economics, and kind of new ground forward, right? And therefore, what would be more relevant for this panel is to kind of deliver upon what they think an ideal 2026 could be from expectation setting, what could be a way forward for
law firms, both Indian and global, to work with the Indian GCs, since we are so price conscious? And what would they want the best, given there is AI, there is legal tech, there is a lot of specialist experience, right? So we're gonna be asking all that. So this is gonna be a very high powered session that ways. I don't think the panel needs any introduction, so I'm not gonna introduce. The names are out there behind, but I'm gonna ask the first question with random order every time, so that the speakers are on their toes every time. Uh, so since you're just sitting here, when you started versus what you see now, right? There's a lot of young blood that's coming. There's a lot of new tools that have come in. There is a lot of new legal, there's a lot of new laws that have also come in, right? A lot of them, and a lot of them have revised, and a lot of them have also been out. What expectations do you have as a GC from a law firm that can guide you well in the year ahead?
Thanks, Business World, for inviting us for this panel. How many in the audience are from law firms? It's a very small minority. So, just answering your question, life has undergone change, and it will. Change is the only reality. If I go back to when we started, we started with, we used to have one secretary in a team of 8 people, and there used to be a manual typewriter. But the competence of the typist used to be so good that he never used to take shorthand. He used to say, "You dictate, I'll type." And he would never make a mistake. And that's something that I used to wonder, how would he type 30 pages and just take out the printout and say, "Read it," and there would not be a single spelling mistake. And lo and behold, it used to be. But life has moved on from there on. Net came in, we got into computers, we got into all of that. You know, the first time I remember when I sent a document on the online, that was a big success, you know, because documents either you would be couriered and you send to, or you fax document. And the first time you sent out electronic documents. So life has changed. The quality of people who are in-house has changed. The quality of counsels who are delivering law has changed. No, there's been a big shift. To give you an example, in the early 90s, the big law firm in Delhi used to be J.B. Dadachandji, right? I don't know how many of you would have even seen an office of J.B. Dadachandji. So the simple rule is to be, in a day, if you have not been to J.B. Dadachandji once, you've not been to the temple. And that's the way people used to say. Over a period of time now, you see more law firms in the client's office than clients getting into the law's office, right? So that's the shift that has happened. And the shift is because not the corporate law per se has undergone a lot of change. You know, I am not sure. I think the first big corporate transaction that by and large happened was Hindustan Lever taking over Tomco. Yeah, that was the first. And thankfully, yours truly was a part of that team. And that's how I got inclined towards the corporate practice, right? And confidentiality those days used to mean that you were all tied up into one room. We Hindustan Lever used to have a guest house in India International Center, 4 rooms. So the main door used to be locked. We were inside there for 4 days, and we finished the transaction. The speed, it was 24 hours. You had nothing else to do. There's only one landline, and the landline only was meant for emergency use. Or the boss would use the landline, calling the lawyers or anybody. You, from a confidentiality point of view, you are not allowed to touch the phone. So from there, life moved on. And I think the bit significant difference, or let me make it a little more energizing to conversation. I think the topic was reset, right? Reset. I think it's important for uh, everyone to realize that these days in-house is no more in-house. It's actually a small law firm inside an corporation. It is. And if your bosses or if you as GCs are not doing it, then you are behind. With internet, with AI, with all of that, you have access to as much of that as much as the law firms have. Now, does that mean law firms are redundant? No. It's a complementary. Both are complementary. Earlier, the feeling used to be law firms are at a higher pedestal. You in-house lawyers are at a lower pedestal. वो ज्ञान देते, आप ज्ञान लेते हो, आते हो, काम करते हो. The system has changed. Today's promoters is not interested to, if you go and tell the promoter that I've got this opinion from Sam, Cam, AZP or Luthra, here's the opinion. He says, what's your opinion? That's where the butt stops. And the moment the accountability comes there, so you and the law firm are more or less on the same page. So both have to realize that. If that realization, so therefore I say it's actually reset for law firms more than the reset, because the in-house counsel that the departments are already on a roll. If they don't do, you know, why do you see so many companies hiring in-house people? That's only because that's the only way that the in-house corporate world will move. And just being fair to the law firm, they have also started realizing that there is some headwinds, you know, or there is some space that they used to occupy is being occupied by this. So therefore, they have to be relevant, you have to be relevant for the success of the system.
We have limited time. Amit sir, why don't you give a few remarks on where do you think we are today versus where we were 5 years ago, and what is the expectation that we would have from tomorrow? Just brief would probably be good.
Thank you. Thank you, BW Legal, Pranav, and Vinay. I think after opening of a economy, when the investment started flowing, the role of a GC has undergone a significant change, right? He is not just looked as a, legal gatekeeper, right? He is now considered as a strategic business leader in the organization. GC, who is actually considered to be a law expert, is now, expected to be a business expert, contribute in the strategic business decisions. Industry knowledge is very, very important. I mean, earlier, we used to think that, a particular general counsel, actually, if he knows the law, he can be successful everywhere, right? In any organization, because, your major role is, defining, interpreting law. But now the role has changed, right? You have to be a business leader. You have to be thorough in the industry knowledge, right? Regulatory affairs, governance, and also, you should assess, the risk involved in the business and what can go wrong and what are the solutions that you can put up. As the role of the GC is changing from the, codes, litigation and contracts to the boardrooms, right? The reset which is required between the GCs and the law firm is also changing. Expectations are different, as Mr. Raghu said. Time has changed, and in-house is no more in-house, right? He is someone who has to advise the board on different aspects, not just related to law. As we the expectation of the board is that general counsel should be an industry expert. The same expectation goes for a law firm as well, right? It's not only limited to law. You have to be clear on the regulatory affairs, the what is going on in the industry, what is the further planning in that particular industry. If we are working on a contract and there is a policy regime which is expected maybe 2 years, 3 years down the line, and if some adverse policy regime come, entire plan of the organization will go for a toss. So there is an immediate need that, we have to be vigilant on the regulatory affairs, what is happening in the industry, what is industry trend, and what is the policy of the government down the line 3 years, 5 years, and 10 years. So it's not just related to your bare ads, right? It is basically, you have to look from a long-term perspective that we are actually someone who would ultimately be responsible to contribute to the bottom line by preserving the value. So this is the expectation that has not only restricted to GC, but also goes to the law firm. Now, law firms, if you look at, there is a shift. I have seen in the recent past, the partners are moving. There is a high attrition. The challenge with the law firm is to retain the partners and, people. Now, this is happening because everyone is in a race to build a team who can, assist the GCs and the clients in such a manner that they can give a one-stop solution, right? And this is what is expected because, today, if you're going, I mean, there were times when you are going to a law firm for a litigation, for a contract support to a different law firm, for a specific kind of a litigation, you go to a renowned, counsel. Now the things are changing. We need a strategic business partner in a law firm. So we need a complete support. The different kind of expert can come on a table, and we finalize a particular business decision with precision.
Well said. I think from typewriters to keyboards to AI, from a journalist to about specialist in terms of advisory, right? Ravi, where do you think we will be heading next year? Any two bits, any interesting points that you're seeing as a trend?
Firstly, thank you, Pranam, for the opportunity. To me, what really matters the most in any corporate setup is the speed. And that's really a reason why, there is a lot of focus on hiring in-house specialists, right? There's a lot of pressure from investors, from the boardroom, on Cs, on the in-house legal team to quickly close the transactions, close the deals, and hence there's a lot of focus on, increasing your team size, getting the right set of people, getting an experienced set of people who will continuously add the value, bring the efficiency in the system. And to me, what will really drive the future is how quickly you're able to deliver to your GCs. Now it depends on you as an organization, what sort of tools you use, what sort of people you have. Do you have got the specialists within the firm? You have got the IT system so that you are able to quickly deliver what is really expected from you. And that also comes from a very clear communication with the in-house teams. You need to have a far deeper relationship with them to understand, what are the intricacies involved, what sort of people are involved, what are their aspirations, what are their expectations. You'll have to go over and beyond the law to understand, the finer nuances so as to ultimately deliver what is really expected, right? No one is really willing to pay for the inefficiencies, right? There would be pressure on the firms, sorry, there would be pressure on the in-house teams to cut down their budgets, right? And which has always been the case. And hence, to me, the most important thing is efficiency and speed. That is one thing these are two things that you need to focus a lot as a law firm.
Right. So what I gather from this first question of mine, the expectation setting is there is a need for the GC who is now a strategic advisor to also have a support from a law firm partner who can also advise very strategically, right? Because if you're only dealing with litigation and you can't kind of give support to a GC sitting in a boardroom about 8 hours in a row deciding on what a 2026 financial year plan should be, and that too in October last year, then you're really not adding any value, except for the fact when a litigation comes, I will probably consult with you, or when there's a contract which my team can't handle, then I'll outsource you. So there is a need for that, and that comes with a lot of experience of handling how a board will probably respond, what is the next best option that we can give, and where is the middle ground that we will have to hold, right? That's one. That's what he said. And then you're saying that there is also the expectation that we also want specialists, right? 2026 or maybe years from now will be an area where specialists will have more role than a journalist, because in-house is more so a journalist approach, because you don't know what is coming to your table, right? And therefore the way the spend has to be will be on more specialist related. So, that's a situation wherein a law firm will think, okay, if I can be a specialist, then I can't be advising a board. And if I'm advising the board, then I need to know everything and I can't be a specialist. And it gives very confusing message to a law firm, whether I become the journalist in 30 years and then I advise the board, or I can become an independent director, or whether I keep going with the telecom law or competition law or maritime law, right? So that's a question I think the law firms will have to answer for themselves as to where they think their firm has an expertise on, and where do they think the journey will take them to. And then now coming on to, our area for this panel is also the new economics, which really means what is it that brings a law firm to the table with a GC and then add value, or what kind of things that do not add any value and we let go of that firm, either as a firm which has been there with our company, or as a new firm that I think, okay, does not add value. So the hourly billing system is now almost redundant, right? And now there's a blended rate that came in between. Now with AI and legal tech, where do you think, and I will start from you, Ravi, where do you think now we are approaching that?
To me, as I said earlier, the most important thing is a very clear, candid communication conversation with the GCs, right? You can have a very candid conversations as to, what are their expectations, what would really, sail through in the system. And more often than not, there are internal parameters as to how they would want to make payments to external vendors. And that's how they also look, law firms as. There would be vendors, from the finance side, from the marketing sides, they would have budgets as to, what are the pricing structures they can internally get to. And for that matter, you need to have a clear communications, work out ways which could be innovative. For example, we are focusing a lot on retailership models. These are fixed price retailership models, and we let them sort of cherry pick where they want to use our services, right? So law firms now need to come up, especially the young lawyers, the young law firms need to come up with something innovative which would really work with systems, especially with the mid-sized companies, startups. There are a lot of, I believe there's a lot of space where you can enter into, and it's just that you need to be a little competitive in the pricing. There are problems with the hourly rates, and large firms have been able to, sail through with that. But there would be a challenge for the young firms to, go with that. Hence, fixed model or some innovative model, would really work. We are also focusing a lot on value-added services, right? For example, if you can arrange sort of, trainings for the employees, be it on the POSH, be it on the corporate frauds, the other AI aspects, data privacy aspects. And if these are the value-added services that you can offer to the GCs or to the in-house teams or to the other business teams of organizations, they really appreciate that sort of an effort. As firms, I think you need to be continuously innovate in your offerings and the pricing structures that you have.
Amit sir, what do you think? Where is this new economics going to be settling in from whatever you've seen in the last few years?
So, Pranav, I remember the days when, I started working as a GC in the organization. Those were the time when we talk about the cost effectiveness and relationships, right? If you like the working of a particular partner, you stick to a law firm, right? Time has recently, has undergone a dramatic change. You don't know, whether a particular partner will stay in the organization for years or till your deal completion. So you have to be careful, right? So what you actually need has to be communicated to the law firm that this is the expectation that we want to meet. I mean, certainly, cost effectiveness has been taken over by efficiency, I would say. And the secondly is the risk mitigation, because the deal size has gone up significantly. You can't afford to have, something missed out, in your contracts, in your litigation, in your deal. That's very, very important. I won't mind paying little higher, right? But at the same time, the quality is something which cannot be compromised, right? Second thing is that you have to go, little differently, right? Not restricting yourself to the legal aspect, but kind of a advisory where a risk mitigation can be planned for a long term, right? So the expectation is based on the solutions being offered by a law firm, the reliability, and how, when a GC needs a particular deal to be closed in 15 days' time, you can't say that, it would require months' time or I don't have a sufficient manpower. I need a back-end reliability on a law firm that if the deal need to be closed in a time-bound manner, they are behind me to, make everything possible so that the client do not suffer. I think those are the things which are gaining importance this time with the GC and law firm relationship.
I think one of the things that have happened for a frequent usage of different firms for the same topic is because the quality has improved significantly and there's a baseline to that quality. Earlier, it was either very bad quality or a good quality. Now everybody produces very good, sufficiently good quality, and the only discussion is the price point and the availability of the partner in question, because he comes for a pitch and then but does not work in any of the deals. It is a junior. So I am paying basically for a junior while I was supposed to have partner on that deal with the price point, right? So Raghu, sir, between a price predictability, what a GC wants for the entire year versus the unlimited budget, what a law firm really would want from a GC, where do you think the middle ground will happen?
The middle ground for me happened many, many years back. So, in the sense that, first and foremost, you are not married to any law firm. That's the first big mistake in-house lawyers make. You're not married to any law firm. Second thing is that you create this huge pool of lawyers who are either litigation lawyers, specialist lawyers, whatever, and you pick the phone and ask the question to the right lawyer. And that is where, just contrary to the way law firms spend a lot of time doing business development, as an in-house counsel, you're supposed to find out and learn who are the lawyers who are good, competent. Like I remember when I was in Mother, one fine day we decided to get into aviation and defense. Market is absolutely, but you had to find who in the market had done aviation and defense. And now you don't ask law firms, everybody will say we can do it. In fact, how many of you have seen a law firm's brochure? It has started from animal husbandry to everything in the system, right? Now, that is the law firms who write that, I completely put the profile to the side, first. Secondly, one thing that I think, just being fair, please realize the litigation environment in this country is going from bad to worse. Companies don't have the patience. So there's a lot of pressure on in-house counsels to reduce litigation. The companies don't mind spending money on corporate transactions, but they don't want to spend money on litigation. In fact, and I say this with a lot of pride all the while, in Motherson during my tenure I brought down the litigation to zero. Zero litigation for a company That is a $26 billion company working across the globe. The only litigation that we had was people who had filed against us. We did not litigate. So, there is an orientation that'll go. Secondly, when you have transactions, how do you select counsels? I think that's very fundamental because pricing is always a factor of, first when the transaction falls into your lap, you know how big, what's the scale of the transaction. It's very important for in-house lawyers, because most of you are here are in-house, to write the scope of the work that you are expecting the external counsel to do. We don't define the scope. If you don't define the scope, the law firms define it. That's where is the problem. So if you define the scope, and the way I've done this for the last 15 years, if there's a transaction on my table, I will spend at least 3 to 4 days drafting the scope. I'll first ask my junior to draft it, then I will review it, then, because just to be sure that, and in that process, you always challenge yourself, what out of the scope can be done in-house? What is it that I'm using the law firm for? That is very important, because cost is, you can't just go to the law firm and say, you're too exorbitant. They have their costs. They will give you 10 arguments and, you end up, and you don't want to be a bad fish in a big ocean, right? Every law firm fits to every other law firm. But you have to be very firm with what you're doing. And the reality today is that if a transaction happens, most of the things that don't have a legal impact are all done in-house. Starting from, I think somebody was saying, I'm not dependent whether the counsel is still there in the law firm or not, because those days are gone. I drive the transaction. The transaction is my transaction. The transaction is not a law firm's transaction. Those days, I think these are paradigm shifts that have happened, and people who have accepted it faster are in a better position. And once you draft the scope, you send it to the 4 or 5 law firms and ask them for a fee quote. Obviously, there'll be 1 or 2 discussions. In the time. And you will be surprised. You'll be really surprised that starting from, I've got quotes on the same transaction, same scope, from $100,000 to $1 million.
Depending on who the client was.
No, they don't know the client. We were the client. So the law firm, gone are the days when the law firms should look at my balance sheet and decide what fee they're going to charge. They must charge on the basis of value that they bring to the table, not my balance sheet. I made a 5,000 crore profit annually. Doesn't mean that I'm going to pay that to the law firm. Then why am I working? I must be an idiot, right? That apart. Then, once you have zeroed in on the fee part, you have to also be very careful who's the partner working and what is the team working. The competence of the partner and the team. It may be the same law firm, but you may not go for every transaction to the same partner. And I've seen there are smaller law firms also, very competent partners you can do. Like I'll give you an example, NCDs. Because in Mercer we used to do a lot of debt transactions. After the first 2 years, for all my NCD transactions, I did it in-house. I did not engage any law firm. The bank used to engage a law firm, whose fee also we used to pay. But I would not engage a law firm from my side at all. Because after the first 2 transactions, in-house we had developed so much of expertise, and we were reading the same FERA laws and FEMA laws. Right? End of the story. Why do you need a law firm? This is not getting filed before any court. This is not getting, you are doing a transaction. It's a bilateral transaction between the bank and you for the NCDs.
Raghu sir, you realize that you're a law firm right now, right?
I have started, but that is, I'll tell you, I'll be honest. I've started a law firm for all my retainer billing, only for my billing pursuit. I'm not in competition with any law firm. I don't solicit business. I have not been to any client's office. I have not, if I have asked for business from any one of you, please tell me.
I don't remember, but sir,
I am there because people ask me to do legal work. From tax reasons, it's better to be in a law firm. They didn't have a personal account. Therefore, that law firm.
I totally agree.
You will not see any pitch from my side ever.
Two of the things that you said, sir, I think one, which we will collectively agree as the audience in this room plus the panel is how much important is the scoping exercise, right? Without which it is truly a make or break, and a bad scoping can actually lead to a frustrated output, right? Because you do not know, you said, you should do the entire transaction, not knowing that he also had to do secretarial work of filing that or a regulatory work. And then he says, no, I was not people. And then you're stuck with the timeline that is going on. So scoping, I think anybody who's not done yet, please, 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 scoping is the best utilization of time. Sit with a GC, sit with your seniors, because if you don't do that particularly well, when you are learning, it is going to impact how you become, because scoping is the next part of the pitching. Pitching without a scoping exercise does not give you any work. If you do not know scoping, then pitching, you can't do pitch. So for any law firm, BD person, that's the most important. I think second, I think you said, sir, the competency that is, and while I agree to the fact that you're not married to a law firm partner, but these days what we've seen is the partners go along with the juniors to the new firm. So the entire department has moved. And therefore your dependency on the firm actually is totally dependent on the new partner who's come in as a replacement or the going on partner. So that's a difficulty when you deal with.
Go to another law firm. Go to another law firm. I'm simple. You know, when the person moves from one law firm to another, he himself is settling down in the new law firm. You and again with no malice. And the split happened in one of the large law firms. For about 2 years, I neither went to A or B. Because they were settling and there was a massive talent hunt that was happening in the market. You never knew who was with this firm or that firm, because after the split, they were just trying to pull. And this has happened 2 or 3 times in the market. So during that period, that's the cool-off period for you. You must get the early signs and back off. You must go to stability, because at the end of the day, these partners and managing partners can fight for talent, but you don't want your transaction to get screwed in the process. Sorry about that.
So apologies needed. Every one of us has a varying answer to that, right? Some people actually depend upon what the partner brings instead of the branding. And some people go for the branding because your transaction is too big to be dependent on one. So there is no right or wrong answer to this. But move on. I mean, we've had a healthy discussion on the partnership model with the GC. But there is this assumption that the partner, the law firm, is the only supplier to the vendor. Sorry, and we are the buyer. As a GC, I'm the buyer and you're the only supplier. But I think I do not agree with that. Usually, what I've seen is the law firm partner will also call up to say, you know what, I have this new thing coming up and I need industry experience. Can you just tell me what should I be looking at when I'm pitching? But that is never stated in a forum, and a lot of people do not know that the GC is also training the law firm guy to do his best, because he's also invested. If I do not train you well, then you do not deliver the best. Ravi, what do you think? Have you seen this?
No, that's very right, Pranav. Coming from in-house background, I remember when we used to engage firms, we were very particular of which partner we want to work with. And the reason was very clear, because we had that comfort with that particular partner. He has been with us for a longest time, right? He understands how we think, how we operate, how we make decisions. So we would not really, back then we would not prefer a random partner from a largest firm. We would prefer a perfect partner, who is aligned with our culture, with our thought process, and who helps us actually close the transaction. Right. So yeah, these are the important considerations. And now as well, as now seeing from this side of the table, you have to invest in the relationship. You start something, from the scratch. You develop that expertise. You develop that comfort, that trust with the GC, and then it works your way.
Pranav, this is absolutely right. You know, the rich experience GC comes with, while doing a particular transaction, they go deep into it. So there are practical aspect to it. Sometimes, law firm can guide you on legal aspect, but not the practical aspect, right? So as a GC, we used to receive a lot of those queries from law firms, partners who have years of experience that this is a particular practical situation. What do we do now? Because this can be addressed 50% legally, but there are other element, human element, which are required. That gap definitely can be bridged over an experience when you are actually doing the transaction for you, right? So yes, the role of GC is increasingly being recognized by law firms as partners also. So, there are no surprises that, you are consulted on numerous deals which law firms are doing these days.
If you allow me one, today the GCs not only are doing India work, most of the GCs of the large companies. So by default, the GCs are getting exposed to a lot of international laws. In the process, a lot of international best practices come into that law. And that is where they are also advising of that when you pitch, you could pitch this way and you could do pitch that way. Because and so important, and I didn't repeat, uh, you must always believe that you are holding the transaction. The moment that shift happens, your knowledge level has to be, if not higher, at par with the senior partner who's supporting it.
True.
If that doesn't happen, then you are still catching up and you are not leading from the front.
That's absolutely correct, sir. If you're not someone who can guide an outside counsel, then you are getting guided, and in turn, you're not as relevant as you thought you would be. So better to be fully educated before you start the transaction. Be very aware of what an accounting assumption would be, what would be a tax presumption would be, how is the treasury going to pay, when are the deadlines of when the payment cannot be, whether this is a geopolitics that will happen. You need to know it all. This is just not legal paperwork. This is not two parties signing to the contract and says everything is gonna go well. The entire transaction takes much longer, and there's a staggered payment system. There are people, there's headcount, a lot of people will leave in between. You need to be very ready that this transaction is not going to be just two people, one is the GC and the law firm, but your entire team and the extended relationship with you will also come in play. People will come and leave, but sometimes that derails the transaction. That is when it turns sour. But one of the things, Raghu sir, that you said, and we've not discussed at length at this forum, is the competition between the Indian law firm and the international law firm for the same deal, and how would you assess that if it's not for the money that is being charged? What are the characteristics that you will probably look into it while as an Indian firm or international firm on the same transactions that you want to do with the that you have?
See, you would only use an international law firm if your transaction is multi-jurisdiction. You will not use it for an India transaction. That part is completely ruled till the time foreign law firms come into India, right? But you don't have to be. You have to apply the same levels of ruthlessness, whether it's an Indian law firm or foreign law firm. Let's stop being, very benign to foreign law firms and very ruthless to Indian law firms just because you have access to them. I will give you a small example. I did a transaction with one of the large law firms. The bill came, it was 940,000, 48,000. I will not tell you the currency, you'll guess. But when I sat with the managing partner there and I said, I'm not disputing your bill, but I need to understand how you arrived at this bill. I never told him that I'll not pay. And I went line by line. Trust you me. What I paid him was 445,000. Nearly $500,000 less than what they had billed. So those days, and I might sound very parochial, those days of Western domination versus Indian domination, everybody, if you are expecting the Indian law firms up there, you also have to bring down this high horse foreign law firms. And I say this, I said this in International Bar Association, so people like me for that, people hate me for that. The question is that economy decides which way business is flowing. And therefore, whoever flows with the tide is the guy who wins, right? In the 70s, the business never used to come to India. We used to follow. We used to follow the Western world. Today, the business is coming. We'll take advantage of that. We ought to be really stupid not to take advantage of that. Having said that, I'm not going to pay you because you are a particular
Magic circle.
a magic circle law firm. That those days, and I say the same thing to our bid 4 or bid 5 in law. I'm not going to pay you because of your brand. Do you give me a discount because of my brand? Because you are the council for, I used to work for livers. You are the council for Hindustan livers, you give me a discount. Do you do that? But you look at my balance sheet and you bill me. That's not the way. And for this, and I again say this with complete humility, there must be courage of conviction of the in-house councils that their competence, they are well invested into their competence. If you believe you are a postman, you'll always be a postman. If you believe you are the general counsel and you are the guy who drives the business of the company, that conviction must be there. That conviction can only come when you can clearly advise your management that this is the position of law. However, if you want from board perspective and opinion, I'll get it from this law firm. But I know the position. The position is this. And I've done that.
100%, 100%, sir. Amit sir, any distinct characteristics that you probably would assess India versus international when procuring services?
See, if the transaction is multi-territory, obviously you have no other option but to have the international lawyers. But at the same time, I think I would evaluate more on efficiency, competitiveness, and the quality of work. I still have a feeler that domestic law firms knows your territory better. They know the policy framework, they know the law better, and how it is implemented. So unless law firm compete and show that they can perform better, I think it's only the time that will tell who would be ranked better by the GCs in the coming time.
I think anybody who knows stamp duty better, I think wins at the end of the day, right? So international law firms have find it a little challenging to read our stamp duty act and kind of understand. They always will rely on an Indian counterpart, whereas an Indian counterpart will actually know if you're in default and the duty at the time was 3% and now you're paying penalty of 400%, which rate to apply. And I think that is a characteristic that an Indian lawyer of Indian origin or has studied Indian law will know better than a competing international lawyer until unless her entire work revolves around stamp duty.
So I'll give you an example, Pranav. I was dealing with one of the Chinese lawyer, and I wanted an opinion on a very small issue. I mean, he was confused, and he gave me answer in 3 days, and that was conflicting, right? And I asked that I wanted a clear answer. So he said Indian law is subject to different interpretations. So I think with this kind of understanding, it's difficult. They will definitely be more aware of how the Indian courts interpret law, and they have to align themselves based on that. Then only the reliability and would increase in Indian space.
But Indian law is subject to who interprets, right? Whether the advocate general or the judiciary or the lawyer who's arguing. So we'll have to give, there's no one interpretation until unless the judiciary settles it down. for everyone, and which is the Supreme.
Right, in this particular case, like, we appointed one of the prominent law firm, and whatever opinion we got from them, it was firm and it worked.
Gentlemen, quickly, we just have 2 minutes left before I'm pressurized for the other panel to start. Ravi, I'll start with you. One thing a GC or a law firm partner should start and stop doing. What he should start and what he should stop. And if you want time, you can handle the mic.
I think GC should have that mindset that your external counsel is like your extended team member. GC needs to be absolutely transparent with the external counsel. And likewise, external counsel should have a very clear communications with the GCs so that they understand, what are the driving forces, what are the real incentives and motivations.
Well said.
I would say a DC should start realizing that the entire ownership, of a transaction, litigation lies with him, right? And he should be, he's sitting in a driver's seat. So, I mean, you should align the law firm, in such a manner that, you preserve your wealth. As a law firm, they should understand that they are an extended team to to a GC, and they should be ready to support, whenever there is a need, and if timeline is an issue, if cost effectiveness is an issue, they should be ready and prompt in resolving it.
One thing that the GC or a law firm should start doing and stop doing.
Law firm or GC?
Whatever stand you want to take.
I represent general counsels and I can say that's what. Increase your competence too. Increase your competence. Don't, because you have access to the same books law firms have. Spend time, energy, reading. Because books should be the first love for all lawyers, and why not for the in-house? Second, at least I have practiced that. Don't seek an opinion till the time you know yourself what the opinion should be. I can repeat that. Don't seek an opinion till the time you yourself know what the opinion should be, which means your competence level, you are more in a probing mode when you go to a law firm, but you know actually what should be the opinion. That is when you have a very healthy debate with a law firm. Otherwise, in the past, what used to happen? Law firms will tell you, you take it as gospel truth and come back and implement in the office. I know, difficult statement. It'll take you time, but that should be your aspirational position.
Well said, Raghu sir, and a huge round of applause for the panel. It's been a very healthy discussions. Like I said, like this panel has 100+ years of experience sitting here. And really, when they speak, there was no preparation, there were no advanced questions. I made sure that I do not give them, and everything that's being said is actually on the foot. So huge round of applause once again. Thank you.
And thank you, Pranav, sir, for moderating that. I'm very sorry with the buzz on times. That's more difficult to do than to host. Thank you. Oh, one more. The other camera as well. Thank you. Thank you so much. Pranav, sir, we didn't give you time there. We'll give you 10 more minutes in the next one. The next one, it was supposed to be a panel discussion, but it is now a fireside chat on ESG statements on trial, climate litigation, greenwashing, and also corporate accountability. And please join me in welcoming on stage Umang Pathak, founder, ESG advisor, along with Pranav Mehra, senior director of Legal Freshworks, to join us on the stage. Let's welcome them with your applause, everybody. क्लाइमेट की बातें हैं, दिल्ली को इतनी ज़रूरत है इस डिस्कशन की, अगर आप ताली ना बजाएं तो कैसे मालूम पड़ेगा उनको भी कि टू डिस्कस. थैंक यू.
I think we're taking a 5-minute break because nobody is there in the audience. Should we wait for a few minutes? Yeah. So I've been retained for this session. You'll have to hear my chatter once again, and apologies if you did not like me, but I'm not abusing my dominance. I'm just being forced to be here. So please excuse me. And this topic is not something I'm an expert at, so I'm gonna rely on Umang very, very heavily on what she says. I may not have a counter, but we'll open the fireside chat for some Q&A. In case if you have any questions not relating to Delhi's AQI or the government stand on how they want to do climate change, but everything apart from that will be very welcome. You missed the most important panel, which we just concluded, Vaibhav. So Weber, we had a point in our last panel wherein we said the assumed supplier is not always the law firm, and the assumed buyer is always not the GC. It happens the other way also. A GC also guides the law firm partner in many ways in making him more intelligent and knowledgeable about how he could pitch to another company in the same industry, right? And which is not mentioned in any of the discussions, which is very understated because a lot of these discussions makes the partner also very, very highly intelligent about what are the internal things that are going on with this transaction or whatever advisory that you are giving. Clearly, you've not been mentored by a good GC yet. So, should we start? All right. Sorry? To make a? To mentor you? I will have to find a GC with about 100 years of experience for you to do that. Or maybe a panel of GCs like we had on the panel. Oh, perfect. So I think we have everything here. Welcome, Seemaji. You are late, but you're never too late. You're on time for your panel and also our panel. Our panel, I shouldn't be calling our panel because I was not supposed to be in this panel, but Umang's panel, a panel with about 4 or 5 people is now more like a fireside chat with me, of course, with much lesser knowledge on ESG. So I'm going to rely on Umang a lot more. But before we do that, and now the room is moderately accommodated by people, and I think they've had their coffee, they're hydrated before we bore them a lot more. We'll probably go to Umang, introduce herself and what she does, and then kind of ask her the questions and make life difficult for her. So Umang, why don't you introduce
I
yourself?
look forward to it. Hi, good evening, everyone. I am Umang Pathak. I'm a lawyer. I worked in tier 1 law firms like Amarchand and AZB. That was my previous avatar. Pre-COVID, we were incubating corporate governance and ESG as a practice in Amarchand, where I was last there. And as the corporate sustainability was evolving in the world, COVID did impact, which now we are thinking with the latest geopolitical and geoeconomic issues that it is no longer relevant. But unlike what we are now seeing, 5 years ago, people thought the same, but sustainability became what it did. So I was convinced, I stepped out, set up my own firm in peak of COVID. And as they say, usually rest is history. My firm does corporate law, niche advisory in ESG, sustainable finance, and now carbon market, which is again something India is going to notify very soon. In the process, we realize there is a lot of work which AI and technology can do for us. So we have also incubated our proprietary technology to do ESG assessments and sort of a command setter for an organization for its legal and ESG management. And similarly, on the other side, for investors to oversee their portfolio to capture sustainability impact of their investment. So that's the long and short of it.
I just hope everybody is able to understand a lot of heavy words that have been said. So I'll come back on the very basics of what an ESG, what could an ESG practice means for a young crowd that we have, or for a mature crowd that we have, which has not started either receiving the kind of services that you offer from an ESG perspective, and what is the regulation around that that will make me more obligated to understand ESG?
So I'll contextualize taking your previous panel discussion in the reference point. Why an in-house GC or a law firm practitioner should equip himself about ESG, because firstly, ESG, let's understand what is ESG. ESG is an acronym for environment, social, and governance. It was devised by investment community many, many years ago, because they started, whenever they looked at a prospective portfolio company, they started assessing that company on ESG parameters. So what does that mean? What is the environment impact of an organization? What is the energy consumption? Is it fossil fuel based or renewable? How do they do their waste management? It is, reuse, reduce, or it's just buy, use, and sell in the landfill. Similarly, on social impact, from your value chain vendor partners to your own employees to community impact. And governance, how independent your board is, how much of expertise professionally is there, or is it like totally promoter driven, whatever I say, I'm the boss sort of governance practices that happen in the organization. So it's certainly not CSR as we understand in Indian context. What regulations apply? Actually, ESG on business side is called as stakeholder capitalism. Instead of focusing only maximizing profit for shareholders, it is about business do not exist in isolation, and while they take natural and human resources to create products and service, which they go back to the
sell to the society, to the world at large. So there's a symbiotic relationship, and a company or a private sector and financial sector is a very integral part of that. So sustainable development or sustainable world cannot exist without corporate and financial sectors buy-in into this. On pure law, it's Section 166 of our Companies Act, which mandates the board to act in the interest of its shareholders, its employees, community, and protection of environment. Unfortunately, whenever we do sustainability conversation, we go to CSR, we do some donations, we click some photos, and we add some SDG goals, colorful logos, and our sustainability is done. But unfortunately, that's not the essence of ESG. ESG is one, how do you do your business, your operations? How does it impact the people and the planet? And the products and services that you provide to the people, how positively they impact? Are they are just exploitative and extractive, or so I'll stop here for you to.
So I understand that if I'm a listed company and there's SEBI rules that apply to me on ESG, if there are, that is, and am I obligated? But what if I'm a private company and I'm into tech space? I'm not manufacturing, I'm not cutting trees, I'm not polluting the climate. How does it affect me as a company which has a sustainable revenue model to apply the ESG rules? And how does it profit me on that? Why should I be spending money on ESG as a private limited company
So
with?
let me give you a few examples. So why I mentioned 166 and not BRSR, because BRSR came much later. 166 was incorporated in 2013. Then MCA made the previous, national voluntary guidelines for responsible business conduct. Taking that, SEBI made a format which was previously BSR, and eventually it took the shape of BRSR. So firstly, let's distinguish between a reporting obligation as a compliance versus business operations, which I tried to explain earlier. This came only for listed companies because, there is a private money involved, public money involved, and the SEBI's role and jurisdiction is very different. What it does is that you disclose it to the world and let the investor make its informed decision. But how do we, and which is actually the theme of our discussion today, whether all these ESG statements that are being made, which is not only till BRSR, it is also by private limited companies by claiming my product is sustainable, it's organic, it is green, it is net zero. So what does all that entail? That you and your company and your products have zero impact on organization whatsoever. To answer why private companies need to do this, because that's where capital is driven. Every investor, whether it's a VC or a PE or an early seed investor or a Series B or beyond, they all do ESG due diligence as part of their normal legal and financial due diligence of a company. We have been able to advise a lot of our startup clients who have been able to leverage premium on their business valuation because of, being on the right side of the conversation. So one is investment and the second is the customer. If you are supplying in EU jurisdiction, whether goods or services, there is a pre-qualification criteria followed by most organizations, which is where you have to make your ESG disclosures. You have to show that you are sustainable, because EU regulations go beyond jurisdictions to ensure their supply chain of the companies based in EU are also sustainable. That's one. And the other is the carbon border tax, which is what India is negotiating with EU to at least keep MSMEs out of its scope, but I doubt that's going to happen. A lot of EU companies which do business or do manufacturing in India or even other jurisdictions for that matter, they themselves do have to make their product more sustainable by becoming more sustainable companies and integrating sustainability in their operations.
So you said when private equity or private money is invested in a private company, and we're not talking public because now the ESG rules on that, the reporting is clear. So coming to private, right? When private money is involved, they look at more ESG related compliances, if not compliances and reporting. So what in that reporting or compliances are they looking? How do companies without a format prepare that ESG statement?
So I'll give you a couple of examples, case studies. We were advising a dairy company. It's a startup which has sustainable and impact investors. First, I must say that you become more attractive to investors. Like today, anything climate tech, agri tech, biomass, biochar, these are the words you must be listening, that this is what investors are looking to invest. So being a sustainable company, by trying to create impact on ground, you attract better investors, more investors, and definitely attract more premium. The other, what do these investors see? As I said, there is an ESG checklist that we draw up for, which is specific to the industry, the size of the company and their business model. In that, as I said, on E side, there'll be energy to waste, to hazardous waste, to which is beyond licenses and approval. You may have a, let's say, license to draw groundwater, but your facility exists in a water scarce zone. So what should you do as a responsible company? So these are, beyond legal and licenses and approval obligations. Specific to this company, I must tell you that there are investors sitting that which every tranche of money release was conditional upon companies meeting certain sustainability parameters, which is to have ESG policy, which is to have ESG governance framework, which is to have ESG risk matrix and risk mitigation and management plan. There was an investor which even went beyond companies. So, you source water, the milk from the farmers, and then sustainability parameters at the farm level. How much of a gender, like women farmers are, putting in more milk, to how much you are engaging or educating the farmers on their feed composition, that there is less methane emission in the stock, the feed stock that you give to your livestock. So, it's the depth which is specific to an investor when they come. They come riding on these requirements and conditions through their entire, investment term.
As a GC, I would think, what if? So what if I don't do this? What is the risk that I'm sitting on? And what if I fake it that I have done? So tell me more on that front. Yeah, I mean, if I've mentioned something wrong to my investor that I've done, I'm more compliant. There are 5 female now dairy persons in my farm while they're not, right? What is the risk? What is it gonna happen?
Okay, so I can only draw comparisons with what happens in the rest of the world. If there is a whistleblower complaint against a listed company in India, and we have seen that there are cases about it, the 3 law firms in US will sue the company. They will certainly get their, what do you say, compensation. But here we will barely even see a regulatory action. So what can happen? There is no limit to it. What does not happen, because, we don't have shareholder activism the way it is in other jurisdictions. Even though having 166 section in our Companies Act, I think Indian companies would have been sued left, right, and center, but it doesn't happen here. We have class action provision from pre-independence era, but how many of such class actions have we seen against companies? So to answer, I mean, this is actually for a company to decide, which is why I said 2 other reasons, which is being capital attractive and be able to compete in the market. But ideally, it's not a high moral issue. ESG sustainability is not high moralistic ground. It is purely how to do business, which brings positive impact to people, to your employees, to the product that you create, which doesn't harm people. And it should not be restricted to a regulatory action or a court, process. that somebody has to file a PIL or a case. But if you ask me, there's enough actionable reasons for anybody who's negatively impacted to go. Currently, the litigation space for misrepresentation like this, if you make misrepresentation in BRSR, for example, SEBI will definitely can take action. So it is not just get your fancy report made and do write whatever. There is a high risk of litigation, a regulatory action by SEBI. The other thing which has recently come is that consumer authority has on greenwashing, they have come out with a code. So any ads which are not authenticated and backed by evidence, like you must have seen a case on this mosquito repellent that it is completely natural, but they were pulled up and the penalty is like 2 years imprisonment to 10 lakh rupees of penalty. Similarly, advertising code has come about on greenwashing. So similar actions are being taken. So it's an evolving space. But as I said, it's no high moral ground. It is absolute business sense to do it. And of course, avoidance of any kind of crisis. So you are sitting on a crisis in making if you don't act.
We are definitely sitting on a crisis that's outside this hotel for sure. Talking about mosquitoes and talking about brainwashing, I've been wanting to ask, no, brainwashing. I mean what I say. Brainwashing and mosquito are two issues that I face on a daily basis. So is this ESG governance only applicable to private companies and not the government? Because the government is also delivering services. The government is into more services and products than one private company put together, right? From road making to delivering alcohol or to selling alcohol to doing everything. The government should and should not be, right? They also operate handlooms, they also operate buses. So there is a lot that the government does. So where is the government in adhering to the ESG governance model that you're telling us? And what is that us as citizens or as people living in the city can do? Can we hold the government accountable, have litigation file for compensation? Has that happened anywhere else in the world? And what are the ways that we can probably tackle this issue?
So let me answer this in two manner. One is government as a sovereign and one government as a service provider, which is actually disseminating public service, right? So as a sovereign, as we all know, there is sustainable development goals. There is a Paris Agreement. We have committed, and let's not get into the enforcement, whether you will or not. We will, because we are the fourth largest economy now. We are slated to become third largest. We want to be Viksit Bharat by 2047. We have a decarbonized green growth strategy to become net zero by 2070. So all of this, what we need for this is finance. And whether we like it or not, no FDI is coming as a charity to any government. It is coming as climate finance, transition finance, adaptation finance, and it is going into either government as a service provider, which is building infrastructure, or government as the facilitator, which is opening, like how, AI missions or semiconductor missions or these kind of things are happening. None of these conversations you will see are without sustainability integration, because this is what we are telling the world. And if the capital is coming riding on this requirement, we cannot not address this. So if you see the policy changes as they are happening, from very industry specific way, I can tell you the EPR has come and its scope is widening by every day. We have made packaging regulations more stringent. The plastic pollution global treaty is still into the discussion and yet to happen, but around plastic recycling, reuse, e-waste, I mean, look at the policy at the fast speed as it's happening. Then on the other side, government as a service provider, You will see railways conversation, which railway used to take government budget as the financing source, has now started taking inwards, attracting global capital, talking about hydrogen, electrification, new age. Similarly with the road infrastructure, PSUs are taking out bids for ESG consultants. So that transition is quite visible even in the government space. So yeah, I mean, nobody is immune to this. And this is around what is your industry business model and your business strategy is. You want to go global, you want to create a supply chain for the world, you want your product to be available last mile even in EU and US. We cannot not integrate this. I mean, that's pure business case.
Got it. So talking about Viksit Bharat, SDG, I want to open this fireside chat for Q&A so that, people better than me who know ESG better can ask some very good questions to Umang. Vanya has one question. Can you hand over the mic to Vanya?
Hi, ma'am. So as Pranav mentioned, I'm Vanya. I've actually worked within ESG. I was with a consultancy firm, and I was one part of my aspect of work was around ESG. And now I'm working in maritime law. I'm relating the two, and over the years, I've found that maritime industry, it's kind of underreported as far as ESG reporting goes, especially when it comes to Scope 3 regulations. I mean, Scope 1 and Scope 2 is fairly taken care of. But as far as Scope 3 goes, there's so much like port to port that happens behind the scenes. How do you feel that, like, what sort of parameters will be made mandatory in the coming years? I'm very curious to know what you feel about Scope 3 reporting, particularly in the maritime industry.
Sure.
Thank you.
So as I said, sustainability means different things to different organizations. While we are discussing public versus private, actually, she's picked up like it is very niche. A sustainability impact for a maritime company to a fintech company would be different, but it would certainly be there. So to answer your question, and firstly to say what is scope 1, scope 2, and scope 3, this is around energy consumption. An organization does its carbon footprint or carbon accounting, whatever you want to call it, by measuring their own carbon emissions first. So scope 1 is by what you are doing, your business processes. If you're using fuel or DG fuel for electricity as a backup or whatever, or scope 2 is when it is not your direct emission, but it goes into what you're doing. So your supply chain, how your products are moving, your energy, which is grid energy, is fossil fuel based in this country. So that these kind of things fall into your scope 2 emissions. How many employees travel, how they travel, which is why you will see a lot of bigger groups, are transitioning to EV, which is what cases for even Olas and Zomatos that are partners, or delivery partners, are all on EV, etc. Scope 3 is your supply chain, and there is, in our firm, for example, we do a separate advisory on sustainable supply chain framework, because to measure scope 3, not only from the emission perspective, but also labor, environment, and other sustainability issues, because typically these issues are sitting there. You normally have a contract labor, for example, or you will have a service provider who's providing you housekeeping or other stuff, but does not mean that it doesn't, factor into your sustainability impact. So yes, scope 3, because again, I would say it's not mandated by law yet to disclose. Progressive companies, especially which are either present in EU or supplying in EU, kind of have to follow this. I mean, I have advised smaller MSMEs, which are vendors to a fashion brand, say Puma or Apple. They are getting monthly audited on sustainability. So it is happening, but it is happening through the business cycle. It is not in disclosures yet, because it's not in the reporting format as yet.
We'll take just one more question. Vaibhav has one. And when my learned friend asks, आवाज बहुत बुलंद है, इनको माइक की जरूरत नहीं है, तो आप
that going forward, you cannot finance a thermal job.
Correct.
Going forward, you cannot finance mining activities.
Correct.
And so on and so forth. So it came with all of these riders. And what became very interesting was that the bank's board got into a debate amongst themselves that why should we accept these riders? Because it also impacts the bank's business growth.
Correct.
And almost for 3 services, their board was fiercely independent, and banks, the so-called promoter or the Lala, not even push through his or her narrative. So the IDs got involved and they said, we will not accept these riders because we might as well raise capital from somebody else, but with these riders, our business growth as a bank gets impacted. Eventually, they were able to build a rationale as to why it still makes sense for the bank to accept this equity. How do you open up other avenues of raising further capital? It became very tricky because the board's responsibility also to do everything that they can to maximize shareholder interest, amongst many, under 169 fiduciary responsibility. So I just wanted to share that experience that that deal got rejected 3 times over, and eventually the board sort of
It did go through.
But there was ridiculous amount of paperwork to demonstrate that why that deal still makes sense for that private sector bank. The other question, so that was just an observation I wanted to share and get your thoughts on.
Yeah.
So the other question for you would be that, is it time, and many would debate that this is ridiculous, corporates are already paying so much taxes, there is CSR, is there a time that particularly certain polluting industries, we now clearly have an idea of who are those industries? Some would argue automobiles, some would argue some other sectors. Is there a time now to literally some kind of a reparation cost, liability, and that be directly utilized to offset against the current fiasco and the prices that we're seeing?
So let me first give you input on what you said. So see, sustainability is not new, first of all. I will put it in a perspective and you will find your answer yourself, whether it's profit versus sustainability. Industrialization happened. There was absolutely exploitative abuse of labor. 1919, more than 100 years ago, International Labor Organization was formed to protect labor rights, right? Then came Human Rights Treaty in 1948. Kyoto Protocol, we started worrying about environment in 1994, towards the end of last century. So today where we are sitting, when oil spills happen, today also it happens. Everything happens. I'll give a recent example. Everybody has seen Erin Brockovich. That hexavalent chromium is still used in India. It's not banned. Should we? Or should we let it be used because we have to maximize wealth for our shareholders? So there are many examples like I find it surprising. If you can see our website, we say 4 Ps. The first P is profit. Business has no incentive to create any good or service for anybody unless there is an incentive of profit. That's parked. Capitalism, fantastic. I'm a great fan. But what kind of capitalism we want? Exploitative, abusive, extractive, because tomorrow we'll go to another planet and, capture that and start living there. Or do we want to do it not profit as of tomorrow? It can come in 5 years. And it is not more than that. It is not hundreds of years, which is where executive compensations are questions which are only designed around profitability of the organization. So there are many examples like this, which a lot of things which EU already has. European investment banks stopped investing in polluting thermal or any of these projects at least 5 years ago, if not more. So I don't see why a source of capital like a bank or an insurance fund or a pension fund, this is what the entire financial sector is doing, sustainability. This is the reason. It's not my money. This money is actually coming from people like us, our pension funds, our everything. Do we want our money to pollute or let the institutions work the way they were working? So here is my 2 bits on that. The second bit that you mentioned, sorry, what was it? Reparations, yes. See, that already is happening. I mean, as I gave you an example, like Erin Brockovich's movie became a movie, but we haven't seen that kind of case here. We know the cancer-causing chemicals. And the bigger problem is that we still act in silos. While we want to address plastic pollution, we allow plastic incineration in cement kilns because, plastic is addressed, but let's emit GHG emissions because that's somebody else's problem. So, we need to holistically look at it. And yes, I mean, just because our judiciary takes long, we have redundant class action, we barely have shareholder activism, companies don't get sued by hedge funds who take over the board and run the company as they like it. But that's what I'm saying. It's a question then for us. If this is the way we want to continue, because my government is not asking me and I can keep filing the reports which nobody is reading and nobody is holding me to account. They do it when the investor asks them to do it. Or when the crisis happens, all our legislations, whether pre-independence or later, you will always see a standard director and corporate liability provision in it. It only kicks in once shit hits the roof. Then we, forbid our directors, we go after independent directors. Oh, were you sleeping? I mean, you can look at profit today, but tomorrow that exception would not work. Oh, I didn't know. Because the document came on the board, right? And this is why even investors who take board positions or veto rights in an organization, they are obligated under stewardship code by SEBI, by PFRDA, by IIRDA to act. Now we can say, okay, I will not do it till the time something happens, and it is our decision. But everything in terms of rules, regulations, why you should do it is sitting there. The reparation orders will probably start coming when these cases will start reaching the courts. As of now, there is not much which is happening there. So, yeah.
Thank you. That's a very insightful discussion. I learned that I was probably 99% not aware on the entire topic, but yet I learned a lot sitting here. And I hope that you've also learned along with me. If you have any questions, please feel free to reach out to her directly. One takeaway is that areas like ESG or areas that are around environment sustenance requires a very passionate person to drive this discussion through, because it's not something that will happen in the next 30 days. But it takes much longer to sustain it as a practice area, to sustain as a independent law firm, to keep on harping the same thing year on year. And sometimes the corporate will listen, and sometimes the industry will wake up to make this happen on a sustainable level. So along with that, a huge round of applause for Umang. How not to get a deal rejected 3 times is what Weber will tell in his next panel. So we'll welcome the next panel now.
Also, thank you so much, Pranav, for taking this one on. He was not supposed to chair this, but of course he did it. Thank you so much. For him as well, please. Thank you. Picture, please. Thank you. With that, we now come to our last panel discussion for the day, which is deal making across sectors, lessons from 2025. While they get the stage ready, I shall introduce our next panelists and then we welcome them together. For this one, you're going to be having on the panel Seema Jengan, Managing Partner, Lex Counsel Law Offices. Running her is Samir Chug, Chief Legal Officer, Games 24 by 7. Joining them is Manindra Singh, Partner, ELP. Also joining them is Vaibhav Kakkar, Partner, Srafed Partners. Also joining them is Ajay Prasad, Partner, JSA. And this one will be chaired by Mukesh Bhutani, Managing Partner, BMR Legal. Let's please welcome them to the stage with your applause. So Ajay and Samir have not made it, but the others, of course. Flights, of course.
Good afternoon. I think the buzzer that you have time, so please don't hesitate to buzz us. It's a privilege and honor to be able to moderate this panel. I don't know when the organizers decided on this session what they actually had in their minds. Most of you know I'm a tax lawyer. I'm not a deal lawyer. But now I have 3 lawyers who are deal lawyers. And the topic is interesting deal making across sectors, lessons from 2025. I had one of my research associates give me some information. I do work on deals. I issue opinions which are tax related, but I don't do the nuts and bolts of the deal, which these 3 lawyers do. So I just thought we will have an engaging conversation. Regrettably, we didn't have time to prepare. So, one of the questions I had in my mind is I didn't want to, catch anyone unaware with an awkward question. So I randomly sent them a few questions and I said, let's have a conversation. So whoever wants to answer the question first, feel free to do that. I don't need to introduce the panel and take everyone's time, but as I was going through some research material on the theme of this panel, I came across that there are some mega deals, there are mid-sized deals like it happens in India, and our panelists are fairly experienced and seasoned lawyers in both. I tried to look at which are the 3 important deals of 2025, though one deal was announced today morning only. So I'm not including that because we are still processing that news. So the 3 big deals were the Emirates NB's $3 billion acquisition of RBL Bank. This is important because it's a major deal in banking and financial services. We don't see very many deals in banking and financial services. Then we have the International Housing Companies deal. This is acquisition of Samman Capital and NBFC. Again, in NBFC sector, we see deals, but we don't see deals of this size. And third is the Tata Motors $1 billion acquisition of Iveco, which is an Indian company. Bold move by an Indian multinational, but not surprising given the size of Tata Motors. So in the automobile sector and in some of the other sectors, over 100 deals happened in 2025. There was a little bit of slowness in the deal insofar as US is concerned for the impeding trade agreement. Many regulatory changes took place during the year. Whether these regulatory changes brought in more deals or they are likely to pave way in 2026, we will also have some futuristic outlook. Let's come back to the panelists and debate on some of the important issues in 2025 from a deal standpoint. Let's first look at the regulatory issues. I wanted to come to press note 3 and whoever wants to go first. There is a calibrated move to take away or reduce the rigors of press note 3. It is unclear whether they want to reduce the rigor to attract more capital from China in categories such as manufacturing of electronic products. But certainly there is a move to attract money by way of strategic investment because the 49% cap is coming in. I just take a quick view of this important development. I would gather is that that suitable, papers are being made out, and including the Prime Minister's office is involved. And I know, talking to many, many deal lawyers, including you, that press note 3 was coming as a very important roadblock. What do you see this as a future? Do you see this likely happening?
First of all, thank you very much, BW World, for having me over as part of this discussion. And thank you, sir, for a great question. It is true that Press Note 3 continues to be a bit of a challenge for investors investing into the country. As most of you are aware, that Press Note 3 was brought in the context of COVID and the context of military conflict at the border between India and China. To prevent opportunistic takeovers from China, this restriction was put in. Over a period of time, what we've seen is the fact that a lot of private equity and venture capital funds have also been affected by this particular rule, because the government of India believes that even LPs from China, which includes Hong Kong, will get picked up by this restriction. That has meant that, true-blooded private equity investors and venture capital investors from the US and Europe, even if they have one LP from China or Hong Kong, is getting picked up in this Press Note 3 restriction, and getting investments from them is becoming a challenge. You're also right, sir, that the government of India, if one has to look at the last 3 years or 5-year track record from 2020, since this press note came out, the number of approvals are far and few. And the group of ministers and the empowered group of secretaries, which is headed by the Home Secretary, that looks at all these proposals from land border countries, and that primarily means China, have taken forever. None of those approvals come in time. They're usually taking more than 12 to 14 months. And there's almost an unsaid rule that in certain sensitive sectors, we also saw pharma, for instance, where the government did not allow the Chinese investors to put in money. What that has actually done is that it's forced a bunch of investors and global funds to now come up with mirror fund structures, where they actually have two fund structures, one with the Chinese LP and the one without the Chinese LP when they're looking at investing into India. The second consequence has been that, literally in equity money from China has completely come to a halt. What we, however, saw was an interesting trend in the backdrop of what we saw with MG Motors, where the government said that an MG Motors, being a wholly owned subsidiary of a Chinese company, government of India realized that in order to fund that company, the Chinese investor needed to fund it. And the government, I think, in a soft way, almost nudged MG Motors to say that, look, we will allow you to raise capital, provided you bring down Chinese ownership to less than 50%. And they finally approved that investment, with a domestic partner, JSW Group, a renowned group, took 51% of MG Motors India. That paved the way for some more deals to be explored in the strategic sector, where the government was now willing to accommodate and allow exception on a case-to-case basis for technology intensive, so auto parts, auto manufacturing, renewable energy, semiconductor. These were themes where the government was willing to now look at Chinese investment non-controlled, so less than 50%. But then Operation Sindoor happened, and the role of China there sort of again assumed relevance. But then Mr. Trump happened, comes in terms of tariff and the geopolitical climate. So India relationship with China is blowing hot and cold. We've now suddenly seen easing up of visa and travel restrictions. So what expects that, and the noise that we are hearing from the government is that, look, if you build a strong case that if you are only going to talk of capital from China, we will not consider it. But if you build a strong case that a particular Chinese investor is bringing in a kind of technology that is very critical for Indian economy, on a case-to-case basis, non-control deals, we might still consider.
Weber, your comment on hot and cold concerns me because from a certainty standpoint, it conveys that, and you mentioned Operation Sindoor as the driver for India to review the terms of Press Note 3. Something else could have happened in the future from a geopolitical standpoint. As transaction lawyers, what would be your advice? So imagine a client, seeking your counsel on getting private equity from China. Would you consider that as safe? Maybe perhaps today, yes, but what happens to risk factors that you will have to weigh in for the growth of that investment?
Yeah, so what happens is, as a transaction lawyer, uncertainty of regulatory regime becomes one of the biggest challenge for bringing in capital. Now, if you are having, as Weber mentioned, hot and cold situation, there is very difficult situation because you will not be able to have investment in mega infrastructure projects, mega projects which requires a lot of equity investment, because for the simple reason that today the relationship is good, tomorrow it may not be, and that would be an hindrance. Therefore, if you see in the last few years, most of the mega transactions have bypassed all of the Chinese, all of the Hong Kong related investment. In fact, the largest investments that were happening were through the private equity route from the Singapore, from Hong Kong. But that has all stopped because of the uncertainty. And the biggest thing that the private equity investors require when they come to India is, one is a tax certainty, the other is the regulatory certainty. None of which is possible if you have Press Note 3. And that is the reason that we have almost diminished all kind of investments from these territories. Approval rate is very low and it's very painfully, tediously long.
It's interesting you mentioned tax certainty. Mahendra, let me come to you. I specifically wanted you to share your experiences on deals, tax issues are involved, general anti-avoidance. I don't know if you know the news just about an hour and a half back, the Bombay High Court, which is hearing the application of general anti-avoidance on the Hinduja deal, has partly heard the matter and it's going to hear in January as well. In my professional experience as well, we see merging as a important roadblock. Do you see any changes in the future? Bear in mind, statistically, not even a single GAR case on merit has been decided. There is one matter which is lying in the Supreme Court, and there are all matters which are sub judice before the High Court. Either the stay has been granted, but no matter has been decided. So we don't even have one successful case that the tax administration has built on application of GAR, which becomes so important in a transaction. Mahendra, your experiences.
Thank you, Mukeshji, for that question. First of all, I am not a tax lawyer, so my views are going to be sort of a reserved views. But having said that, from a regulatory perspective, I think GAR plays a very important role. And specifically from a taxation perspective, because GAR gives tremendous power to the regulator to sort of see through the corporate structures and figure out what is actually resulting in the tax avoidance, and can actually question any kind of tax saving structure that you are coming up with. So from that perspective, I'm in agreement with the point that, look, as far as GAR provisions are concerned, there has to be some regulatory clarity on this. And of course, there is that Bombay High Court matter happening on the Vedanta matter, Hinduja matter. But having said that, I think there needs to be a lot more clarity that can come in terms of the GAR provisions. We have budget just around the corner, and maybe an industry consultation is something that should be done on this point, where the specific instances which are holding back from the deals perspective not happening, those provisions should be taken into consideration. For example, we see from structuring point of view, specifically say on the indemnity points, we see a lot of contentious issues that come up specifically on the tax indemnity, right? Those are the things I think the clarity is definitely needed. Of late, for example, in tax indemnities, we have seen insurances happening, right? Those are the things which are picking up because of these uncertainties growing over a period of time. So having said that, I think in a nutshell, there is that regulatory clarity that is required in terms from a deal structuring point of view and specifically from a GAR perspective.
Okay, so let's now shift gears, little bit futuristic outlook. Vaibhav, Budget 2025 for the first time made an announcement on M&A transactions being funded by banks. We are staring at 2026 budget. It's still not been made applicable, as I'm told. But the RBI has been working in consultation with the IBA to look into this, which is also considered as a credible option to, ECB, which had its own set of restrictions on whether it can fund. Have you seen any movement in the M&A market, or do you see anything in the future that's coming in? To me, at least as a bystander, I feel that there is a very cautious approach. For example, you cannot fund share acquisitions, understandable. You cannot get into commodities, understandable. But you cannot now get into real estate as well. So that seemed a little bit more restricted to me. I don't know what your overall observations are, whether this is a calibrated move which is over a period of time, or this is something that doesn't excite really deal lawyers like you.
No, sir, I think firstly, some of the themes that you're picking up are tremendously brilliant at that in terms of the impactful issues that they for M&A. I don't know how everybody got supremely excited when this particular proposal came through from the RBI. All my friends in the banking practice got really excited. So did I. From a purely legal perspective, if M&A has to be accelerated in the country, and ultimately we've got to do everything to facilitate growth. Inorganic way of growth will be the way to grow for most corporates, and we are now getting to a scale where M&A activity will be fueling the growth of the economy. In that backdrop, the reality was that today, sir, most companies were looking at non-banking financial companies to fund these acquisitions because of two issues. And the Indian law on leverage buyout is so restrictive. For the benefit of the audience here, we still have a provision on the Companies Act which says that a company cannot finance purchase of its own shares. Clubbed with the fact that the RBI has very strict guidelines that banks could not fund promoters' contribution of equity. These two things, along with the external commercial borrowing guidelines, which say that ECB cannot be used for financing M&A activity, all three meant that debt as a capital source for Indian M&A was really, really restricted. I mean, virtually did not exist. People had to resort to NBFC financing, which of course is far more expensive. And to my mind, opening this area will be very, very useful. It will allow banks to improve their balance sheet, will allow banks to do creative support for M&A activity in India. And Indian corporates will not have to look overseas to raise bonds outside to fund these acquisitions, which was the only norm that was taking place. And I think in this backdrop, I do want to tell you something, sir, that some of us who work very extensively with the RBI on exchange control, they reached out to us in a jiffy saying that, look, we are planning to rationalize the ECB guidelines to allow ECB to fund M&A activity. Can you tell us, how we can ensure that there's no abuse? And some of us have been working with the RBI. This is all happening in the backdrop of a real economic challenge, which is that, sir, I think the next 2 quarters is when we will start seeing the effect of $30 billion of exports becoming nil. And that is really, really worrying, even with the rupee depreciation. And I think, therefore, the government and the RBI is thinking out of box. But I feel that eventually RBI will come up with some regime, but a very, very calibrated one, because they don't want to also permit indiscriminate lending. But this kind of economic scenario and the current scare is what will drive the RBI to come up with these creative models.
My first reading suggests that it's conservative way to start with. It applies to listed companies. It applies for companies with 3 years of consistent profitability. It also has restrictions that eventually after the transaction, the debt equity of 3:1 used to be maintained. So it's a slow start. I don't know, Seema, what you see as the future of this. Very reformative. Over a period of time, it will play out. But I just feel that we need to wait and see. I don't know if you're experiencing clients expressing optimism on this.
I, I would just pivot to a little different issue here, adding to what he said. See, I see most of our clients are more concerned with the regulatory scenarios and the bondage education. Some of the regulatory bindings that we have in the deal structures is basically holding us back. What are the two aspirational areas that we have in India today? One is healthcare, a good healthcare system, and the other is the education system. And both of these systems are marred by so much of regulatory regulations. When it comes to hospital, they're supposed to be under not-for-profit entities. When it comes to education, you not only have educational laws, you have charity laws in each of these jurisdictions. What happens is, in my own dealing as a healthcare or in the hospitality sector or in the education sector, and including space sector, what is happening is there are so many private equity investors wanting to invest, including certain banks and through ECB routes. They're wanting to invest in these three primary sectors. But the constraints is that you need to be, at least in the first two sectors, in not-for-profit charity structures, which is basically holding back billions and billions of dollars of higher education investments, hospital investments, take profit dividend from these for not-for-profit charity institutions. So what is happening is that they are trying to now circumvent the regulations, bring in the equity in the regulated structures for creating equity structures which are not completely above board. I think more than coming up with more policy, what they need to do is to allow certain sectors like telecommunication, hospitality, healthcare and education sector to be moved away from this ultra regulatory regime that we have today.
Mahendra, I don't know if you want to react to that, but I also had a follow-up question on valuations. We have now valuations under FEMA, Companies Act, income tax regulation, which obviously prescribe different standards and different deal scenario and how challenging it is. And do you see that these inconsistencies will be addressed by the regulators in the future?
Well, Mukesh, to answer that question, how often? I think in almost all the deals that we do, we see this issue, especially in cross-border matters, where you have FEMA on one hand, then you have company law on the other hand. Let's say if you're talking about a SEBI situation or a listed entity situation, then you have formula driven by, say, if you're raising primary capital, then you have ICDR coming into the picture. Or if you're, say, doing a control deal or an open offer deal, then the takeover code comes into the picture. At times, of course, there is a correlation which is done, for example, in an open offer deal where say if you're doing it through a primary issuance, the FEMA will say that, look, it will be basis the SEBI laws, and then there is that convergence that happening. But in an unlisted scenario, it becomes extremely challenging. Also from a taxation perspective, where you have Rule 11 UA coming into the picture. So at times there is that inconsistency or difference in the numbers that keeps coming between the FMB that is there, basis the FEMA valuation or the company law valuation, and then the 11 UA valuation. Then the question comes, how do you bridge that gap, right? Then there are situations where you will end up you will have structure, say, earnouts, or say indemnity provisions coming into the picture, or you will have deferred considerations coming into the picture. All of these then come into the picture, and then because there is no synergy as far as the valuation rules are concerned, it is a problem that we have seen across in almost all the deals that we do. The easiest way that we try and bridge this gap is try and come see that there is a similar approach which can be followed across all the three valuation principles which are there. If that is not the case, then of course we go back to the drawing board and then figure out commercially how we can take care of the difference in the valuations. Specifically, say if Rule 11 UA valuation is far different than what a FMA valuation is going to be. So it's something that we see day in and day out, and there is that requirement that I think the regulator should, specifically if you are targeting to have more and more foreign investment coming into the country, we should have that synergistic approach in terms of valuation across the different laws which are there.
Rule 11 UA is Income Tax Rules 1962 because income tax has its own set of regulations. Every word and every sentence again becomes a subject matter of interpretation. Mahindra, thanks. You made a very interesting reference to deferred. Vaibhav, next question is for you. We have this regulation that not more than 25% of the consideration can be deferred, parked in an escrow arrangement, or indemnified by the seller for a maximum period of 18 months. This is a FEMA regulation. How challenging is this? And don't you think that this regulation has outlived its importance?
I wouldn't go as far as saying this has outlived its importance. I think this goes to the very root of the fact that India is not convertible on capital account. I find it kind of ironic on a very separate note, sir, and to everybody else in the audience, that we go all over the world, we make strong pitch to invest in India. But what do we tell the foreign investors? If you come into India, you cannot come at a price lower than the fair market value. And when you exit the company, you cannot exit at a price higher than the fair market value. And then you tell foreign investors, please invest in this country. I kind of find that ironic because ultimately investors will come where they see that opportunity. Clearly, India presents an opportunity, but the Reserve Bank of India still is in that play where they believe that capital controls need to be there. And in that backdrop, they have laid down this limitation that, whenever there is a transaction and there is a between a resident and non-resident, not more than 25%. And that can also be provided that 25 above the fair market is 100. Only then you how can you put such regulatory limitations on what should be purely driven through contracts and the freedom that parties have depending on the risk that are involved? Having said that, I think until RBI does not give up its play on capital controls, these kind of rules and limitations will continue. And the fact that the rupee continues to depreciate doesn't help us to build any case to relax any of these rules. So I feel that some of these rules will remain. They do impact deal making in the country. But having said so, I think in the overall macroeconomic play, I don't think we'll be able to wish away these rules anytime soon.
Thank you. Seema, you wanted to add something to that?
No, I think.
Right. Let me come to the next question. 2025 deals, experiences of some of the deal lawyers that I spoke to, higher emphasis on indemnities, escrows, earnouts, deferred considerations. Do you think that the risk allocation in the Indian M&A space structurally has shifted in favor of the buyers, or is this merely an outcome of global uncertainty?
I think it's a combination of factors. One is the liquidity issue, whether the funding is being drying up. ECBs are hard to get. But indemnification and a deferred payment has always been part of the deal structures. What is happening is the aggressiveness with which it is being negotiated now. There is the earlier, if we were doing, let's say, 10 to 12 deals in a way, there would be 3 to 4 deals which will have deferred consideration or an escrow arrangement. But now all the deals that we negotiate, starts with the concept that any deal that we are doing will have 10% for sure a deferred consideration, which will be paid out as an earn-out. Earn-out, which basically means you will be getting that money, you earn that out over the next period of 1 year or 12, 18 months. So that's something which is on the table to start with. Earlier, it was, let's say, in 20 to 25% cases. So there is an aggressiveness to that. Indemnification, there is a trend. What is happening is that more and more the impetus of the buyer is to indemnify against all possible scenarios. Earlier, the deals used to be that, secure some larger aspects of take some reps and warranties, secure some larger aspects of the deal. But right now, the way the reps and warranties schedules are possibly going into starting from 7 to 8 pages, now it's going into 15, 20 pages, sometimes bigger than the document itself, the contract itself. This aversion to any kind of exposure, not that it diminishes any possibility of litigation, it does end up in being litigious and contentious going forward. But there is a trend to minimize the exposure. And I think that is happening because the funding, it is right now, 2025 has been a buyer's market. And therefore, they were able to have those kind of no risk, diminishing returns kind of scenario.
Weber, you want to?
I actually have had a very different experience. I must share this with all of you. What we are seeing now is that if a deal value is more than 200, 300 crore Indian rupees, invariably there is a banker who's running he's running almost like a bid-like situation. And invariably the sellers are turning around and saying, we will not give you business reps and warranties, because these are bid-like situations. So there are many bidders trying to bid for the same asset. So they're coming in from a position of strength. Of course, there will be those exceptions where the seller is more desperate to get out. But our experience over the last 1 year has been that gone are those days where you're negotiating indemnities at length with the seller. The seller's starting position is, I'm not giving you business reps and warranties. And then as a buyer in a bid-like situation, I'm being forced to therefore consider insurance, rep and warranty insurance, as a way to mitigate my risk. And the sellers are telling you, price in the premium in your bid, but I will not stand behind the reps and warranties. And one of the additional reasons why this is happening is that, earlier, sir, the owner of the company was largely the promoter himself. Today, if you look at any reasonably mature company, even if they are not publicly listed, even private companies, there is a large number of institutional financial investors, such as VC investors, such as private equity investors, who are owning large chunks of the company. So by the time a Series E or a Series F has happened, the promoter is down to 20, 25%, if he's lucky, if he or she's lucky. The financial investors are sitting with 75% of the cap table. And the financial investor's position is, I will not give you business reps and warranties because I've not been running the day-to-day show. Of course, there are some exceptions where a large private equity owns more than 51%, but that's not happening as often. So the sellers and the financial investors are saying, we will not give business reps and warranties. The promoter is saying, I only own 25% in the company. So if I'm doing a $100 million deal, I can only give you reps and warranties around $25 million, which doesn't work for the buyer. So what we are seeing of late is we are spending incredible amount of time with insurance brokers, sitting down, trying to negotiate insurance policies around the indemnity cover. So that's an interesting trend. We've spent a lot of time now getting educated on that.
Mahendra has a comment.
That's a fair point that Weber has made. And I think it also depends from the sector to sector in which you are. And of course, the promoter, how much do they control at the end of the day? Insurance brokers are, in fact, becoming the hot topic as we speak. I think if not, say 90%, but at least say in 60 to 70% deals we are seeing the indemnity insurance is being negotiated, heavily negotiated, which actually is a win-win position for both the sides, be it for the buyer or for the seller. And that's where I think now the litigation funding is also going to be picking up majorly, right? Because even the banks or even the financial institutions are able to fund the litigation, which is going to be taking the promoters or the main guys off the hook. So also, I think that's something which is also going to be becoming, which is equivalent to something what we are seeing in the form of indemnity insurance. Also, the litigation funding is going to becoming the next big thing in the line of, say, dispute resolutions also.
Mahendra, one follow-up question for you. Again, trend in 2025. is it becoming more common in the M&A space, which is the post-closing disputes, particularly transactions that involved earn-out, complex earn-out formulas, indemnity, indemnities being worded in a very complex manner, and regulatory non-compliances, which got picked up at the due diligence stage. Is that your experience as well?
Well, I'll say it's been a mixed of such cases. Yes, I will not say it's completely gone, but more and more we are seeing parties trying to negotiate a settlement out of a dispute situation. That's something where we are seeing a trend going in that direction, rather than parties actually litigating it for years and years. Because see, we had litigation to begin with as the first mode of resolving disputes. Then we brought in arbitration, right? Arbitration also has lived its life in terms of trying and resolving its disputes, right? Arbitrations now also run for 3, 4, 5 years, which is not acting as a speedy disposal of disputes, which is what it was intended to. What it is doing in the process is people are getting tired, parties are getting tired, they don't want to spend money over lawyers just to try and litigate over stuff. So parties are trying to take haircut and try and resolving disputes. I think that's where we are seeing a lot of trend happening, and which is where I think the third party intervening players, say the indemnity insurance guys or the litigation funding guys, these guys are now picking up more pace in terms of resolving these dispute situations.
I'm drawing inspiration from the earlier session on ESG. Do you, in your deal experience, see interplay of ESG considerations, particularly if there are very hardwired, clauses, or to be able to deal with allied legislations or to ensure stricter adaptation becoming a real deal breaker?
Yeah, so ESG is no longer a must, should be there, but it is an essentiality. It's a necessity for any deal to happen. For instance, the attractiveness of the investee company to be able to track more bidders, the ability to have better valuation, the ability to get the deal actually to the closure is all based on the ESG compliances. So more and more what we are seeing in the last 3 to 4 years, that the ESG, when it comes from legal compliances, when it comes from financial ESG compliances and reputational risk emanating from not compliance of the ESG, is becoming very important part of the deal making. So M&A means that the financial advisors and the legal advisors will do a thorough assessment. And now there is a third angle of the third party reputational risk associated to non-compliance with the ESG. So this is when the ESG, when the deal is being discussed, any entity which is ESG compliant is a potential entity which will have many more bidders and many more buyers, and the possibility of its closure is much more higher. So it's a real deal now.
Whatever you wanted to add. Just another futuristic question: what are the deal makers watching or anticipating in terms of market sentiment and regulation, keeping in mind that we're just about few weeks away from the budget of 2026? Do you see something as big bang as it was announced last year on banks being able to fund the M&A transactions?
That's a tough one. It takes a bit of crystal ball gazing. I think the government, as I mentioned, and I can't overemphasize the point that I think the government and the Reserve Bank recognize the fact that there is a bit of a crisis at the moment. With the coming 2 quarters, the realization of $30 billion becoming zero in terms of exports to the US will hurt us. And but what do difficult circumstances do? They give great opportunities to pivot. Some would argue that GST 2.0 was as a result of that difficult scenario that we find ourselves in. I do expect some consultations have started at an industry level. I do expect some industry-focused concessions to be made. Some rules around exchange control and leverage buyouts and things like those will become a lot easier. I also feel that particularly in the infrastructure sector, sir, there will be some greater dilutions on some of the restrictions around promoter contribution being financed. So those will be incremental changes that you will see. How out of box do they go is the key question. And I think somewhere where those trade negotiations lead us will drive the motivation of how creative they want to get.
You want to?
Yeah, I think for a very long time when the budget used to come, we as corporate lawyers also got very excited when, say, the changes in FEMA or even SEBI or even company law were introduced via budget, which is, I mean, in my honest opinion, it's not required. Like you can do separate independent amendments to those laws, not necessarily routed through the budget. But I think gone are those days when the government is implementing these changes, at least in these corporate laws, through the budget route. But independent of the budget, I feel government is already focusing a lot on trying and see how they can make the whole investment market lucrative, not just for the foreign investors, but also try and bring a sense of stability within the domestic market also. I'll take an example of the securities market code, which is right now introduced in the Lok Sabha, right? I mean, it's a massive, massive move that the government has done, consolidating SCRA, SEBI, Depositories Act. Earlier, government securities are also supposed to form part of it, but it is not, as I see. But I think those regulatory reforms are already being done by the government in an independent capacity and delinking it from the budget perspective. So I think the government's focus is already there. Budget is going to be more on the point of view of trying and ensuring that expenses are given to the right areas which are going to be picking up where we can get more foreign investment, say the manufacturing sector or the electronics, or in fact, say even AI driven sectors, right? So I think those are the areas where the government is going to be focusing and putting a lot of budget in those sectors.
Since I promised that I will end with the buzz, let me just give 1 minute to each of our panelists. I felt if 2025 was a year of resilience and recalibration, 2026 could be scaling sophistication and strategic dominance in the M&A space. Do you have any closing comments on what should be done to incentivize M&A practice in India?
I think the government has to deregulate and specifically focus on 3 critical areas. One is defense. The amount of budgets that we have for defense procurement and defense imports. We have held back for a very long time in defense manufacturing within India, and we have put ourselves as a government, we have put a lot of hurdles in that process. That needs to change because we have a licensing process. The second area that they really need to work hard is getting the space sector move very fast, which is happening at a tremendous speed, but we are a minuscule part of the entire ecosystem of the world ecosystem in terms of space and satellite campaign. That needs to change. And I think they need to change the archaic regulations related to education sector in India.
Yeah, I mean, first of all, just to add to the point that he was making, can't agree more. If you think about it, in the last 30 days, 3 big changes have happened. You have the new labor codes. You now have the data privacy rules and the data law coming into force with full fury. And the insurance law bill got passed yesterday where FDI has been increased to 100%. So clearly the government's not sitting idle. They're making a lot of changes, and with the securities law bill being pushed today, I feel that we will incrementally continue to grow in this space. I think what will be important is for the government to be responsive and receptive to feedback from practitioners. One very quick example where I'm very proud of what the government did was, I think, the realization that we need to do ghar wapsi of startups where holding structures were outside of India. Government quickly realized that you need to bring back the holding companies into India. They came up with a fast track merger scheme. They allowed cross-border mergers. The RBI came up with an automatic regime. And you've started seeing NCLT's approval. I think Flipkart got its approval yesterday, which will pave way for the IPO. Misho did that, and we supported them in that exercise as well. So I think the government being responsive and picking up where there's an opportunity, I think that has been something which has been a very welcome step. And I just hope that we continue in that direction. The government and the regulators get a lot of bricks from everybody, but I think where they've done something on their own and something which everybody appreciates, I think they deserve all the accolades as well. This is one example of that.
Certainly accelerated regulatory developments. Your take, in fact, we've already laid down the basis for acceleration in 2026, just with the month of December that we have seen, the 3 important changes Vaibhav you spoke about.
Yes, Mukesh, I think going forward, what government should focus on, while their focus is rightly there to ensure that we are able to increase M&A activity, deal activity, but in reality, when we are seeing how do deals get executed is, say, for example, through courts, right? We are seeing a logjam at NCLTs, right? We are seeing, I mean, if you're going for a tax neutral merger, you're going to go through an NCLT route. Cases are pending for 9 months to begin with, right? So that just loses the entire charm of how a deal making should happen. And that's not something which is going to be incentivizing foreign players to come and do structuring or a tax neutral mergers acquisitions in India. I think that's where the government should really focus on. There are a lot of patients, but there are hardly any doctors. You go to an NCLT, the merger matters just take back seat, right? They're not, it's just not there. The alternate to that, which is a fast track merger, good part, government on paper expanded the scope of entities which can utilize that route. But I mean, from a practical perspective, having done fast track mergers, I'm telling you, I mean, that is also taking a lot of time. There are a lot of repetition in the process and the procedure that even at the RD level we are seeing. So I think those are two places where the government really needs to focus on how can they actually bring the law into play and effective enforcement of those laws. And that's something the way the government should really focus on. And I think after that is just going to be some path breaking for the foreign players or even for the domestic players to move forward.
Terrific. On that note, please thank the panel for an excellent exposition.
A picture, please, sir, before we make a move. Thank you, ma'am. Thank you, gentlemen, for this one. Thank you. Thank you so much. And now, ladies and gentlemen, moving forward from those enthralling sessions to celebrations of the evening. It is time to celebrate the future masters of the legal industry. My name is Aditya Malik. I'm absolutely honored to welcome all of you to the 6th edition of BW Legal World 40 Under 40 Awards. A big thank you to our partners as well. Our powered by partner Iris Value Catalyst, our event partners Atik Shake Factory, Joy Travels Private Limited, Opal Events, Reality Plus, Exchange for Media, IWM Buzz, Impact, Pitch, Fandom, and also Beanley Coffee. Before we invite our guest of eminence on the stage to talk to you about enforcement regulations, new processes, the winners list that I will be receiving in the next couple of minutes, from the time you applied, you submitted a nomination, जब तक ये list हमें दी जाएगी, there's been an entire process of jury members overseeing everything, your interviews, your discussions, the final list framing. We have captured that beautifully in a jury AV. Can you please play the jury AV? Surely, now to talk on enforcement, regulations, new processes, preserving balance in India's legal framework, please join me in welcoming a guest of eminence on the stage, Sanjay Jainji, former ASG Senior Advocate, Supreme Court of India. Please.
The topic that has been given to me, ladies and gentlemen, is the enforcement, regulation, and due process of law, preserving balance in India's legal framework. First of all, I congratulate the organizers for having organized such a interesting function in which, apart from the distribution of awards to the worthy winners, the intellectual stimulants have also been sought to be blended. And I assume that this topic has been interested to me, given the fact that when one of the major regulatory regimes that we see today, that is Enforcement Directorate, it really came into a lot of limelight in the year 2014 with the, and I had the occasion to serve as Additional Solicitor General of India for Delhi High Court, where most of the matters for at least Enforcement Directorate, the initial defense of the government, which was that was prepared and thought about, because prior to that, ED was hardly used, and government also didn't know what defense it would take in different myriad of situations. So as an introduction, I must say that I am not confining it only to Enforcement Directorate. There are other regulatory regimes as well, which need to be addressed. Enforcement, regulation, and due process together constitute the three core pillars of India's legal framework. Rapid economic growth, globalization, and digitalization have dramatically increased the number and reach of regulators and also the enforcement agencies. From SEBI and CCI to the Enforcement Directorate and the nascent Data Protection Board, this expansion has intensified tensions between the demand for strong action against the wrongdoing and also the need to protect individual rights and constitutional guarantees. Enforcement without due process degenerates into arbitrariness. Regulation without effective enforcement becomes purely symbolic and a purely procedural focus, detached from outcomes, risks making the law ineffective. The central task is therefore to preserve a stable balance between these pillars so that the state remains both effective and legitimate. Growing relevance for enforcement and regulation and due process today is the first subtopic that I am required to deal with. Early experience has shown us that merely regulators on papers is insufficient. For example, a 2002 Joint Parliament Committee found that SEBI had launched prosecution for insider trading only in one case during its first decade, underlining that credible enforcement is indispensable for deterrence, and the weak enforcement undermines both market integrity and public confidence. As regulation has become more of an issue, which requires our constant monitoring. CCI's orders imposing large penalties on enterprises, including major technology companies, demonstrates increasing regulatory ambition. However, when CCI denied cross-examination of crucial witnesses in a cartel case, the appellate tribunal and later the Honorable Supreme Court set aside the order for violating natural justice. This episode exemplifies how sweeping regulatory powers must be exercised within a due process framework of notice, access in evidence, and fair hearing. Similarly, a new front has opened in data and technology regulation. Supreme Court in case Puttaswamy recognized privacy as a fundamental right. The DPDP Act of 23 seeks to translate this into an enforceable regime through the Data Protection Board. This board will frame directions, conduct inquiries, and impose penalties in an area that affects almost every citizen and enterprise. The legitimacy of this new enforcement architecture will again depend on its adherence to due process, clear procedures, transparent criteria for penalties, and effective appellate review so that enforcement of privacy rights does not itself become arbitrary. Then we can come to failures and lapses in enforcement regulation and the relevance of due process. Recent history reveals stark failures in dealing with economic fugitives, most notably Vijay Mallya and Mehul Choksi. In Malya's case, large defaults to public sector banks were followed by his departure from India in 2016, facilitated by a diluted lookout notice that was downgraded from detained to informed and subsequently described by the Supreme Court as a blunder. Extradition proceedings in the UK then subjected India's case to intense due process scrutiny, dual criminality, evidentiary sufficiency, and prison conditions, including a video inspection of the Arthur Road jail cell. Despite a favorable extradition order in principle, Mallya remains in the UK. Since 1992, only one person has actually been returned to India under the UK and India extradition treaty. These cases reveal domestic enforcement failures at the point of exit and the difficulties of meeting foreign due process expectations once the fugitive has left. Because there is an enormous gap between our due process regime and the due process regime which other countries at least profess to be following. ED's PMLA enforcement presents another form of failure, this time in the balance between the coercive powers and fair process. ED's dramatic expansion of PMLA investigations, nearly 5,900 cases since 2015, reflects enforcement intent, but a conviction rate below 1%, has led the honorable judges to question whether investigations are thorough and whether the process is, in effect, being used as a punishment, while stringent bail conditions keep many accused incarcerated for years as under trials. With regard to ED, I may also share with the audience that sometimes, speaking from the perspective of ED as a ASG, I face that situation very frequently, that there used to be a lot of pressure sometime, especially in those cases which had caught media attention or which involved a large number of people like home buyers. There we used to face a lot of pressure from the courts to wrap up the investigation in a very short time. And it is during one of that interactions when I had called a very senior officer from ED, and I requested her that the Honorable Court is expecting us to wrap up the investigation in a short time. She told me very categorically that the very nature of ED is such that the investigation would require time, and if we do any shortcut work, ultimately we will not be able to gain the conviction. So that is another perspective that I am putting across you with my own experience. So coming back to August 2025 statement of our former Chief Justice, Justice B.R. Gawai, who pointedly remarked that the ED has been successful in sentencing almost without a trial for years together by jailing them under stringent laws, even if eventual convictions are rare. This prolonged process and harsh bail rules are functioning as a de facto punishment in cases where substantive guilt has not yet been established. It weakens the credibility of enforcement and raises serious questions about proportionality, targeting, and respect for constitutional guarantees under Articles 21 and 22. Environmental regulation, particularly in Delhi NCR, illustrates the opposite imbalance. Detailed regulatory framework exists, but enforcement is weak. The Graded Response Action Plan and the CAQM Act 2021 prescribe escalating measures including construction bans, vehicle restrictions, and industrial shutdowns when air quality crosses certain thresholds. Yet, implementation has repeatedly been patchy. Investigative reports and court observations record ongoing construction during bans, continued entry of prohibited vehicles, and poor coordination amongst agencies. The Honorable Supreme Court described this as a total failure and a knee-jerk approach, with enforcement intensifying only at the crisis peaks. In the present domain, the failure lies not in lack of legal tools, but in their inconsistent application on the ground. Now, focusing on the root causes of failure and lapses, a primary root cause lies in capacity and resource deficits. Police and investigative agencies are often overburdened, undertrained, and operating with limited forensic and analytical support. This increases the likelihood of errors, such as the mishandling of lookout notices or weak investigation files that cannot sustain the conviction at all. Regulatory bodies such as pollution control boards face chronic manpower and monitoring constraints, which translate into low inspection frequency and weak follow-up on violations. Courts themselves are constrained by a severe backlog of over 3.4 crore pending cases and a low judge to population ratio, making delays and adjournments the norm rather than the exception. In such an environment, even a well-designed law and a properly structured regulation is not really going to achieve the desired objective. Political interference and lack of institutional independence constitute another structural cause. The Honorable Supreme Court's characterization of CBI as a caged parrot reflected long-standing concerns which investigating agencies often function under informal executive direction. For example, in the Colgate scam case 2013, the court castigated CBI for allowing government interference in its investigation, confirming opposition allegations that ruling powers often use the agency to shield allies and target rivals. Similar doubts surround ED and other bodies. Where top appointments, tenures, and operational priorities are influenced by political considerations, enforcement can become selective, and regulators may be more hesitant to act against powerful interests. This undermines both effective deterrence and the appearance of fairness that due process requires. A further set of causes arises from outdated legal framework, procedural complexity, and a culture of impunity. For years, India lacked a comprehensive data protection law. Extradition arrangements were not calibrated to contemporary standards, and police and criminal procedure laws retained colonial features that did not match current rights jurisprudence. Procedural safeguards, though essential, contribute to delays. When not matched with the case management and capacity resulting in cases that drag for years, emboldening offenders and exhausting victims. Historically, white-collar and regulatory offenses often attracted minimal sanctions, creating expectations that penalties could be absorbed as a cost of doing business. Moreover, low compliance with civic and environmental rules and a tolerance for small-scale corruption collectively weaken the deterrent effect of enforcement. Now, coming to existing frameworks, which are there to preserve the balance. We can examine the constitutional provisions. The Constitution provides powerful tools to preserve balance through Articles 14, 19, and 21, as interpreted in Maneka Gandhi's case in 1978 and also in subsequent cases. Any law or state action affecting life or liberty must follow a procedure that is fair, just, and reasonable, and must not be arbitrary or disproportionate. This principle underpins judicial review and under Article 32 and 226, allowing constitutional courts to quash unlawful arrests, seizures, and regulatory orders, or to strike down statutory provisions such as 66A of the IT Act when they violate fundamental rights, as we have seen in Shreya Singh's case. In Vineet Narayan, the Supreme Court also issued structural directions to insulate CBI from political influence, demonstrating how judicial powers can be used to strengthen institutional independence in aid of both enforcement and due process. Now, several institutional mechanisms reinforce the accountability and correction, both. So we can speak about SAT for SEBI, NCLAT for CCI, NGT for environment matters, and PMLA appellate tribunals ensure that enforcement and regulatory decisions are subject to expert second-level scrutiny. Now, internal vigilance units such as CVC, NHRC, and state human rights commissions examine the patterns of abuse, including custodial violence and corruption. RTI Act and CAG audits further expose failures and inconsistencies with active media and civil society groups. Legal reforms in recent years have sought to address these specific gaps. These developments, while uneven, do represent the efforts to align enforcement of powers with the contemporary needs and constitutional standards. Now, I would like to conclude straightway coming to a few suggestions, that is with regard to the way forward. Legal and procedural reform should aim simultaneously at efficiency and fairness. This particular aim is extremely important and highly critical. Criminal law and procedure must be modernized to incorporate stricter timelines, structured case management, and greater use of technology, while preserving the rights to fair trial and bail. On the regulatory side, India would benefit from a general administrative procedure framework requiring notice, disclosure of evidence, opportunity to be heard, separation of investigative and adjudicatory functions, and reasoned orders being passed across major agencies. Institutional independence, capacity, and oversight need to be strengthened together. One, I would say, implementing Prakash Singh directives and extending similar principles of tenure security and neutral appointment to central investigative and enforcement agencies would reduce day-to-day political influence, because this is one of the major problems we have been facing, especially even in the Tribunal Reforms Act scenario, where the tenure security, even of the tribunal members, has been seriously compromised. And recently, just before His Lordship's retirement, Justice B.R. Gavai passed an order in relation to the tribunal reforms and setting aside a law which was brought just a few weeks later after the Honorable Supreme Court set aside a similar regime of curtailing the tenure of the tribunal members and other service conditions. So coming back, enhancing judge strength, tribunal staffing, and technical capabilities in agencies will surely improve the quality and speed of both enforcement and adjudication. Regular parliamentary and independent audits of agencies' performance, covering both outcomes, that is conviction and compliance, and processes, that is to say adherence to procedures, patterns of targeting, etc., should be institutionalized and made public. And then cultural and international dimensions must also be addressed. A sustained emphasis on constitutional values and human rights training for police and regulators can reframe the due process as integral to effective enforcement rather than an obstacle. Public legal education and responsible media coverage can also help build support for rule of law based enforcement instead of shortcut instant justice. Internationally, improving prison conditions, evidentiary standards, and compliance with human rights norms will strengthen India's position in extradition and mutual legal assistance proceedings, and aligning domestic frameworks with global standards in financial regulation, data protection, and competition will facilitate trans-border cooperation and reinforce the image of India as a rule of law jurisdiction. So with this, I conclude the topic by observing that the path forward lies in deepening those reforms and fostering a culture that values both effectiveness and fairness. Only by maintaining this balance can India's legal framework deliver on its promise of justice without fear or favor, affection or ill will, in substance as well as in form. Thank you.
Thank you so much, sir, for your address. And now, ladies and gentlemen, it is an honor for me to invite on stage a chief guest and guest of honor for the 6th edition of BW Legal World 40 Under 40 Awards. I have sir's introduction with me. A distinguished legal scholar celebrated for his significant contributions and strong commitment to environmental conservation. A beautiful academic journey marked by a philosophy degree from St. Stephen's College and an LLB from Delhi University's Law Campus Center as well. And very important and very interesting as well, our chief guest for today and a guest of honor is famously known as India's Green Judge for his pioneering use of judicial orders to expand urban forests. He earned the moniker Green Judge by directing litigants to plant over 370,000 trees across Delhi as an alternative to monetary fines or imprisonment. Please join me in welcoming to this very stage our chief guest and guest of honor for today, Justice Najmi Waziri.
ये रोशनी के आदी नहीं है हम, फोकस एंड लाइमलाइट, जो इन्होंने कहा वो सब यकीन करने का दिल करता है, पर इतने आसानी से नहीं मानूंगा। पंछी नदियां हवा के झोंके, कोई सरहद ना इन्हें रोके। सरहदें हैं इंसानों के लिए, सोचो हमने क्या पाया इंसान होके। जावेद अख्तर, फॉर यू। आप सबको दिल्ली और एनसीआर की ताज़ा हवा खूब मुबारक हो। 3 दिन की तकलीफ के बाद बड़ी मोहब्बतों से इन्होंने मुझे गुजारिश की आने के लिए। कृष्ण ने 5 बजे तक फ़ोन करते रहे कि आइए। जब कोई इतना इसरार करता है तो बड़ा मुश्किल होता है। कहा चलो कोशिश करते हैं। इस महफिल में अगरचे एक शख्स भी मेरी बात से मुतासर होता है तो मैं समझता हूँ कि मेरा सफ़र यहाँ तक आने का बहुत मानी खेज रहा। चूँकि आज एनवायरनमेंट की बात हो रही है, लिहाजा मैं उसी ज़बान में बात करूँगा जिससे मैं एनवायरनमेंट को समझता हूँ। अंग्रेज़ी मुझे उस तरह से भाती नहीं है, मेरे दिल के करीब नहीं है जितना हवाएं हैं, नदियाँ हैं, झील हैं और परिंदों की जो गाने होते हैं सुबह उठ के। अब तो बेचारे वो भी छोड़ के चले गए हमको इस शहर से। इतना हमने उसको टॉक्सिक बना रखा है शहर को कि they don't want to be on our window ledge or something. रोज सुबह उठते हैं और इस शहर में और गुड़गांव और फरीदाबाद और तमाम इलाकों से हम लोग की उम्र देखिए, यहाँ पर एवरेज एज 40 साल की होगी, बच्चों को और यंगस्टर्स एंड सीनियर्स को मिला के। कितने बरस और जिएंगे और अपना बचपन याद करिए जिन्होंने इस इलाके में जो you've grown up here, you saw blue skies. We don't know when we'll see that again, except for the roughly 6 weeks or maybe 4 weeks or 3 weeks in a year, बरसात के वक्त सितंबर में। वो भी कब तक रहेगा हमारे साथ हमें नहीं मालूम। कौन जिम्मेदार है इसका? हर चीज क्या हुकूमत पे डाली जा सकती है? मैं नहीं मानता। हमारे हिंदुस्तान के आईन में, द कॉन्स्टिट्यूशन ऑफ इंडिया, इन द प्रियम्बल देयर इज अ सेंटेंस, fraternity assuring the dignity of the individual and the integrity and the assuring the fraternity assuring the dignity of the individual and the unity and integrity of the nation. हमारी और आपकी डिग्निटी क्या है आज की तारीख में अगर फिजा इतनी खराब है? यहाँ पर अमीर और गरीब का कोई फर्क नहीं है। हवा खराब है, शहर की फिजाई आलूदगी है, एयर पोल्यूशन इज सो इंटेंस, इट्स टॉक्सिक, we've gotten used to it. It's only when you put on the machine in your home and you say, अरे 300 के ऊपर है कमरे के अंदर भी, as if it makes no difference to you. These figures every day सुनते हैं आपके, यार 400 हो गया, 500 हो गया, गगन विहार, all those places जहाँ जहाँ है 500 के ऊपर, then you say नहीं कुछ figures कम है इसके अंदर. It's an academic discussion, but what you're taking inside you is poison. It can never come out from you. It can never come out from you. और आपकी अपनी औलाद के लिए क्या छोड़ के जा रहे हैं? अपने बुजुर्गों के लिए क्या आपके लिए शहर में? शुक्र है कि मैं देख रहा हूं सब लोग सुन रहे हैं। ये इंपॉर्टेंट इसलिए है, अगर आप आजाद हैं, आपके पास, you're well off, all of you here, सबसे इंपॉर्टेंट चीज हमें जिंदा रहने के लिए हवा, ताजी हवा, ताजा हवा। कहां से लाएंगे उसको? कोई मैन्युफैक्चर तो नहीं कर सकता बैठ के ना यहाँ पर। एक ही तरीका है मैन्युफैक्चर करने का, ट्रीज, trees and only trees. And to absorb the carbon in the air and all the toxicity, to a large extent you have to have carbon sumps. And what are those carbon sumps? Large green areas. We are a landlocked NCR, National Capital Region. I'm not saying Delhi only. Delhi is not so special. जो दिल्ली में रहता है, गुड़गांव में रहता है, फरीदाबाद में रहता है, सोनीपत में रहता है, मेरठ में रहता है, सबकी कीमत कानून में उतनी ही है। everybody treated equally, और कुदरत सबको बराबर ही मानती है। आप और हम एक्स्ट्रा लैंड पैदा नहीं कर सकते, पर अगर आप अपना उस शहर का मास्टर प्लान उठा के देखेंगे तो उस मास्टर प्लान में हमेशा there are district parks, there are neighborhood parks, those are meant to be absolute green areas. आप अपने पड़ोस में, अपने हमसाये के में देख लीजिए जाके, क्या आपको मौका मिलता है पेड़ लगाने का या उसको देखने के लिए? कभी आपने पलट के देखा है? आपके घर के सामने कोई नई बिल्डिंग बन रही है, आपके पास जो है, how many of you of us actually get the time to go and see कि यार इसको जरा देख लेते हैं, बेचारा अकेला खड़ा हुआ है, उसके गले तक कंक्रीट लगा रखा है, और वो कंक्रीट जिसने वो ठेकेदार ने किया म्युनिसिपल कॉर्पोरेशन का, उसको अप टू द ट्री के सर्कमफ्रेंस तक उसको जो है उसका वो नापेगा, उसका पैसा दिया जाएगा। ये गलत है। 1 मीटर तक तो आप कंक्रीट लगा ही नहीं सकते, तो जो नाप के दिया तो सरकार ने पैसे ही देना चाहिए ना उसका। तो एक ये है। पर आप में से और हम लोगों में से कितने लोग हैं जो अपने सामने या अपने मोहल्ले, अपने सड़क पे, अपने हमसाये के पास जाके किसी भी दरख्त को उठा के थोड़ा पानी दे सकते हैं? कहाँ से आएगी हवा, ताजी हवा हमारे यहाँ? कहाँ से आएगी ताजा हवा? कोई और तो देगा नहीं। अदालतों ने क्या किया? क्योंकि talking about what the courts have done, how the courts orders make an effect to all of us throughout the country. अविरल गंगा की जो कहानी शुरू हुई थी सन 80 के दशक से शुरू हुई थी कि हमारे गंगा की जो पानी और जो बहाव है वो कम नहीं होना चाहिए और स्वच्छ होनी चाहिए। आज 40-45 साल के बाद भी हम उसको देख रहे हैं। फर्क हुआ है या नहीं हुआ है, आप खुद उसका जवाब दीजिए। There should not be too many dams on it. There should not be disgorging of your municipal sewage inside it. Toxic effluents from the factory should not be poured into it. How far are we successful? We have to ask ourselves. किसी पे उंगली नहीं उठाया जा रहा है, लेकिन क्या हम उसी पे हाथ धर के बैठे रहेंगे? नहीं, आप अदालत के पास जाएंगे। ये कोशिश और ये मुहिम तो हर एक इंसान की, हर हिंदुस्तानी की है, जो चाहे वो गंगा से मुतासिर हो, गंगा के लबे गंगा हो, लबे जमुना हो, चाहे गोदावरी के पास हो, हर एक जो हमारी नदी है उसको हम देखेंगे। दिल्ली में ही कितने सारे तालाब थे, ताल तलैया थी यहाँ पर, कहाँ गए सारे? इसी गुड़गांव में कितने थे यहाँ पर? मद्रास हाई कोर्ट ने बहुत अच्छा फैसला दिया है कि उस शहर में 300 जितने 100 थे, वो वेयर आर दोस वाटर बॉडीज, वेयर हैव दे गॉन? तो वहाँ कोशिशें की जा रही हैं कि उनको रिवाइव किया जाए। रिवाइव के लिए दिल्ली में भी कोशिश हो रही है, बट इट्स अ वेरी वेरी स्मॉल स्लो प्रोग्रेस। हर शख्स को एक जागरूक नागरिक की तरह से, वी हैव टू विजिलेंट एवरी टाइम टू लुक फॉरवर्ड एंड टू प्रोटेक्ट आवर ग्रीन्स, प्रोटेक्ट आवर वाटर। मैं आपको एक और सुनाता हूँ। अगर हमारे ग्रीन्स नहीं रहेंगे ना, तो जो रन ऑफ ऑफ वाटर रहता है वो और नदी में जाएगा, हमारे जमीन में एब्जॉर्ब नहीं होगा, और जमीन में एब्जॉर्ब नहीं होगा तो हमारे वाटर टेबल और नीचे गिरता जाएगा। कहाँ से लाएंगे पीने का पानी हम? कुछ साल पहले तक तो ये था कि दिल्ली की ठीक हो जाएगी, फजा ठीक हो जाएगी, इलेक्ट्रिक कार्स आ जाएंगी और पब्लिक मास ट्रांसपोर्ट मोबिलिटी हो जाएगी। कुछ हुआ? होते हुए नजर आता है किसी को? प्लीज थिंक 5 years hence, not 10 years or 20 years. Please look at the National Capital Region Planning Boards. Go to the site and see the plan for the National Capital Region. It's a 1985 Act. It takes under it 25 regions, 25 districts, 24 districts, 14 from Haryana, 8 from UP, 2 from Rajasthan, and all of NCT of Delhi. 55,000 स्क्वायर किलोमीटर का एरिया है ये। आबादी कितनी होगी इसकी तकरीबन? मैं आपसे पूछता हूँ, इतने सारे सबको मत, सारे सिटीज को मत जोड़िए, सिर्फ दिल्ली को सोचिए। दिल्ली में कितनी आबादी होगी? दिल बड़ा रखिए। There you are. I heard Mr. Jain say this 2 days ago somewhere. और उसमें आप जोड़ लीजिए फरीदाबाद, गुड़गांव, नोएडा, सोनीपत, गाजियाबाद, कितनी आबादी हो गई? 8 करोड़ मिनिमम। पूरे ऑस्ट्रेलिया की आबादी कितनी है? 2.76 करोड़। कितनी जमीन है हमारे पास इस सारे इलाके दिल्ली में? लेस देन 1500 स्क्वायर किलोमीटर दिल्ली की। पूरे एनसीआर की 55,000 स्क्वायर किलोमीटर। ऑस्ट्रेलिया 2.7 करोड़, एंड अब लैंड एरिया कितनी है उनकी? 77 लाख स्क्वायर किलोमीटर्स। हमारी जो मुश्किलें हैं, हमारी चैलेंजेस बहुत गजब की हैं। उसके लिए हमेशा हम सबको कोशिश करनी पड़ेगी। ये सरकारों पे और अदालतों पे और सिर्फ हुकूमत पे इल्जाम रखना ये मुनासिब नहीं है। इसलिए मुनासिब नहीं है कि हम सब, हर शख्स यहाँ पर जो है और जो नहीं है, वो किसी न किसी से जिम्मेदार है इस शहर की फजाई आलूदगी और पानी ना होने को खराब करने का। क्यों? आप पेड़ क्यों काटते हैं और पेड़ क्यों नहीं लगाते? अगर 3 करोड़ लोग दिल्ली के और इस इलाके के 8 करोड़ लोग लगाते हैं पेड़, 8 करोड़ पेड़ तैयार हो गए ना आपके लिए। दिल्ली में जो कोशिश की गई कि फैसलों के जरिए किसी पे हर्जाना और किसी पे फाइन लगा के and letting that money go into some fund, this fund and that fund, you never know when that fund will be used, what the money is there for. It's just gone in some quiet corner. But when asking for a citizen, that litigant who's there, to go and do something which will bring benefit to your society, to your city, you know what happened? What used to happen? That citizen felt empowered. That citizen felt कि यार मैं अपने शहर में जाके कुछ पेड़ लगा सकता हूँ. फिर वो देखता था 6 महीने के लिए. उसको लगता था मैंने just participated democracy. He felt जमीन से जुड़ता था वो शख्स. चाहे अपने मोहल्ले के सामने पार्क में या फॉरेस्ट लैंड में, कोई नई जमीन नहीं, फॉरेस्ट लैंड में जाके करिए. मुझे एक वाकया याद है. एक क्रिमिनल साइट पे एक मैटर था. एक शख्स को हमने कहा कि आप 100 पेड़ लगा दीजिए. He was very happy. FIR क्वाश हो गया, चलेगा, कर दिया. क्यों लगाया? क्यों पेड़ लगाने के लिए कहा गया? वो हर्जाना उनको दिलवाने से फायदा तो था नहीं ना. आपस में माफी मांग ली, किस्सा खत्म. But to expiate for that wrongdoing, अपने आप से माफी कैसे कोई मांगेगा? अपने आप से. मेरा जो 5 साल 7 साल गुजरा है इस मुश्किल से, पुलिस केस और उनको तंग करना, वकीलों को ले आना, अदालतों में पेश होना, केस खत्म हो गया अदालत के अंदर. अपने आप से कैसे माफी मांगूंगा? तो ऐ हुजूर, आप जाके अपने शहर में, ये फॉरेस्ट लैंड है, यहाँ पर इतने पेड़ लगा दीजिए. ये शुरुआत वहां से हुई है 2018 से. ऐसे सैकड़ों केसेस हुए, सैकड़ों. और बढ़ते बढ़ते 3,70,000 केस ऐसे ऑर्डर्स हुए केस पेड़ लगाने के लिए. That gentleman came back to the court after a few days and he said, sir, I would like to plant 500 trees. Mr. Jain, I said, kya baat hai? And he said, I would like to plant 500 trees and to take care of them for 1 year. Please allow that I can take a tanker of water to water these trees. I said, please do it by all means. When you let citizens take charge, they become the change. I was not heading a green bench. There's no such thing as a green bench. It's a red court. How do you make the citizens participate in their lives, in the society में कैसे कर सकते हैं? ये तो हर शख्स कर सकता है. अगर आप वहां बैठे होते तो शायद आप भी यही पहल करते. फ्रेटर्निटी, बरादरी, हमारी जो मैं करूंगा ना, उसका असर मेरे पड़ोसी के ऊपर होगा. आप अपना कूड़ा, गंदा, मैल जो भी है, अपना पानी मेरी तरफ मत करिए. गर्चे पंजाब में है या मध्य प्रदेश में है या कुछ भी वहां पर होता है, वो हवा उड़ के यहाँ पर आए. दिल्ली वाले सिर्फ दिल्ली की क्यों शिकायत करते हैं? क्या दिल्ली की प्रदूषण नहीं है और बाकी शहर में नहीं जा रहा है क्या? सुरखाब के पर नहीं लगे हैं यहाँ के रहने वालों के लिए? तो सिर्फ अपनी ही ना रोइए बैठ के. लिहाजा कोशिश हम सबकी है इसके अंदर और होनी चाहिए. और देखिए, मैं आपको बताता हूँ, दिल्ली में लोग कहते हैं कि हाय हाय होती है कि जगह नहीं है, जमीन नहीं. जमीन इतनी है कि आप हैरत करेंगे. If 28% of Delhi is green or is forest land, then 1483 स्क्वायर किलोमीटर में कितना हो गया? आप खुद ही जोड़ लीजिए. तकरीबन 500 के आसपास आ जाता है आपका. 450 स्क्वायर किलोमीटर ग्रीन एरिया हो गया. ये प्योर ग्रीन एरिया है, फॉरेस्ट एरिया. फिर PWD के पास लैंड है, सड़क के बगल में आपको लगाना है. फिर DDA के पास लैंड है. 17 एजेंसीज मैं गिनवा सकता हूं आपको दिल्ली में. 3 लोकल सेल्फ गवर्नमेंट्स, NDMC, MCD, Cantonment Board, then you have LNDO, then you have central government, then you've got Delhi government, Gaon Sabha, PWD, you do say, I mean, there's 17 agencies, army, everybody holds lands there. I mean, there are so many organizations. अगरचे आप पेड़ लगाएं, you are the owner of an O2 startup. लगाइए और फिर देखिए उसका असर, उसका अंदाज. I've had the benefit of going through this myself. खुद लगाया और 10 साल से देख रहा हूँ करते हुए इसको. जिस वकील, मैं अदालत में आप जिक्र करता हूँ कि कोर्ट में अक्सर हम अपॉइंट करते थे कोर्ट कमिश्नर्स को कि जाइए देखिए कि ये साहिबान जो हैं, अफसरान कहते रहे हैं कि यहाँ पर हमने इतने पेड़ लगा दिए, ये हो गया, वो हो गया. प्लीज गो देयर टू असिस्ट देम एंड आल्सो टू वेरीफाई. यकीन मानिए इतना फर्क पड़ता था we would be taking satellite, monitoring it by satellite photographs. 1 साल, 2 साल, 3 साल कितना change हुआ है. Then drone photography, and then वहाँ पर जाके at the site lawyers would go there and take photographs and come back and give their reports. That's the kind of strict and strong monitoring we were doing in court. उससे फर्क ये हुआ कि कई जगह पे दरख्त बढ़ गए, वहाँ की फजा बदल गई, लेकिन वो बहुत ही समझ लीजिए एक कतरा सा अभी कोशिश हुई है. 3,70,000 पेड़ अगर हमारे जिंदा रहें, उसके बाद जस्टिस सिंह ने भी कहा है 10,000 पेड़ लगाने को वो लगे हैं. पिछले साल हमने बताया, PW ने लगाया उन्होंने. अब 10,000 पेड़ का फर्क बताइए कितना होता है. Now 10,000 पेड़, and I'll give you four of big parks in Delhi. Everybody knows Lodi Gardens, 80 acres, 5,400 trees. Nehru Park, 75 acres, 3,400 trees. Talkatora, 48 acres, 2,000 trees. Sanjay Jheel Park, 16 acres, 1,600 trees. 5 ऐसे गिनवा देता हूं आपको, कुल मिला के 10,000 बनते हैं, 11,000 इतनी जगह पे. और जस्टिस जसमीत सिंह का एक ही ऑर्डर, 10,000 पेड़ PWD को कहा जाके लगाइए. गर्चे उसमें से 60% भी जिंदा रहते हैं. फर्ज कीजिए अट्रिशन रेट होता है, 60% भी जिंदा. 6,000 पेड़ का कितना फर्क पड़ेगा आप सोचिए जरा. इस चिलचिलाती गर्मी में, फिजाई आलूदगी में आप गुजर रहे हैं. फिजाई आलूदगी है पोल्यूशन. आप वहां से गुजर रहे हैं, and the sound levels are so high, you're oppressed. Your driver is oppressed. You can't drive. So इसको कम करने के लिए किसकी जिम्मेदारी है? कुछ हमारी है, कुछ हुकूमत की है. अगर हम खुद करें कोशिश तो बहुत फर्क पड़ सकता है. इसीलिए मैंने वर्ड फ्रेटर्निटी से शुरू की थी ये बात को, कि हम जो करते हैं उसका हमारे हमसाये पे असर होता है. मैंने लिख के कुछ, I was trying to jot down a whole lot of things, but I suppose I've run out of time. And इस टाइम सुबह से शाम तक लोग बैठे हुए हैं. कितना आपके जहन में गया, कितना नहीं गया मैं नहीं जानता, बट हमारे शहर में इतनी जगह है, बोथ दिल्ली एंड गुड़गांव के बीच में, ये तकरीबन जो 16,000 एकड़ ज़मीन जो फॉरेस्ट बोलती है, उससे कहीं ज़्यादा द मॉर्फोलॉजिकल रिज में है. बहुत बड़ा एरिया है. अगर वहाँ पेड़ लगा देते हैं तो मैं समझता हूँ कि 2-3 शहरों का बहुत फ़र्क हो जाएगा. ये सिर्फ मैं दिल्ली के एरिया को बता रहा हूँ. अगर उसमें फरीदाबाद और गुड़गांव का भी रिज एरिया ले लीजिए तो तकरीबन 40,000 एकड़ ज़मीन हो जाती है. That's a huge land. One central park of New York makes so much waves. न्यूयॉर्क में सन 70 के दशक में 1 million trees लगाया था, because it was a very polluted city. They were burning coal and other kinds of fuels there. I haven't been to the city, but I'm told it's clean, fabulous air, despite it being, उस ज़माने में इतनी प्रदूषण थी, despite it being next to the sea. But now they're reaping the benefits of those trees which were planted 50 years ago. We have to look beyond ourselves. अगले कई generations के लिए सोचना पड़ेगा हमको. और I feel that nobody is powerless. हमारे अंदर इतनी ताकत है. हर शख्स अगर ये देखे कि मुझे पेड़ लगाना है हर साल, चाहे मेरा बर्थडे हो या अम्मा अब्बा के जो है आपके उनकी यादगार पे हो या किसी और की इश्यूज पे हो, आप लगवाइए और उसका ख्याल करिए. That's the only way to save your city. और सरकारों का जहाँ गलत हो आप अदालत के पास जाइए. If it was not for the Aviral Ganga orders, if it was not for MC Mehta's orders, in orders of the Supreme Court and MC Mehta, if it was not for the Taj Trapezium के orders नहीं होते तो उस इलाके में बहुत कई डिस्ट्रिक्ट से जुड़े हुए जितने लोग थे उनकी रोजी रोटी पर असर होता. Because the beautiful sites which you have there, उसकी tourism खत्म होता. Artifacts जो बनते हैं उन पे असरात होते हैं लोगों के. It's not just the order of the court with respect to इसको यहाँ पर stop the pollution around the monument. दिल्ली से of this golden triangle, दिल्ली से लोग कतरा क्यों रहे हैं? दिल्ली, आगरा, जयपुर. दिल्ली का आहिस्ता आहिस्ता नाम क्यों हट रहा है वहां से, या लोग इसको अवॉइड क्यों कर रहे हैं? अरे भाई, अक्टूबर से लेके फरवरी तक तो इट वाज द बेस्ट मौसम फॉर दिल्ली। अब ये शहर बढ़ता बढ़ता दिल्ली और गुड़गांव कहाँ जुड़ गया पता ही नहीं चला। आप देखिए ना, तो हम सबको मिलके एज वन यूनिट ही काम करना है इसके अंदर। बहुत सारी चीजें जहन में हैं। आज के लिए सिर्फ इतना ही है कि आपके हाथ में बहुत ताकत है। जाने से पहले एक सुनाता हूँ कि ये टी.एन. गोदावर्मन का जो केस है ना, उसमें एफिडेविट फाइल हुआ था सन 1997 में। हैरत होगी सुन के आपको कि ऑल ऑफ मथुरा रोड इज शोन एज अ ग्रीन पैच। मथुरा रोड इज अ ग्रीन पैच and there is so much land which is land owning agencies Delhi is mentioned there। और गुड़गांव जैसा एक्सपेंसिव थोड़ा ये दिल्ली, इधर से पूरा का पूरा हरियाणा बढ़ता जाता है, पूरा उत्तर प्रदेश उधर है। जमीन की कमी नहीं, हमारे दिल्ली में जमीन की कमी है, बट गुंजाइश बहुत है। एमसीडी के पास सैकड़ों पार्क्स हैं, डीए के पास इतने सारे एकर्स अपॉन रोलिंग एकर्स उनके पास डिस्ट्रिक्ट पार्क्स हैं। इसी गुड़गांव में जाकर देख लीजिए, गुड़गांव मास्टर प्लान, सारे वकील साहबान बैठे हुए, कल को उठा के देखिएगा मास्टर प्लान कि आपके पास जो डिस्ट्रिक्ट पार्क है उसमें एक्चुअली आधे ट्रीज या कोई अफीम खा के पड़ा हुआ है यूं ही। इट्स रिस्पॉन्सिबिलिटी इज आवर्स। सरकार अचानक से आके नहीं कर सकती है उसको। आपके लिए और मुझे मौका देने के लिए बहुत शुक्रिया। थैंक यू।
Thank you so much, sir. Thank you. Usually हम ये सवाल पूछते हैं, but let me ask you because I am going to do it for sure. Going back home and realistically, कोई ऐसा है जो एक plant लगाएगा? आप में से कोई भी? Like I'm going to do my bit for sure. I will. I promise myself. On New Year's, 40 trees. Lovely. बढ़िया. We've got approximately 60, 70 trees here. Very good. Chalo, that's a happy start. Yes, sir. Another happy news because आप सब और मैं भी उसमें हम इतने उत्सुक हैं। 15th of March, we are going to have a plantation drive, which Justice Waziri is going to be leading. You can take more details on this. You'll get more details on this. We'll make sure the platform of ours promotes it. It's a lovely thing to be a part of. And we would request you to please also join us there. But before that, do start your bit. Like all of us, 70-80 पेड़ पौधे तो मुझे यहाँ पे we managed through. But lovely, let's just applaud for that. That we're all together. We are in sync for this. इसी खुशी के मौके पे, to open the award ceremony, let's please welcome on stage for the opening address, a quick and short one. I have to say it, otherwise he will not. Dr. Anurag Batra, Chairman and Editor-in-Chief of Business World and the founder of Exchange for Media Group.
There's water in that. I'm just checking with him. Only water. Good evening. I think we do a lot of events and sometimes I get carried away. I talk like you about things that you talked about, but with your track record of doing what you've done, I think the thought that you planted today, I'm sure this is a very conscientious of young leaders and people like me also will follow and do something. So please give Justice Waziri a big round of applause because really, I mean, it's the most important thing we can do. Otherwise, what will we do with the wealth that you are creating? Or, you will have some of your children, you'll have more children, your parents are getting old. I don't want to stay between you and the awards. I just want to welcome Justice Waziri, Mr. Sanjay Jain, Mr. Mukesh Bhatani, Mr. Shashank Vajpayee, Ms. Seema Jingal Naluwalia, Mr. Vivek Narayan Sharma, my senior colleague, Mr. Harbinder S. Narula, all the leaders of the legal fraternity. First of all, I want to congratulate Krishnendra for putting this together. Please give him a big round of applause. He's very brave. He's come back and started working again with me. So I just want to say that we in the media can do a better job in talking about environment, sir. 7 years back, we started ranking India's top company on sustainability. It's called India's most sustainable companies ranking, and we do it very credible partners who have high domain expertise and knowledge. I just want to say that I read a cover of Time magazine 2.5 years back, and it was about oceans and how the dwindling oceans are bad for us. And I'd gone, my daughter was speaking at a UN conference 3.5 years back, and I was there. I met the admiral who was also speaking, and he talked about how oceans need to be protected. And this happened within 2-3 months of, I read the Time magazine, and then I heard his lecture, and I started to research him, and I realized that the mammals that are at the bottom of the ocean, their population is, coming down. It's very bad for humans because they absorb so much carbon dioxide, which makes the air in our lives better. So I won't go into that, but the things that he's talking of are real. I promise to make you meet People Baba. Is somebody I met 25 years, 24 years back, and he's planting tree. I don't know the number, but you can Google him, figure out 4 crore trees he's planted, 4 crore trees. So, we'll bring him to meet you, sir. But I just want to say that the BW Legal World 40 under 40 is a list. This is the 6th year. I did talk about in the morning that the first year when we started in 2020, 2019, 2020, we had a Dream 11 kind of a jury. We had Justice Narasimha on the jury. I requested him to be jury chair. He was not a judge that time. Mr. Shardul Shroff, Mr. Ryan Karanjewala, Mr. Rajiv Luthra, the late Mr. Rajiv Luthra, Mr. Lakshmi Kumaran Sita Raman, right? Am I right? Sridharan, right? And the other 8 people also were like that, right? And I remember sitting through the jury process. They told me, Anurag, you don't know anything about law. You will not judge anything. I said, okay. And Justice Narasimha said, I don't want to be a jury chair. I want Mr. Shardul Shroff to be jury chair. And I have to tell you that that whole day of deliberations was a learning experience for me. And there are many winners today who applied for the 3rd time and won 3rd time. So I just want to say, some of you may have applied for the first time, they've won. I just want to say one thing. Some of you have brought your parents, families together. And I just want to say this. I read this book called Fluke. Iska matlab tukka. It's written by a social scientist called Brian Klaus. And let me not use the word fluke. I don't like the word accidental fluke. But I like the word serendipity, luck, chance. If you're a Hindu, prarabdha, preordainment. But the success that you're getting today is not just because of you. Of course, it's because of you, but it's because of the good work that your parents have done, your ancestors have done, people around you have done. I've been part of building 2 organizations, but I may head those organizations, but it has happened because people like Krishnendra, Tanvi, many other colleagues, Prashant, they do fantastic work. So I just want to say that you're a very accomplished professional. You're 40 under 40. It's an honest process. I keep saying there are only 3 people who are perfect, Mr. Bhutani. Lord Shiva, Seema, my wife Neeti, I mean, you know her well, and maybe Mr. Modi, but nobody else is perfect, right? So I just want to say it's an honest process. No process for awards is perfect. So you won through an honest process. We have a locus standi, we are an editorial product, and we are proud of the way we run our jury process. So congratulations in a world where you can buy almost everything. Almost everything. I know I'm amidst a legal fraternity. Sadly, I'm saying this, but you can buy almost anything. Our awards you cannot buy. Okay, I am saying that, I'm making that, and look at the jury members who attested to give awards. Mr. Pranav Mehra is also here. I forgot to acknowledge you. So I want to congratulate you, and I want to repeat, this was for younger people who are 30 and 30 in the morning, but some of it is true. But only I'll talk about the 3 G's that you should follow, which I try and follow. And the first G is what I call gratitude. I have come here because of lots of people have helped me, younger than me, older than me. They're kind to me. So I express my gratitude. And I have told this story before at forums that when I was 12 years old, I have an older sister, Her name is Sukurti, but her nickname is Bittu and my name is Anurag. So my nickname is Anu. So my mother would tell me when I was 10 or 11 or 12 that pray to God that your ears are okay, eyes are okay. And I would tell my Bittu दी कैसी बातें करती है मम्मी, मैं भगवान को thank you क्यों बोलूं? But I think today I am grateful that somebody like Justice Waziri said what he said and delivered a speech which is very real and it comes from experience, and all of your gratitude to your environment, to God, to your ancestors, to friends, to people who cannot do anything for you. They can only give you blessings, but they're blessed. Second is grit. You know, I'm a first generation entrepreneur. I started it. Came from India. I remember I had a litigation that Lex Counsel and Mr. UK Chaudhary handled, and that is what built my life because we won in that. And Seema, gratitude to you, Alisha and Dimpy and Alfred for helping us on that. Is grit. Never lose hope. The two most important words in life are umeed and koshish. I really believe that. There are days when I'm low energy, but I never give up on hope. And I'm always in the play. But one word that I learned, which I believe is the most important, is the third G, which is grace. And I keep saying that grace will take you to places that hustle can't. So if you have grace, Ishwar ki kripa, Allah ki kripa, you know, I don't know Urdu like you, sir. My father reads it very well and he writes. But I will only say my gratitude to Justice Waziri, all the jury members, all of you for being here. I wish you luck and may you continue to do well. I want to end by saying that we are living in an era of AI, and we are not talking about the side effects of AI, because AI means more computing, which means more pressure on water, because huge computing power, more pressure on electricity, more pressure on local resources. As India tries to stay ahead in the AI war, and we will, and we must, because if we don't, then our nation would not have that competitive advantage. I think we must consider the impact it has on environment. If clean air is not the most fundamental right we have, I don't know what will matter. So I think today's address, I wish I'd met you earlier, so I heard about you and know about you. But I'm glad I met you, and I will take up. I'm an action-oriented person. You know, I was born in Haryana. They don't think even after doing an action. So thinking before is not so. If you planted a thought in my mind, I'm sure I'll do something about it. So thank you for reinforcing that thought. And I do want to take a pledge from all 40 winners. Can you plant 10 trees each? Can you plant 10 trees each? Yes or no? Will you plant 10 trees? Say it emphatically, yaar. Okay, so I will follow up with you to see if you planted those trees. If you plant more, it's your, it's something good comes back. So congratulations once again to you, to your families, to the companies that you represent, because your success is shared success. Thank you. God bless you.
Thank you so much, Dr. Batra. As an artist, Justice Waziri, does anything that I can lend my voice to for such initiatives? It'd be an honor for me, sir. I promise you that. That's on me. Chaliye ji, now for the awards. Any picture, any view, any opinion that you share online, please do use the hashtag BWLegalWorld40 under 40, where 40 is numeric and under is only a U, which is always the U. After receiving your award, when you step down from the stage, please proceed to stage left to receive or to get a picture, and then also stay back till the end for a group picture, both for editorial purposes. Jis bhi winner ne winner's bite nahi di hai, please also do the needful, which is happening right outside this very hall. And then, of course, dinner awaits us and weekend is here. Chaliye ji. To present the first set of awards, let's welcome our presenters on the stage. First, Dr. Anurag Batra, Chairman and Editor-in-Chief of PW Business World and founder of the Exchange for Media Group. Joining him is Justice Najmi Waziri, former judge, Delhi High Court. Joining them is Shashank Bajpaji, LLM, IRI Central Government Standing Counsel, Delhi High Court, and also Counsel for Union of India, Supreme Court. Gentlemen, joining them is Mukesh Budani, Managing Partner of BMR Legal. Please. Chaliye, time to reveal the winners. The first person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Okay. Abhinav Mishra, founder, Chambers of Abhinav Mishra, advocates and solicitors.
Yeah, please give Abhinav a big round of applause. Kanjusi to mat karo. There is no GST on clapping.
Congratulations. Moving ahead, the next person to join the power list of BW Legal World 40 under 40 lawyers and legal influencers. Aditya Ganju, partner, AG Chambers. Congratulations. Moving ahead, the next person to join the power list of VW Legal World 40 under 40 lawyers and Aditya Gupta, Principal Associate, JSA Advocates and Solicitors. Aditya, everybody. Winners, a reminder, individual picture, group picture in the end, winner bites as well. With that, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Modalika Bose, partner, competition law, Sandyok and Mahajan advocates and solicitors. चलिए जी आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Garg Vyas, Senior General Manager, Legal, Humans India. Congratulations. चलिए जी आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Manendra Singh, partner, economic laws practice, ELP. Manendra, everybody. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Ashutosh K. Srivastav, partner, SKV Law Offices. Ashutosh. आगे बढ़ते हुए, the next person to join the power list of PW Legal was 40 under 40 lawyers and legal influencers. Amandeep Singh Virk, partner, JSA Advocates and Solicitors. Congratulations. आगे बढ़ते हुए, the next person to join the power list of PW Legal World's 40 under 40 lawyers and legal influencers. Amit Gupta, partner, Saraf and Partners. Amit, everybody. Congratulations. आगे बढ़ते हुए, the next person to join the power list of PW Legal World's 40 under 40 lawyers and legal influencers. Arpan Bahel, partner, litigation and dispute resolution, economic laws practice. Congratulations, Arpan. Thank you so much, Justice Waziri, Shashankji. Okay, so thank you so much. Once for them, please.
This is the time to acknowledge people who've led the way. Sorry, यहाँ तो सब legal world के लोग थे. From the world of environment, एक छोटी सी कोशिश ने पूरा माजुली आइलैंड को बचाया. शख्स का नाम क्या है? Check your cell phones and find out. कौन सी आइलैंड? माजुली. जाधव पायेंग. एक किसान कह सकते हैं, हर रोज बीज अपनी जेब में लेके जाता था और वहाँ इलाके में लगा. आज बहुत बड़ा लहलहाता हुआ वो जंगल है वहाँ पर. एक वकील जिसका नाम है अफरोज शाह, उसने बरसोवा बीच को साफ किया. शहर में, शहर के आसपास एक सज्जन है, उनका नाम है पीपल बाबा. उन्होंने कितना काम किया. इसी शहर में बहुत सारे, दिल्ली में खास तौर पे बहुत सारे सिटीजन्स हैं. You know, they're doing so much work in the field of conservation and taking the green forward. I thought आज मौका है, अगर BW Legal जो भी है आप करना चाहें, you can also become an entity in this area. Lead the way, lead the way.
Thank you so much. Please request Sanjay Jainji, former ASG, Senior Advocate, Supreme Court of India, along with Mr. Sunil Sood, Assistant Vice President, Intelligence Iris Consulting, along with Mr. Harbinder Narula, CEO of BW Healthcare World and BW Wellbeing World, to please join us on the stage and help us present the next set of awards. आइए. चलिए आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Ashwin Nair, partner, JSA Advocates and Solicitors. Ashwin, everybody. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Deepika Narayan Bharadwaj, Director, Ekam Nyay Foundation, a journalist, a filmmaker, and also a social activist. She's being also joined by her family, who especially come from Greater Noida. This I know. That's very far. Daughter? Is it?
Yeah, I think there are only two winners I really know well. In the one I met only a month back. I've known Deepika for 15 and a half, 16 years. We used to work together. Deepika runs this Ekam Nyay Foundation, which helps men fight false rape cases, false dowry cases, harassment to get financial gain. And I've known her. She has two qualities which help her and don't help her. One is she's absolutely selfless. Second, she's very non-commercial. So she has the Ekam Nyay Foundation. Since Justice Waziri is talking about the right causes, this is, you may want to engage with Deepika and maybe want to contribute to her cause. I do want to acknowledge her presence. So God bless you, Deepika.
Your family is here.
I just want to acknowledge my father, my mother, my bhaiya, my bhabhi, and my sweet little Gungun. They've come from Gurgaon, from Greater Noida, just to see me winning this. And winning this award means a lot to me because I've been working for the last 13, 14 years selflessly, and 40 under 40 means a lot to me. Thank you so much, Anurag sir. Thank you so much, sir. Thank you, sir.
Thank you, uncle. Thank you, auntie. Hi, Gungun. Congratulations. She's very happy. So, Deepika, individual picture, don't forget that. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. The associate partner, Rajani Associates. Dikshat, everybody. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Megha Upadhyay, a partner, JSA Advocates and Solicitors. Megha, everybody.
Lawyers don't charge for clapping yet. So can you? Because the goodwill you're building for yourselves by clapping will be there for you when you're on stage. So can you give Megha a bigger round of applause?
Thank you. इसी खुशी के मौके पे आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Mrinal Sharma, partner, Shardul Amarchan Mangal Das. Congratulations. Winners reminder, individual picture, group picture in the end, your winner bites as well. इसी के साथ the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Niyati Narayan, Principal Associate, JSA Advocates and Solicitors. Niyati. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Nishan Sogani, partner, Chandiok and Mahajan Advocates and Solicitors. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Prabhakar Tiwari, Associate Partner, KNM and Partners Law Offices. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Pranay Bhakti, partner, Touchstone Partners. Pranay. Congratulations. इसी के साथ the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Pratik Sethi, Assistant Vice President, Legal, Bharti Group. We've got 5 members on the stage and only 4 guys clapping from the audience. इतनी नाइंसाफी तो मत करो. Thank you. Thank you so much, Mr. Sood, Mr. Narula. Thank you. Mr. Jain, we need you for a little longer, sir. My request. We also request Saurabh Ajay Gupta ji, former additional advocate general for Punjab and Chhattisgarh, to please join us on the stage, sir, and help us present a next set of awards. We're halfway through a list. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Priyan Garg, Senior Manager, Marketing Communications, Cyril Amarchand Mangalas, Advocates and Solicitors. Everybody. The music is just to add to your claps, not to substitute it. if you thought so. चलिए जी आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Rahul Ingmori, co-founder and managing partner of Wiz Legis Law Practice Advocates. Rahul, congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Ravi Vaswani, founder, Zentrum Law Partners. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Rohan Batra, partner, Anagram Partners. And congratulations. Congratulations, Rohan. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Rohit Jolly, associate partner, Hammurabi and Solomon Partners. Congratulations, Rohit. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Shalini Sati Prasad, a partner, JSA Advocates and Solicitors. Congratulations. आगे बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Sasank Agarwal, founder, Legal Advocates and Corporate Law Consultants. Shashank, everybody. Thank you so much, Saurabh ji. Thank you so much, Mr. Jan. Thank you so much. Thank you. Please. I now request Vivek Narayan Sharma ji, arguing counsel, advocate on record, Supreme Court of India, along with Pranav Mehra ji, Senior Director, Legal, Freshworks, to please join us on the stage and help us present our next set of awards. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Shubham Avasti, Advocate, Supreme Court of India. Congratulations. Winners, reminder, individual picture, group picture, your winner bites as well. इसी के साथ, and Shubham just forgot his group picture, I guess. Chalo, next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Sucheta Bhattacharya, partner, JSA Advocates and Solicitors. Sacheta, everybody. Congratulations. We're down to our almost last 10 winners. My only request you, जो जोश आपने starting में दिखाया था, जो आप अभी भी दिखा रहे हैं, please also keep that going till the last winner. We should not do injustice to that. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. What? Sohail Budan, partner, SKV Law Offices. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Sumer Sori, partner and advocate on record, VSA Legal. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Tushar Agrawal, advocate, Supreme Court of India, founder and managing partner, Juris Advocates and Solicitors. Congratulations. इसी के साथ, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Varun Singh, founder and managing partner, Foresight Law Offices, India. Congratulations. With that, the next person to join the power list of PW Legal World's 40 under 40 lawyers and legal influencers. Varun Bajaj, co-founding managing partner, head venture capital and private equity, M&A General Corporate, RST Bajaj Global Law Firm.
I think he's not looking happy. I told Varun, you're not getting married, you're getting an award. So look happy. Varun, you're getting an award. And you know, he's such a nice person. I met him in 2019 at the first awards, Law Firm Awards, and Justice Sikri was the chief guest, 12th December 2019 at the Imperial. And subsequently, he's applied. This is the third time. And he just turned 40. So if he hadn't won, I would have felt bad. But there are multiple people between 30 and 40 lists that have won, that have applied multiple times and have won in multiple attempts. So give Varun a big round of applause.
Congratulations. With that, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Zishan A. Khan, partner, Luthra and Luthra Law Offices. Thank you so much, Pranav sir, Vivek sir. Thank you, gentlemen. Thank you so much. Once for them, please. May I once again request Harbinder Nirulaji, the CEO of PW Healthcare World and also of PW Wellbeing World, to please join us on stage and help us present the last set of awards. आगे बढ़ते हुए, the next person to join the power list of PW Legal World's 40 under 40 lawyers and legal influencers. Urfi Rumi, partner, litigation and enforcement, Sujata Chaudhary, IP attorneys. We have with us Just Karan Singh, senior associate. Sujata Chaudhary, IP attorneys, to receive the award. Urfi and Just Karan as well. Congratulations. आगे बढ़ते हुए, the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Aditi Sehgal, partner, JSA Advocates and Solicitors. Yes, Aditi is coming on to receive. Aditi and as well as Niyati. Congratulations. आगे बढ़ते हुए, the next person to join the power list of PW Legal World's 40 under 40 lawyers and legal influencers. Abhisar Beragi, partner, Khetan and So. Robbie, sir. Congratulations. The next person joining the power list of PW Legal World's 40 under 40 lawyers and legal influencers. Akshay, Sachdev, partner, Shardul Amarchand, Mangaldas. Congratulations. The consul's in a party mood for sure. Chalo, aage बढ़ते हुए the next person to join the power list of BW Legal World's 40 under 40 lawyers and legal influencers. Arishit Pratap Singh, Lead Counsel, Adani Energy Solutions. Congratulations. And the next and the last person joining the power list of PW Legal World's 40 under 40 lawyers and legal influencers. B. Shravant Shankar, Managing Partner, B. Shankar Advocates, LLP. He's waiting for 40 of you to receive this. Give him the applause he deserves. Congratulations. And now, for all the winners, if you wish to take back your trophies in boxes, please collect them from this side of the stage. Team members are here. May I now request all the winners to please join us on the stage with their trophies for a group picture. Also, all the presenters, jury members, if you have any in the hall, please. Aye. Do not forget to give your winner bites as well. After that, do join us for dinner as well. Anything else? No. Aye, all the winners, please. With your trophies. Can the business world team please make sure अगर कोई winner बाहर है तो उनको बुला लीजिए. All the winners, come. If someone wants to sit in the front on the steps, you can also do that. Please feel free. अगर आप बैठना भी चाहते हैं तो. Any more winners? You want to sit in the front? You can. Malik ji, एक और chair लाएंगे please. एक और chair. Pranav ji. Anyone wants to sit in the front? You can. If there's a chair coming, no, of course there's a chair coming. There's one coming. There's one coming. Tab tak we'll set the frame while the chair is coming. Ma'am, you'll have to come a little front. Ji. Ma'am, you will have to, yes. Also right behind you. So, go be. You want to sit there? You can sit there. You can sit that side. You can sit here. No, yeah, you've got more photographers than you on winners on the stage. We'll wait for him. Yeah, of course. मैं तो रोज का है. अच्छा पहले अपने phones में देख लीजिए आप. You've got 10 seconds for that, wherever your phones are. And then we'll do the main frame as well. Nidhi, can you? Yeah, weekend now. It feels like 30 under 30 winners taking a picture of the 40 under 40 winners. Okay, 10, 9, 8, 7, 6, 5, 4, 3, 2. Happy New Year, guys. Okay, chalo. Now, where's the center frame? Where's our photographer? Acha, haan. Boss, you'll have to come to our side. You have to sort of vacate the frame. Okay, in the frame upar. Dost. Supriya, can all of you? The business world team, can you guys go? Go, Supriya, go. That's it. And are you here? Prashant? Go, you also go, no? Business world, no? You're from business world, no? Go, quick. Done? Nahi, ek. One. Final, chalo, final one. Smile. And we are done. Thank you. Congratulations to all of you. Do enjoy the dinner. Merry Christmas, Happy New Year as well.